I just wanted to flag that we are about to start direct cases for Northern is first, but they have a shared witness. The witness is also for, to my understanding, Denver, Aurora, CSU, and Homestake, but I will let them correct me if I am incorrect on that assertion. I wanted to also flag, my understanding is that several of you may already have legal questions that may require executive session. If we are to hold an executive session, we will hold it before rebuttal. So at the conclusion of all the parties' direct cases, in case other legal questions come up. What would be best too is for you to write them down, and then I can announce on the record the reasons for executive session, and I can determine also if they're, in fact, legal questions or policy or fact questions that we can try to address without going into executive session. So please feel free to write them down or send them to me via email. Thank you so much. That you are using the shared witness first, or will they be going with Denver Water?
Okay, thank you. So we do have one shared witness. She will be going later in the presentation during Denver's
Understood.
part
Okay.
of the presentation. I, like you said, it's a shared witness. So in terms of time, I think the plan is to.
Distribute that time amongst all those parties.
Correct.
Yes.
Correct.
So Madam Timekeeper, this will just be Northern.
Just for Northern. The first two witnesses will just be for Northern Water's allocation. Yes.
Thank you for that clarification.
Also, just a reminder for everybody that comes up and speaks, please announce your name for the record, and so everybody online also knows who you are. Thank you.
Thank you. And good morning, directors. My name is Davis Wirt. I'm a shareholder at Trout Rayleigh. We serve as general counsel to Northern Colorado Water Conservancy District and its municipal subdistrict. We appreciate the opportunity today to participate in this hearing and contribute to the board's deliberation on this proposal. As is clear from the testimony you heard in May and the testimony you're hearing this week, as well as the simple fact that the parties to this hearing represent millions of constituents on both sides of the divide, the exercise of the Shoshone water rights impacts almost every Coloradan. You don't need me to tell you that this acquisition is a weighty responsibility and requires careful consideration to ensure it is done right. At the same time, I think it's an opportunity for the board to exercise the in-stream flow authority bestowed upon it by the General Assembly in a way that encourages collaboration among the various interests rather than discord and power struggle at a critical time in the Colorado River Basin. As you will hear from others coming up, we strongly urge the CWCB to not agree to acquisition terms that cede authority, essentially a veto power, to the River District for the use of the Shoshone water rights for in-stream flow. In Northern's view, if the River District's goal is to protect West Slope water, we think that is better accomplished through the CWCB's statewide leadership. Subject, of course, as you'll hear later, to the terms of a change decree. The CWCB would not lightly cede any of its other statutory powers, and we and the other Front Range parties you will hear from do not believe it can or should do so with respect to its exclusive authority to use the Shoshone water rights for in-stream flow use. Northern Water and the other Front Range parties also have other areas of disagreement with the River District's proposal, as you will hear and as you've seen in the pre-hearing submittals. In particular, the River District submittal to the CWCB included a preliminary historical use assessment that drastically overstates the right's historical use. So Northern Water, Denver Water, Aurora Water, Colorado Springs Utilities, and Homestake Partners have jointly provided the board with comments critical of that analysis as well as an alternative. We are not providing this information to have the CWCB make a final determination of historical use. I think everyone agrees that's a water court matter and that can be resolved in water court. But the magnitude of difference between these analyses, which is on the order of hundreds of thousands of acre feet per year, highlights the importance of this acquisition and the need for the CWCB to get it right. This historical use issue also compounds the current concern we have with the proposed delegation of veto authority to the River District. If anything, it shows the River District's clear intent, if given the chance, to exercise the Shoshone rights in a manner that disadvantages Trans Mountain diverters. Another complicating factor in this acquisition is the fact that use of the Shoshone water rights is encumbered by various agreements, as you heard yesterday. And these together define the present administrative regime. These agreements, which others will dive into in greater detail later, display a commitment to flexibility in how parties can address the difficult effects of drought and prolonged outages at the Shoshone plant. We believe these agreements form a valuable foundation from which to build a durable and collaborative approach to ISF use of these rights. As we have said before, and I will say again here, we support this acquisition if it's done right. You heard many yesterday speak about the negative impacts if there is no Shoshone water right on the river. I want to be clear that nobody is proposing that. What we're talking about here is a way to preserve the status quo and bring it into the future. Given all of this complexity and the essential need for the CWCB to use the Shoshone rights for ISF purposes, free from the River District's overriding veto, Northern Water and the Front Range parties that will follow me, on this slide, had 2 requests and as of now have 1 request. Our first request on this slide was to delay decision, and of course that happened with a 2-month extension. We thank the River District for that extension and look forward to working with them and the CWCB staff in those 2 months. We also think that there are frameworks that have already been discussed that will be a good foundation for those discussions moving forward and that can do better for all parties as well as the environment. But second, if and when the CWCB accepts the acquisition, the ISF agreement must be revised to remove the River District's veto authority over the CWCB's use, expressly state that the CWCB does not endorse the River District's historical use analysis presented here, and subject future in-stream flow use to the terms of existing agreements to which the rights are subject, among other needed changes. And again, on those matters and the ISF agreement, we look forward to the next 2 months and the discussions on those matters. On the issue of delegating an overriding veto to the River District, I want to dive briefly into the roots of the ISF program. Before enactment of the ISF statute in 1973, parties had occasionally sought to claim water rights for uses that resembled in-stream flow rights, but the Colorado Supreme Court held that such a right could not be recognized under Colorado law, which requires a diversion from the stream. The case in which the court made that holding was in fact an attempt by the River District to claim water for natural stream flows and fish preservation. But in the 1960s and early 70s, concerns about dry streams and environmental health grew, just as federal pressures also pushed for bypass requirements on permitted projects. These considerations created a desire for some in-stream flow mechanism. But at the same time, there was concern that simply removing the diversion requirement and allowing any party to appropriate ISF rights could prevent further development of the water to which Colorado is entitled. In the words of former Director Felix Sparks, the result was an unholy alliance between the environmental groups and so-called water buffaloes that put forth an ISF program managed by the CWCB, not some other agency. And that choice was deliberate. The CWCB could balance emerging environmental values with protection and development of the state's water resources, its original statutory charge. Giving the CWCB exclusive authority to use water for in-stream flow purposes ensured that the use could be accomplished in a way that she achieved optimum utilization and balanced the state's various interests. The board's authority on in-stream flows remains exclusive today. Of course, in addition to the appropriation of new junior in-stream flow water rights, the CWCB also has the authority, which is exclusive, to acquire interests in senior water rights on the open market to use them for in-stream flow purposes as well. The CWCB's power in this respect allows it to determine what terms and conditions it will accept in a contract or agreement for such acquisition. It has clear authority to negotiate the terms of the agreement to best align with its interests, comply with the scope of its legal powers, and serve the interests of all Coloradans. Here, the River District's proposed in-stream flow acquisition agreement unabashedly asks this board to give up its sole power to use water for in-stream flow purposes. Under the River District's proposed agreement, paragraph 7, the CWCB would be duty-bound to exercise the Shoshone rights for in-stream flow to the maximum extent possible, regardless of any countervailing reasons for reducing their exercise. Paragraph 4 similarly states the party's proposed intent that the water attributable to the rights will remain in the stream up to the maximum decreed rates. And along those lines, paragraph 7, 8, 9, 14, and 15 would require the CWCB to request administration to maximize its use at all times when the natural flow is less than 1408 CFS. If the CWCB concludes that there are compelling reasons and it's appropriate to use the rights for in-stream flow in a different way and to reduce the call placed, it cannot do so. Paragraph 7C would prohibit such an adjustment unless the River District gives its consent. In short, the River District would be dictating in-stream flow use of the Shoshone water rights. Even if, as the River District promised, a collaborative process were appended to the agreement, the fact remains that the River District would still have dispositive authority over the rights used for in-stream flow. Yes, the proposed ISF agreement claims that the River District is dedicating these rights to the CWCB for it to exercise its exclusive right to use them for in-stream flow. Recital A references that exclusive authority. Recital I states the River District's purported desire to dedicate it to the CWCB for it to use it exclusively. And paragraph 2 claims that is what the River District is doing, but it is not. Diametrically opposed to that intent and attempt is paragraph 7C, which vests in the River District a superior say in whether and how the rights will be used for in-stream flow. This arrangement is clearly counter to the ISF program scheme and the General Assembly's unambiguous vesting in the CWCB of exclusive authority on behalf of all of the people of the state of Colorado to use water for in-stream flow. Nothing in the statute authorizes the CWCB to delegate that authority to another party. The General Assembly specifically declined to do so itself. Mr. Veal asserted yesterday that the River District can retain authority over the call and use of the rights and decide not to contract that right away. But the River District cannot hold the right to use water for in-stream flow purposes. Only the CWCB can. We wouldn't be here doing this acquisition if that were not the case. So this is not the River District contracting away a right it has. It would be the CWCB that would be doing so in violation of statute. True, the CWCB has enacted collaborative arrangements with donors to the acquisition program in the past, but as you will hear later from Aurora Water's attorney, Josh Mann, none of those other agreements grant a superior veto authority to the other party. Under those examples, the CWCB retains final say in exercise of the rights for ISF use. So while those other examples may comport with statute, the structure that the River District proposes here does not. It goes without saying, too, that none of those other examples involve the level of impact that use of the Shoshone water rights on the Colorado main stem does. I do briefly want to respond to Ms. Mealy's example yesterday about Glade Reservoir on this topic, because as you know, Glade Reservoir is a planned reservoir by Northern Water. To me, the Glade example is off base for several reasons. The main one being that the operations for Glade Reservoir occur under a separate statute called the Protected Mitigation Release Statute, which you learned about yesterday with Fort Collins's more recent proposal to use that statute. It is written in a different way from the acquisition statute and applies in a different way. The other difference I want to note is that the Glade Reservoir operations would be releases from reservoirs. It's not a direct diversion that can command the river in the way that the Shoshone water rights can. There are other reasons why the CWCB should not entertain a dominant role for the River District in use of these rights for in-stream flow. Most importantly, as we emphasized in our pre-hearing submittals, handing the ISF keys, so to speak, over to the River District sends the undisputedly wrong message that use of the Shoshone rights only affects the River District's West Slope constituents. More than any other ISF acquisition, use of these rights will have wide-ranging statewide effects that would greatly benefit from the CWCB's statewide perspective and its ability to bring differing views together. In sharp contrast, subjecting use to the discretion of the River District would increase the ability of the Shoshone water rights to sow discord between West Slope and East Slope. The dispute about historical use, which I will touch on in a little bit, emphasizes the problems with granting the River District that authority. If the River District's position as to historical use seeks to maximize benefits to the West Slope to the direct detriment of the Front Range users, then presumably it would do the same in wielding its veto authority. In short, the CWCB cannot and should not grant the River District veto authority over the CWCB's decision-making in exercising the Shoshone water rights for in-stream flow use. At a minimum, this would require removal of paragraph 7C and other revisions in the agreement. And there's language in the Denver Water Exhibit Exhibit 1 that addresses this need to revise the agreement on this and other issues. It's important to understand, though, that the CWCB's decision on this discretion issue and delegating authority is not necessarily binary. And the conversation yesterday, I think, seemed to recognize that fact. As noted, the CWCB has in the past constructed acquisition agreements that give other parties, primarily the donating party, an opportunity to contribute to the CWCB's process in decision-making without supplanting it. As Northern Water suggested in its rebuttal pre-hearing statement, a sensible approach here could be an advisory group, including a diversity of stakeholder interests, to provide input to the CWCB on proposals for changes in exercise of the rights. That group could then assist the CWCB to assess the possible effects of a change or reduction and ironing out the details on how that could be implemented in a way that avoids, minimizes, or mitigates unwanted effects. If that group has disagreements on a given proposal, which it very well might, then the CWCB can be the one to take those differing views and decide how they affect its sole discretion in exercising the rights for in-stream flow, subject, of course, to the parameters that will be put in place between now and entry of a change decree by the Water Court. This is just one possible way for the CWCB to create an inclusive process, all while retaining its exclusive authority to use water and place a call for in-stream flow. Other arrangements short of granting final decision-making authority to the River District could be used, but the goal, we think, should be formulating an approach that fosters collaboration to ensure exercise of the rights does not adversely affect water users in unexpected ways compared to the current use for hydroelectric power generation. Such an approach would align with the culture of collaboration that the Colorado water community has exemplified over the last 25 years, as demonstrated by the state's water plan, establishment of the basin roundtables, and many other examples. As I noted, the magnitude of this acquisition cannot easily be overstated. You don't need me to tell you the stakes are high. The board should be careful in determining the terms and conditions it will require to accept the acquisition. This additional 2 months between now and November will be valuable for the parties to discuss how the board could do that. And we think the board should provide its input, to the extent as it has not already, on what it might like to see coming out of those negotiations. But if and when the CWCB decides to accept the present proposal, it must do so on terms different from the agreement proposed by the River District. Specifically, the agreement should expressly state that the CWCB is not, by accepting the acquisition, endorsing the historical use analysis presented by the River District, or frankly, by the Front Range parties in these proceedings. And in addition, if staff will participate in this issue, the historical use issue in Water Court, its objectivity should be assured one way or another. And I think we can discuss ways to make that happen either today or in the next 2 months. Second, the agreement must subject future use to the existing agreements to which the rights are subject. And finally, the agreement cannot and should not grant the River District veto authority over the CWCB's decision-making process. To give you a sense of the presentations you're about to hear from others today, I want to spend a couple more moments to provide a roadmap for Northern Water, Denver Water, Aurora Water, Colorado Springs Utilities, and Homestake Partners. So first, you'll hear from Kyle Whitaker, Northern Water's Water Rights Department Manager, about the Shoshone Water Rights context, particularly as it relates to Northern Water's interest in the Colorado Big Thompson, or CBT project, the municipal subdistrict's Windy Gap project, and the Upper Colorado River Endangered Fish Recovery Program. Mr. Whitaker will also describe how the Shoshone rights are presently encumbered by or subject to various agreements, most of which address one of two scenarios. Either they seek to relax exercise of the rights in times of drought, or they seek to address the effects of the Shoshone rights not being exercised during a plant outage through voluntary agreements to operate as if a call is in place, what we call the Shoshone Outage Protocol, or SHOP. The CWCB should be aware of this context and think about ways it affects its decision or could be used as a basis for shaping future use of the rights, ideally through a negotiated resolution. Mr. Whitaker will conclude with Northern Water's view that collaboration and continued negotiations is the best course of action to add certainty to what the CWCB is getting out of this acquisition. Next, Denver Water will provide testimony through Jeff Bandy, Denver Water's manager of water rights, supply, and analytics, about its system and the status quo that the board should be seeking to replicate through its acquisition. Heather Thompson, a consulting engineer with Ecological Resource Consultants, Inc., will then provide joint testimony, as I mentioned, on behalf of all of the Front Range parties to rebut the historical use analysis prepared by BBA Water Consultants and included in the River District's submission to the board. As I mentioned earlier, this testimony is not being given because we think the board can or should make a determination about quantification or find a specific number on that issue. That, again, is for Water Court. Instead, given that the River District included this assessment in its offer packet, we've presented this evidence on this issue to ensure the board has a full record of the dispute surrounding it. As I also mentioned, this dispute over the right's historical use compounds the concerns we have about the proposal to grant overriding authority to the River District over use of the rights for in-stream flow. By providing our critiques of this analysis, we hope that the CWCB will better understand the magnitude of difference on the historical use issue that may affect the amount of water available for in-stream flow use. There are risks on both sides of this issue, and we believe could be avoided by a compromise solution that more thoughtfully leverages the rights to benefit the entire state. Yesterday, Mr. Fleming suggested trial on historical use is how we do things in Colorado. And while that's true, I think the reality is more often than not, cases settle. We can find a settlement that resolves this issue ideally without even litigating the issue of historical use. And I think we're all committed to doing that if we can. In the end, the Front Range parties do not want any acceptance to be taken of this acquisition to be taken as an implicit endorsement of the River District's historical use analysis presented, as I mentioned earlier. Counsel for Denver Water, Dan Arnold, will then provide brief testimony wrapping up Denver Water's presentation. After that, Aurora Water will provide testimony through Alex Davis, Assistant General Manager of Water Supply and Demand, about Aurora's system and water supply portfolio, its robust conservation efforts, and the potential impacts of the acquisition on its supplies. After Ms. Davis, Aurora Water's attorney, Josh Mann, will summarize Aurora Water's 2018 intergovernmental agreement that includes provisions about the Shoshone water rights. Mr. Mann also will provide additional argument, as I mentioned, in opposition to the River District's request for veto authority by discussing the example ISF agreements that the River District cited in the pre-hearing submittals and explaining why they do not at all resemble the acquisition agreement here. Colorado Springs Utilities will follow with testimony from Tyler Benton, Senior Water Resource Engineer for the city, about its water system, water conservation practices, and the potential impact of the acquisition on its supply. After Mr. Benton, Colorado Springs Utilities attorney, Michael Gustafson, will describe the city's 2024 Memorandum of Agreement that includes provisions about Shoshone. Mr. Gustafson also will touch on the historical use and delegation of authority issues referenced earlier. Finally, Homestake Partners will provide an overview of its system and the potential impacts of the acquisition on that system on Aurora and Colorado Springs through testimony from Rick Keenitz, Aurora Water Water Resources Manager, Heather Thompson, and Tyler Benton. The parties then plan to reserve time for rebuttal as needed. Before I hand it over to Mr. Whitaker, I want to conclude by emphasizing that how the CWCB fashions this acquisition will have wide-ranging effects, not just on water users in Colorado, but also on the future of the agency's program and potentially its mission to conserve, protect, develop, and manage water for the benefit of Colorado. The CWCB should closely guard its exclusive statutory powers, including its exclusive authority to use water for in-stream flow. It should not sacrifice those principles and its unique role in the realm of Colorado water for short-term gain or political expediency. We believe that accepting the acquisition as proposed and ceding veto authority to the River District not only oversteps the CWCB's legal authority, but also would be a disservice to the agency and to the state. Thank you, and I'll hand it over to Mr. Whitaker and would be happy to answer questions at the appropriate time.
Good morning, Kyle Whitaker, Northern Water and the Municipal Subdistrict. I'm here today on behalf of those entities. I want to start by thanking you all for your thoughtfulness and the amount of time. This has been a big lift. The amount of paper, the amount of pre-submittal hearings, and all of you are so busy. So thank you for taking the time to understand this extremely important issue and to contemplate what's right for Colorado. It cannot be overstated how important this issue is to all of us, not just all of us in this room, but to all of us within the state of Colorado. While myself and many others have spent countless hours looking at, analyzing, and digesting significant amounts of data and other technical information, I am confident that all of you understand and appreciate the complexities and the impactfulness of the Shoshone water rights. The technical details will be worked out, and therefore I'll spare you the weedy details and the opportunity to once again make fun of us engineering types. The most important issue to Northern Water, as you heard from Mr. Wirt, is for the CWCB to retain the full discretion of the exercise of the Shoshone water rights for in-stream flow purposes. As you have heard, the CWCB exclusive authority and the historic use analysis are intertwined. With that said, there are very few things that I am certain about, but I can assure you that if any level of discretion on the exercise of the rights is not retained by the CWCB, it will force all the entities involved to drive towards a significantly lower historic use quantification. We have to protect our systems under all future potentialities. This will have a chilling effect on collaboration and cooperation amongst all involved and is likely to result in an outcome that is not only less desirable, but also less beneficial to the Colorado River. We have a proven track record of coming together to solve challenges in a mutually beneficial way. The preferred approach is for the CWCB to retain full discretion, as well as regularly exercising the water rights for in-stream flow use whenever the power plant is not operational, and thereby maintaining the status quo while providing flexibility for an uncertain future. With that said, I would like to spend a few minutes explaining the history of operations of the Colorado River main stem and the important and complex role of the CBT project, the Windy Gap project, Northern Water, and the Bureau of Reclamation. Very briefly, there have been, in my opinion, 3 errors of water administration on the Colorado main stem. One occurred prior to the CBT project, and what you have all seen is what's known as Senate Document 80. The time before Senate Document 80, before the late 1930s, early 1940s, the Shoshone Power Plant, as you heard yesterday, is a run-of-the-river plant. There's little documentation of how the river was administered, how the Shoshone water rights were administered against other water rights upstream. But I don't think that's relevant anymore because that all changed in 1943 when Green Mountain Reservoir a critical component of the CBT project was completed and came online. From 1943 through the mid-1980s, it can be described as the administration on the Colorado River, the agreement that was struck between the west slope and the east slope to allow the CBT project to go forward was for Green Mountain Reservoir to benefit the west slope, to not impair any future development of west slope water rights by supplementing the flows. In essence, keeping the call off at Shoshone and down in the Grand Valley. And how this looked regularly, you've seen the numbers. The flow of the Colorado River is commonly below 1,000 CFS. That's reality. That's what the basin creates. And what Green Mountain Reservoir did, again, a component of the CBT project, propped those flows up. It was the original supplement to the Shoshone water rights and kept it at 1250, even though Mother Nature did not do so. And that's how the system operated. There is thousands, hundreds of thousands of acre feet of water that came out of Green Mountain Reservoir, was made power on at Shoshone that was well above the natural flow of what the Colorado River produced. In 1984, the parties primarily on the west slope with the Bureau of Reclamation agreed to operate the west slope portion of Green Mountain Reservoir in a different manner. The 84 operating policy changed. We'll get more into that here in just a minute. But it set forth a new direction. No longer was Green Mountain Reservoir used to prop up flows. It acted more as a replacement supply and a water storage source for many on the west slope. That was modified or maybe codified and understood in a whole different way in the check case settlement that you heard about yesterday. In 1997, parties came together to settle that case and to create what's known as the operating criteria for Green Mountain Reservoir. It can be described that the time period between 1984 and 1997 was not only a time of transition, but a time of learning. Division of Water Resource Administration, water users' expectations, all transitioned during those years from 84 to 97. After 1997 became an era of intense cooperation, figuring out ways to make the Colorado River better, whether it was through recovery program operations, the agreement between Denver and Excel regarding a relaxation agreement, the Colorado River Cooperative Agreement, and the Shoshone Outage Protocols. Every one of those intended to help the river, to maintain the status quo, whether the power plant was operating or not. To touch a second on the Shoshone Outage Protocol agreements, you can see at this point, every major water user in the basin is a signatory to those. And even though hundreds, if not thousands of West Slope water users are not signatory to those agreements, they are covered by those agreements, again, because of Green Mountain Reservoir and how Green Mountain Reservoir acts, in essence, as an augmentation supply for hundreds, if not thousands, of water users on the West Slope. The SHOP agreements honor a virtual call. Let me be clear, it is not a call. It is an agreement when the call cannot be placed to act as if the 1250 call was in place. There is not a change case. There is not a haircut, as you heard so much about, being applied. It is honored at 1250 CFS. Even though historic use is likely significantly below 1,000 CFS. Lastly, Northern Water and Grand County recently entered into what we have referred to as the Bunty framework. I won't go into details, but it's again, an opportunity to come together, collaborate and cooperate on a way to add storage water to the system to make conditions on the Colorado River better. What you see throughout these eras of administration is a lot of shepherded water. There's a lot of reservoir water in the Colorado River. It has been there, whether it's under Senate Document 80 operations or things that have come since 1943. The reality is that recreation, whether it's boating, fishing on the Colorado River, has significantly benefited from Green Mountain Reservoir in ways that are tremendous. Ending here, we are willing and ready to figure out a mutually beneficial approach again. But we need resolution of the CWCB authority issue. This is a quick snapshot of the plumbing of the Colorado River Basin above Shoshone, as well as throughout the rest of the basin. I won't spend much time on this, but I just wanted to point out between Denver Water's system, both their Moffett collection system, their Dillon Reservoir Roberts Tunnel system on the blue, Colorado Springs Utilities, Continental Hoosier system on the upper part of the blue, the Homestake Partners system in the Eagle Basin, the CBT and Windy Gap systems on the upper Colorado. And then what's not here is the thousands of water rights of West Slope users that benefit from the CBT project through Green Mountain Reservoir. You have heard a lot of statements yesterday about Shoshone going away, a number of which were fairly dramatic, some somewhat draconian. That is just not the case. Flows through all the agreements you've heard about will remain for decades in the future as they have in the past. There has been a lot of information submitted about Green Mountain Reservoir. I will not go into it, but what Green Mountain Reservoir does for the West Slope and for the East Slope cannot be understated. What our biggest concern is you see here, the CBT replacement pool, it's the bottom of the reservoir. It's the first 52,000 acre feet to fill each year. It is extremely reliable. As you get into the 100,000 acre foot remainder, there are years, the modeling reality of where that part of the reservoir may not fill. And if you exercise, if you pull, if you draw down Green Mountain Reservoir to a greater extent, the risk is all borne by the parts of the reservoir that fill last. We are asking that that is not impacted going forward. Lastly, I just wanted to touch on the reality of flow at the Shoshone Reach. What you see here in blue is the natural flow. This was a period, as you can see, at the end of August, right before our pre-hearing submittals were due. The blue line, the blue bars there, the average flow of the Colorado River, the natural flow, just over 800 CFS. Very, very common. The gauged flow, how much water was there, averaged just over 1,350 CFS. The part you see there, the green, the brown, the orange, and the red, is all water either coming out of Green Mountain Reservoir for either the benefit of West Slope, what are known as historic use beneficiaries, historic user pool beneficiaries, or as you see the big bar in the orange, that is direct delivery to the Grand Valley. They do not have a right, title, or interest in Green Mountain Reservoir, but the benefits are huge. What you see there is roughly 300 to 500 CFS headed to the Grand Valley to finish crops coming out of Green Mountain Reservoir at no cost to them now or in the past. These orange bars, because of, as all of you know, infrastructure challenges are real. The Grand Valley is facing some challenges this year. If their challenges were not there this year, these orange bars would be roughly 300 CFS higher. The flow of the river would have far exceeded power generation at Shoshone, even though the natural flow was approximately 800 CFS. In closing, we are in full favor of exercise of the Shoshone water rights, but we ask that we maintain the flexibility for an uncertain future. When you systemize things, you lose the ability to optimize. CWCB has a history of conserving, developing, and managing the public water resources for the state of Colorado in a fair, balanced, and thoughtful manner in the best interest of all. I thank you for the time, and I look forward to questions at the appropriate time.
Members of the board, I believe that concludes Northern's presentation, so you may begin asking questions of those two witnesses now.
Director McLeod? Oh, Director Felt?
Kyle, you can answer this question if you want, but I was going to ask it of Davis. There was a slide that you showed in your opening remarks. I took a photo of it so I could remember. Yeah,
This
there
one?
you go. Yeah, you didn't really, I didn't feel like you fully explained that one, but I appreciate this slide. It has some structure to it. It may not be optimal for all in the room, but at least it is, something you can point to. But one thing that did strike me about it a little bit is, this thing we call CWCB, Colorado Water Conservation Board, we have a bit of an identity problem sometimes because the same name applies to an agency and to the people sitting at this table. And they're intimately connected, but they're really two very different things. And so I'm wondering if you have any commentary on what you mean by CWCB in this slide.
And thank you for the question, Director Felt. As I said too, this is just one example of a framework that might work from Northern Water's perspective. But to your question, I think by and large, the day-to-day administration and use of this right, that's not something that, it's not like the directors here are calling the state engineer to place that call for the CWC, for the agency. I think most of this would be more in the vein of day-to-day operations from CWCB staff, probably the entire staff, the director and whoever the director wants to lean on in administering this kind of framework. So in my mind, it would most likely be CWCB staff, but I could envision a place where updates are given to the board maybe yearly or as needed to get guidance if staff determines that's helpful to them.
Okay, and I guess what led to my question was just that line about a diverse advisory group. I felt like, well, people at this table are a diverse advisory group. So I wasn't sure. I agree with you on day-to-day sort of nuts and bolts stuff, but I was wondering about sort of that bigger picture determination of what should be considered, that kind of thing. So,
And Director Feld, to that question, I think in this example, what we envisioned was that group is water users that have a stake in what these decisions mean to their water supplies. So that group may include East Slope users, West Slope users, US Bureau of Reclamation. That's an incomplete list. I'm sure there's a different way to slice that, but under this idea, that those would be the stakeholders that would come together to try and work on ways to, if there is a change in use, how do we minimize any effects that parties don't like about that? And then the CWCB can sort of hear those differing views and be the one to decide how to resolve them or bring all the parties together on a proposal.
Director McCloud?
Thank you. Davis, you and Kyle both repeatedly talked about exclusive authority and how we shouldn't cede that to the River District. We raised this with the staff yesterday, and they take the position, I believe, if I understood them correctly, that the exclusive authority applies to appropriation, but that acquisition has different standards, and that it's entirely appropriate for a donor to want to insist that we exercise the water right. Now, arguments in some of the pre-hearing and rebuttal statements are saying, well, you're agreeing to do 1408, 365, 24/7. That's not what the agreement says. It says it's subject to the terms and conditions and limitations of the water court decree. So help me with the distinction between appropriation and acquisition and what your comments would be on that theory. And then the limitations that will be in the decree will certainly, well, I guess, limit the exercise of the water right. And you'll all be there putting these conditions in the decree. And the standard is no injury. That applies to you, not injure your water rights. So that's two questions at once. I'm sorry. Start with the exclusive authority.
Yeah, sure, Director McLeod. I'll start with that, and then if I forget your second one, I'll ask you again. On the authority, I think we have a clear legal disagreement with CWC. 3792-1023 is a very long part of the statute. I think it's about a page long and very small text. In my view, and this is why I gave the history of going back to 1973, what the exclusive authority is that was granted by the General Assembly to the CWCB is the right to use water for in-stream flow. No other party can do that. And to me, that carries through for both appropriation and acquisition. If acquisition could be done in a way where other parties could have that power, then it wouldn't make much sense for the CWCB to really be involved. I don't see that as sort of a rubber stamp to let other parties go off and do their own in-stream flow programs. To me, I think that's something that the CWCB should guard closely. It's the only party in Colorado that can use water for in-stream flow. And in my mind, the General Assembly has not allowed the agency to give that authority to another person by contract, another party. To your second question, which I think I remembered, we're fully aware, there will be parameters imposed in the water court process, terms and conditions to sort of define the scope of what can and can't be done in terms of exercising the water rights. But I do think there will be room within those parameters for the CWCB to have discretion in how it exercises these water rights. I mean, part of the acquisition agreement, part of this board's role is to determine what is appropriate for use for in-stream flow. And maybe that's different on a given day with other statewide interests in mind. And so to me, there will be important protections for non-injury in a decree, but there's still room, I think, for the CWCB to have a role in deciding within those bounds, how are these rights going to be used moving forward, particularly in uncertain scenarios in the future. And, I think the scenarios where there might be a need for flexibility are probably pretty limited. And maybe there's ways to try and get at that. It's hard to predict the future, so I don't think we could come up with every scenario where that might come up, but there needs to be some flexibility there. Like Mr. Whitaker was saying, systemizing sort of hems you in a little bit, but we're trying to create at least a little bit of room for flexibility to address unforeseen needs.
Okay, but even if we have exclusive authority, the exercise of the water right is still going to be dictated by that decree, right?
Correct.
The river district doesn't get to direct the exercise of the water right. The decree will put the parameters for the exercise,
Correct.
and you don't feel that's adequate to protect your interests.
I don't think, you know, in terms of preventing injury, that is the water court's role. And I think, yes, from that perspective, but you know, exercise of water rights is a discretionary act. There's no requirement that you call, you know, for instance, if you decide not to fill a reservoir, they paper fill you. That's a choice you could make. In this same vein, if there's room for CWCB to operate in slightly different ways within the bounds of the decree, that discretion is important to us in those unforeseen scenarios that may need some flexibility rather than maximized use at all times. And again, I want to emphasize, you know, we don't see that as, more often than not, I think the water rights will be exercised up to their decreed amounts. But there could be scenarios where that might not be ideal.
So the discretion we're surrendering is the agreement to exercise the water right to the fullest extent allowed by the decree. That's your concern?
Right. And how those water rights are exercised under the terms of the decree.
Thank you.
Director Gibbs?
Do you think, I'm just curious about the advisory work group and how quickly the changing river conditions could be, and do you think they would have enough time to act in a meaningful way? And I don't know, maybe that's really a question for Jason too, like what the time frame, how quickly you need to act to place a call. I just don't know.
And Director Gibbs, I think that's a good question that probably isn't reflected in this short list, but I do think that's one thing that would be a deviled detail to work out. I think from Northern Water's perspective, some of the scenarios that we envision, and maybe I'll hand it over to Mr. Whitaker if he wants to add on this. You can see them coming from at least a little bit of time away, and so I think there would be leeway or time to get the ducks in a row and figure out if there's a change that needs to be made. I think similarly with drought conditions, by and large, you can foresee projections of what stream flows will look like. You know, that doesn't address, you know, emergency infrastructure needs. And so there probably would be some need for more expedited process there. You know, I would hope that there would be a way to get people together quickly, at least virtually, to make that happen. But again, maybe details to work out in the next 2 months or moving forward.
Yeah, thank you, Director Gibbs. I would just add to that, I guess we envision this being a rarity, that 99+% of the time, these water rights would be exercised per their decree. When the power plant's not operating. I mean, that's really what we're talking about. We're still going to have significant portions of time where the power plant's operating and the in-stream flow use is not needed. But in times where it is needed, where there is an unforeseen circumstance, where there is a situation where it is felt it's a statewide importance to consider modifying how those water rights are exercised, we will see them coming. We will know that, and it's not going to be a day in, day out. It's not going to be changing. It's going to be, we're in a tough stretch. We're in an odd stretch for whatever reason. There's things coming upon us that we haven't seen before. We didn't envision. And that's when we view this as being added flexibility. And I want to restate, I think This added flexibility will allow all parties to be much more flexible in that 99+% of the time, meaning there will be a lot more water in the river day in, day out than if we're driven to a hard historic use quantification that protects our systems against injury at all times. And that's what we are asking that you all consider, is giving us a path to do good most of the time. But if there are some things that we did not consider or things are really rough, that there's some flexibility.
Director Vasquez?
Yes, I'm sure what I'm about to say is no surprise to anybody in the room. This hearing is floating on a very long history of distrust between the Front Range and the West Slope. And I'm concerned about your proposal about having to put together a diverse group of water users to come to a quick decision about a reduction in that call. And I'd like you to explain to me how you think that would work in a very timely manner, because some of the conditions we can forecast with climate change may not be so far off. And your comment about it's, we'll see it coming with a long ramp, I question.
Yeah. Thank you for the question, Director Vasquez. I think you are, there is a history here, undoubtedly. But I think in this in particular, the agreements that are already in place took years to negotiate.
I understand that. Thank you.
And they provide a lot of these same exceptions. To date, they have rarely been exercised. And when they have, we've been able to see those coming. Whether it's drought, some of these are not necessarily drought considerations. We're thinking of an uncertain future. What is Colorado going to want to do? What may we want to do that exercise of these water rights may prevent? And those things we're going to see. I'm talking statewide policy initiatives, not day in, day out administration. The day in, day out of this, I think, will be very routine. It is in situations because we all know, we know how the river operates. We know what the current status quo is. Now, does hydrology change? Yes, it always has. And as we see that hydrology changing, these are not triggers that are going to be hit a day. These are triggers, envision, if you will, reservoir levels being at a certain level. We know going into runoff where they might end. And then ultimately, if they do, we're going to have months leading up to this and having collaborative input. This is not, please don't view this as a proposal just for our system or the Front Range system. This is also critically important to West Slope water users. As I mentioned with Green Mountain Reservoir, the ability for Green Mountain Reservoir to fill for the benefit of the West Slope water users, that is one of the things we want to be considered. If it is looking like it isn't going to fill, which it has, that's happened. We knew months before that was a possibility. This would also allow West Slope water users to have a flexibility to get as much water in storage to get us through tough years.
But this in-stream flow would be dated once it's approved by a water court, right? So it's a very junior right. Do I understand correctly?
My view of that is that it would be a change of water right of the existing Shoshone water rights, and it would maintain the priority
Is that correct?
of those rights.
I'm looking to Director Ullman.
Director Vasquez, he's correct. It would be
Thank
a
you.
change of water right maintains the priority date.
Thank you for the education. I appreciate it.
Director Combs?
Thank you guys for being here. Davis, I got a question and then I'll ask one to you, Kyle, if that's okay. When you were presenting on this, Davis, you said, and check your notes, don't let me put words in your mouth, but I thought you said that one of your conditions was you wanted us to insist on the quantification structure before we accepted this in-stream flow. Is that
Thank-
correct?
Thanks, Director Combs. I don't, I I don't think I made that comment. I think what I tried to say, at least, is that direction from the board, I think, will be helpful in the next 2 months, particularly on this issue of who has authority to decide how these water rights are exercised. I think that issue is going to be pivotal to how things look in 2 months in terms of what the ISF agreement will say. As Mr. Whitaker mentioned, that issue is intertwined with others, particularly the historical use issue. And to the extent that we can get thoughts from the board to guide those discussions, I think that would be helpful. In terms of the historical use, like I said, we don't see it as the agency's role, and you probably are glad that it's not for you to determine the exact number of the historical use of these water rights. I think what was discussed yesterday was a potential approach of staff being involved in that once we're in water court from an objective standpoint. And I think part of what we would want there is assurances that that will be an objective approach. That could be accomplished in various ways. I mean, one idea would be getting assistance from a third-party consultant to help on those HU issues. Another might be if the board decides you want check-ins with staff, that's within your prerogative, I think, as well. There's probably other ways, but trying to set up a structure so that there's assurance that that objectivity will carry through water court is one of our requests to hopefully try and work out in the next 2 months as well.
Okay, so I understand the magnitude of this situation, but the precedent of us weighing in on a methodology of quantification prior to water court is what gives me pause as far as a precedent. And so that's where my question is coming from. I totally agree with us being involved in the case and being that objective person or that objective entity as was discussed yesterday. But prior to that, I have pause on that, thinking that we would get involved at that level.
Right.
Of the situation. So that's all I was gonna say there. And if you want to respond, that's fine. And then I have got a question for Kyle, if you.
Sure. And just to clarify, our position is on that historical use issue. We would want just express recognition, ideally in the ISF agreement, saying that in accepting the acquisition of the Shoshone water rights for in-stream flow use, there is not implicit within that an endorsement of any particular historical use methodology or analysis. So saying essentially at this point, you are endorsing neither side and recognizing that's a water court matter to be hashed out later. I think that's our request on that issue.
Thank you for that clarification. And then if it's all right, Kyle, I'm looking at your both the Green Mountain Reservoir diagram and your colors of water. So help me here. If when even go prior to that, when you look at your timeline that you laid out, releases from Green Mountain since 1943 have been propping up the flows so that Shoshone could generate, correct?
That is the end result, but the intent generally was to avoid a call at Shoshone because that would allow the West Slope to continue to develop new water rights, new uses. And that was generally the description and the agreement that came out of Senate Document 80 is to keep the call off at Shoshone as well in the Grand Valley so that the West Slope could continue to develop post 1937. And by doing so, they would never be curtailed vis-a-vis either of those calls.
Okay, so in a stretch, I guess we're saying that because that water was available, it did fulfill that purpose of generating, like you're saying. And so is it your contention then that that excess water should be now removed from the quantification? Is that I mean, is that part of what you're asking us to make a decision on? Because wouldn't that, I have a hard time saying that if it's been going on since 1943 and that's what it was doing, that that's not part of the average historic use. And then for us to weigh in one way or another, especially regarding something like this, seems a little bit of a stretch for where we would say we're objective. So I think I understand what Mr. Davis was saying. You want us to stay objective, but then you present information that seems to have us make a decision on what we would agree is or isn't part of the average historic use.
Thank you, Director Coombs, for the question and the ability to clarify. We are not, this was not put in front of you to ask for you to consider how it impacts the historic use quantification. We do believe, and it will come out in water court if we get to that point and it's needed, that water released from Green Mountain is above natural flow. It is not within the control of the Shoshone water rights. They do not have a right, title, or interest in Green Mountain Reservoir. So this was here for illustrative to help you all understand that there's a lot going on in the Shoshone Reach. The flows are not going to go to zero. They never have. There are agreements in place that will avoid that. But this was just daily operations. What you see here, and this all changed in 1984, and I won't get into that. But this is all water being shepherded at Shoshone. And so, yeah, I guess just to end and to clarify, no, we're not asking you, nor are we asking you to weigh in on how staff should deal with this, either in the intervening 2 months or in water court.
Can I do my final? So then just as a final, it seems like what we're trying to do, everybody agrees in trying to maintain the historic flow regimes. And this is part of that. Regardless of how we want to label it or describe why, this becomes part of that. And so I hope you can see the quandary that says we want the flow regime as long as we get to interpret the flow regime.
Yeah.
That's
And-
troubling.
and yes, I think all of us want to maintain the status quo. I will end with this as saying, if the Shoshone call was not on this day, which it was, there would be zero difference in the flow at Shoshone, because the Grand Valley, they have their water rights. They put their call on as well. And all this water would be in the river at Shoshone headed to the Grand Valley. There would be no difference if the Shoshone call would have not been exercised on these days.
Thank you. Appreciate it.
Director Hawes.
Yes, thank you both for being here. My question is for Mr. Wirt, I think. So building on Director McLeod's question, obviously this issue of authority and who can do what is really at issue. And so looking at the statute, 3792-1023, it lays out the exclusive authority around appropriation for new rights and then acquisition of others giving us an interest in that right. And it very clearly says any contract or agreement executed between the board and any person shall be enforceable by either party. So I'm really struggling with this, how you all reconcile this language with what you're saying about who can do what here.
Thank you, Director Hazen. My response would be enforceability in terms of that statute is enforceability of the terms of the in-stream flow acquisition agreement, not enforcement of the water rights. In terms of enforcing the water rights, or if you will, using them for in-stream flow, that is exclusive to the CWCB. And in our view, the General Assembly did not say that's delegable, and so it is not.
So you're kind of saying it's because it's not explicitly stated that authority has not been given. It's kind of a negative there, but
Well, the statute says it is exclusive authority on the part of the CWCB to appropriate water rights for in-stream flow. I think that clearly says no other party may appropriate or
Appropriate.
hold a decreed water right for in-stream flow.
right?
So in terms of an acquisition, it is a right to use for in-stream flow that the CWCB holds. The River District does not. And in terms of an acquisition agreement, it would be a choice on the part of the CWCB to delegate some of that authority or all of it
Mhm.
to another party. And the General Assembly did not authorize the CWCB to do that.
So it comes down to the terms of the agreement, which it sounds like is going to be a focus of the next few months, hopefully finding some kind of protocol that can be laid out. And that's really, we have to hope you guys can get there.
Well, I do think there's lots to discuss in the next 2 months on how that will work. Our position, though, is that a provision that cannot find itself into the ISF acquisition agreement is a delegation of final say on the part of another party and how the water rights are used for in-stream flow purposes. There may be a framework to set something up to help inform the CWCB's decision, but it's still the agency's decision within the bounds of a change decree, of course.
Director Gibbs.
Thank you, Madam Chair. This is really nice follow-up to Director Haas's questions, but I was wondering what conditions around the discretion to call would you feel more comfortable under this co-management situation? I know you have stated you prefer this to be CWCB, but under co-management, what would those conditions look like that would make you feel comfortable?
Thank you, Director Gibbs. Sure. Well, first of all, I don't know if I would call it co-management, and maybe you've noticed the difference of terminology today and yesterday, but to us, if in a hypothetical future there is some legal delegation of decision-making in terms of the use of the rights to the River District, I think there may be criteria that could help give us some comfort on that, but ultimately the biggest protection we would go for and fight quite hard for is the lowest historical use quantification possible, because that's the surest way to prevent injury to our water rights.
Director Camlin.
Good morning, Davis.
Morning.
This is for you, and it's kind of bouncing around. It started with John, and then Taylor kind of hit on a little bit too. So yesterday, we were talking about the collaborative and who made these decisions and so forth, and I was told, pretty much by staff was, the administration of the call was determined by the decree. So thinking on this and what you guys have stated today, so what I'm getting out of this is it's not the decree as much as the relaxation agreements that are in place. There's 3 relaxation agreements in place. And those that is what you guys are asking to be co-managed or actually getting an additional relaxation agreement? I mean, is that what we're discussing here? Not necessarily the decree or even historical use, but we're talking about additional relaxation agreements here or adjusting what is in place.
I'll let Mr. Whitaker speak to that question.
Thank you, Director Camblin. I think how we have envisioned this is the current relaxation agreement and what we refer to as drought exceptions that are in the Shoshone outage protocol agreements would all be incorporated into a new framework that would allow a higher, most likely a higher rate to be in the river most of the time. But when those triggers, whatever they may look like through a collaborative approach, when they are approached or hit, there would be a way to request some type of relief or relaxation. I will add to that I think all the entities, West Slope and East Slope, are not going to need that relief at the same time. So what I envision is while one entity may need some relief in certain conditions in the future, that all parties could come together. I think for our system in particular, it's going to be very, very rare. And we would be more than willing to maintain a higher amount, even though another entity may need some relief for whatever reason. And so that's how I envision it. It's a framework at best at this point, but all the current agreements would be superseded by a methodology, by an approach to do best for the river, but also provide that flexibility for the uncertain future.
Okay, so the other question I have, is, so those current agreements are through Public Service Company, and then I can't remember, who else's name is on that. I've got it wrote down, but I don't remember, but you're asking for additional groups to be added to those current relaxation. I mean, so, there would be more parties on the relaxation agreements also.
Just to clarify, the relaxation agreement is only between Denver Water and Xcel Energy. The Shoshone outage protocol agreements are a much broader group.
Okay.
And we in many West Slope parties, I guess my vision of this would be a representative stakeholder group, including Grand Valley, East Slope, West Slope, everywhere in between, entities that are affected by the call in any way would come together to figure out what's best for all of Colorado.
Thank you.
Okay, are there any other questions? Okay, hearing none. Thank you.
I just wanted to ask, I believe it's Ms. Thompson is up next as the shared witness, and we only have 8 minutes before our break. That might not be enough time for her to get through her presentation, so
Okay.
maybe we take our break now.
Yes, I believe that would be a good choice. Thank you. Let's make a
think it's 15 minutes.
15-minute break.
Thank you.
Thank you.
Recording stopped. Recording in progress.
And back, so give one moment. Thank you.
I thank you all for returning from our lovely break, and thank you again, Viola, for the snacks. I believe Ms. Thompson is going to start for you all.
No, we'll be kind of jumping up and down throughout our presentation.
Is there a way that Ms. Thompson can go for like 2 discrete blocks? So it's.
You'll be going for a discrete block. She'll be the third, and then I'll be
Okay.
back up to wrap up.
Okay, just for Star Denver. Thank you. We're just,
Sorry.
no, it's okay.
Good morning. My name is Daniel Arnold, and I am an attorney with Denver Water's Office of General Counsel. And I want to begin first by thanking the board for affording Denver Water the opportunity to appear at this hearing and share its position on the proposal before you today. I also want to thank the CWCB staff for their transparency throughout this process. And I want to thank our friends at the River District for their willingness to provide the board more time for its deliberations, but also to continue to explore collaborative and cooperative solutions in the months ahead. Denver Water supports the acquisition of the Shoshone water rights and agrees it can be a win for the state of Colorado. The conversion of the Shoshone call to in-stream flow use has the potential to protect the environment as well as the flows of the Colorado River, which help ensure a reliable and sustainable river system. Denver Water believes that the Shoshone call flows are critical to protect, and that is why it agreed to permanently operate under the Shoshone outage protocol, or SHOP as it is commonly referred to. Denver Water believes that the status quo is best represented by SHOP, which is a set of procedural operating conditions that apply when the Shoshone power plant is unable to operate for any reason. However, I do want to caveat that while Denver Water believes SHOP is representative of the status quo, it is open to other collaborative approaches to strike a balance that is protective of flows and other uses of water. And we want to use the next few months to try and explore those collaborative solutions. Denver Water is concerned, however, that the current proposal before you today does not maintain the status quo as the proponent has pledged. And this raises 3 issues of concern for Denver Water, which are primarily legal and technical in nature. The first issue pertains to what maintenance of the status quo means for Denver Water and the differences between in-stream flow operations for the Shoshone water rights under SHOP as one potential scenario and the proposal that is before you today. Second, Denver Water believes that the BBA historical use analysis has flaws and requires revisions. In the interest of giving the board a full picture of the differences in water available under the Shoshone water rights, Ms. Heather Thompson, a professional engineer, will discuss her review of the BBA analysis and the amount of water a revised analysis could yield. Because of the significant discrepancies in the BBA analysis, Denver Water requests that the board and its staff refrain from taking a position on historical use in this hearing as well as in water court. In the alternative, the board may want to consider directing staff to retain a third-party consultant to do an independent analysis, but we do think there are some drawbacks to that approach. Third, Denver Water is concerned with provisions in the proposed dedication and use agreement that restrict the CWCB's discretion in how it would operate and use the Shoshone water rights in the future. For both policy and legal reasons, we believe the board should insist that the proposed use agreement be revised so that it may retain its discretion in how it operates and uses the Shoshone water rights for in-stream flow purposes. And we welcome discussions on how to do this and hope that we can be part of finding a collaborative solution. With respect to SHOP, we'll be presenting testimony from Mr. Bandy here in a few minutes, a registered professional engineer. And he's going to describe how SHOP has been implemented since 2013 and discuss the model differences of what things might look like and how the Shoshone water rights would operate for in-stream flow purposes under SHOP as compared to the proponent's proposal. But before I turn things over to Mr. Bandy, I want to make just a couple points on SHOP and the status quo. First, Denver Water has not requested or suggested that the board resolve a contract dispute in this matter. I do not think that is an appropriate role for the CWCB. And rather, what Denver Water is attempted to advocate is that the board consider applying terms that are similar to SHOP as a holistic compromise to maintain the status quo through its policy making power. This is just one idea, but we are open to exploring other concepts. A holistic approach, whether it be SHOP or some other concept, I think would be far better alternative to taking a potentially contested case to water court, which would be a drain on everyone's resources and could be extremely time intensive. Second, for what it's worth, SHOP does not prevent injury to Denver Water. It is not a historical use analysis. Rather, SHOP is a set of operating procedures that Denver Water agreed to as a compromise to maintain flows at the .0 gauge when the Shoshone power plant is unable to operate. Third, SHOP operates holistically. No one single aspect of SHOP protects Denver Water. Rather, between the flow rate limits in SHOP and the water shortage exceptions, they work together to provide Denver Water a level of protection when it is trying to replicate the Shoshone call and the power plant is not operating, while also protecting the Shoshone call flows most of the time. Hypothetically, if SHOP terms were incorporated to protect to apply to the operation of the Shoshone water rights for in-stream flow purposes, this could be done by reducing the call of the Shoshone water rights to no more than 1250 CFS in the irrigation season and no more than 900 CFS in the winter season. And when water shortages occur, as defined in SHOP between March and June, the Shoshone water rights would not place the call until conditions improve. And if they don't improve by the end of June, there would not be a call for the remainder of the irrigation season. If a water shortage occurs in the winter season, and Denver Water storage contents are at or below 79%, the call would be ratcheted down from the 900 CFS call eventually to no call if the storage contents of Denver Water's reservoirs fall below 49%. With that, I will defer to Mr. Bandy to provide his testimony.
Thanks, Tim. Good morning, directors. Thank you for the opportunity to speak with you today. My name is Jeff Bandy. I'm the planning manager for water rights, supply, and analysis at Denver Water. I have a BS and MS in civil engineering with emphasis in water resources. I've been a registered professional engineer in the state of Colorado since 2002, and I've been working as a water resource engineer for over 25 years, nearly 14 of which have been at Denver Water. As you know, Denver Water is a municipal water provider serving 1.5 million customers in the Denver metro area. Denver owns West Slope facilities and water rights, the operations and administration of which are affected by the Shoshone call. As mentioned by Mr. Arnold, Denver Water supports the effort to preserve the flow regime created by the senior Shoshone call and adding in-stream flow as a use of the water right. Denver Water committed to Shoshone permanency or the Shoshone outage protocol with the signing of the Colorado River Cooperative Agreement. SHOP and the related agreements are the status quo on the river today when the plant is not operating. Today, I'll walk through, first I want to go over how Denver Water operates our system in relation to the Shoshone call. how Denver Water has historically operated under the terms of SHOP, and go through some evaluations of some potential adverse impacts to Denver Water system if the proposed in-stream flow by the River District is adopted as opposed to SHOP conditions. My straight line diagram is not as detailed as Mr. Whitaker's. I apologize for that, but this focuses on Denver Water's facilities in the Upper Colorado Basin. So Denver Water owns water rights associated with several facilities that are illustrated here. Our West Slope facilities consist of the Moffett Tunnel Collection System, which includes the Upper Williams Fork Collection System and Williams Fork Reservoir. On the Blue River, we have Dillon Reservoir and Roberts Tunnel. And then to the north on Muddy Creek, we have Wolford Mountain Storage in Wolford Mountain Reservoir. All of Denver Water's facilities are located upstream of Shoshone and the Dotsero Gauge. And the water rights associated with these facilities are all junior to the senior Shoshone water right. And all of them, with the exception of the Moffett Tunnel Collection System water rights, are also junior to the junior Shoshone water right. When Denver Water's facilities and water rights are out of priority, we either need to cease diverting or we divert and replace a like amount to the downstream call. Typically, that is an exchange out of Williams Fork or Dillon is possible, and in an extreme, in an emergency situation, we can exchange out of Wolford Mountain. Shown here and located downstream of Dillon Reservoir is Green Mountain Reservoir. And the operations of Green Mountain Reservoir greatly influence Denver Water's West Slope operations. It's primarily through substitution operations, which I think you've heard reference to previously. Pursuant to the Blue River Decree and the Green Mountain Reservoir Administrative Protocol, Denver Water can store out of priority against Green Mountain. If Green Mountain does not achieve a fill in a given water year from inflows below Dillon, Denver Water replaces or substitutes the amount stored in Green Mountain and pays a substitution bill by releasing from Dillon to complete the fill of Green Mountain, or alternatively releases water from Wolford Mountain and Williams Fork to meet Green Mountain obligations downstream. As I mentioned, we contribute from all three of these sources. Since Dillon Reservoir can supply water directly to our treatment plants on the east slope, our preference, and through several agreements, we are allowed to replace out of Williams Fork and Wolford Mountain Reservoir. Depending on these operations vary greatly or can vary depending on the hydrology, the call, and operations of Green Mountain Reservoir. But in short, if Shoshone's calling, Denver Water is replacing to the call. Denver Water's commitment to honor the Shoshone call flows is laid out in the Shoshone Outage Protocol in the CRCA. Denver Water signed the CRCA with 17 West Slope entities in 2013. We committed to operating pursuant to SHOP, or the Shoshone Outage Protocol, in perpetuity. The SHOP terms, as Mr. Arnold described, I'll go over them briefly here, but the SHOP terms apply whenever the plant is shut down and unable to place a call, and the flow at Dotsero Gauge is less than 1,250 CFS in the irrigation season and 900 CFS in the winter. Exceptions to this include 17 days during the winter to replicate historical plant outages and maintenance outages associated with maintenance of the plant, and also the water shortage provisions that Mr. Arnold described. When a water shortage is determined, Denver Water is not obligated to operate as if the senior Shoshone water right is calling. These provisions reduce the risk to Denver Water supply in very dry conditions. Since this agreement has been in place, the water shortage provisions have not been triggered. This table is a table of Denver Water's contributions under SHOP since 2013. And I bring this up to illustrate that the Shoshone Outage Protocol is more than just theoretical. Denver Water's been operating with SHOP in place for over a decade when Denver Water and the River District committed to it in 2013. Other entities have joined in 2016 and subsequent years. SHOP is the status quo on the river today when the plant is not operating. And part of this administration of SHOP in recent years, as shown on this table, The big number is over 66,000 acre feet has been contributed by Denver Water to maintain the historical flow regime at Dot Cerro when the plant has not been operating. In 2023 and 2024, in those years alone, or in each of those years, we've released approximately 28,000 acre feet to the Dot Cerro gauge. The shop outage and flow conditions were not present in 2013 through 2019. This Denver Water was operating normally and not making shop releases. That's why you have zeros from 2013 to 2019 on this table. But we were replacing to the Shoshone plant, the Shoshone call when it was operating. Had the plant been off, and I'm not sure from a recollection if the plant was out during those years, but then the flow targets would not have triggered shop operations. So we're just operating normally in those years. I've mentioned substitution. I'm going to talk more about substitution here moving forward. But in 2021 and 2022, those were substitution years for Denver Water. There were drier years, and it's not always a direct correlation of dry years to substitution. But to point out that we were substituting to Green Mountain in those years, but the drought provisions were not triggered under SHOP. So the 1,408 CFS in-stream flow proposed by the River District is above and beyond SHOP. Compared with SHOP, the proposal will have the ability to call for greater amounts and for longer periods. This will have adverse effects on Denver Water's water rights and operations by requiring larger substitution bills as Green Mountain is called out more, and more reservoir releases will be required to effectuate our exchanges. Now I'm going to move into some modeling. So maybe I should just apologize there. We're talking about some modeling results. So Denver Water's evaluated these potential adverse effects to our system using our planning model. Noted here on the slide is PACSIM. It's called our Platte and Colorado simulation model. For this modeling, we compared two in-stream flows, the River District in-stream flow proposal of 1,408 CFS, and then SHOP conditions. So to model that, we modeled it as if it were an in-stream flow. As of course, today it's not, it's an agreement. But to model it, we modeled it as if it was a water right. And we modeled those effects on Denver Water's West Slope operations for two different scenarios, a current condition scenario and a future condition scenario. We did a current condition scenario and a future condition scenario to sort of bracket some of the impacts. They're not going to be exact. They're not going to, in the future, certainly is but one potential future. It's not certainly predetermined. The current condition scenario uses climate adjusted historical hydrology from 1947 through 2020, assuming Denver Water's current system as is built today and recent customer demand. The future conditions model adds Denver Water's gross reservoir expansion project into the system. It's currently under construction on the east slope to add 72,000 acre feet of storage to our system. It adjusts the historical hydrology from 1947 to 2020 with a projection of 5 degrees of climatic warming, and also with an increase in Denver Water demands of some future projection. In both of these scenarios, the Shoshone plant is assumed to be offline. Also, in these model results, drought triggers as may be implemented by Denver Water's board are also approximated and included in these results. The first impacts or results I'd like to discuss are in regards to substitution bills. As I mentioned earlier, the substitution bill is the amount of water that Denver Water stores out of priority against Green Mountain, and to the extent Green Mountain does not fill, owes that water back. We pay that water out of a combination of Dillon Reservoir, Williams Fork, and Wolford Mountain. So this chart here, the substitution bill is associated with the current conditions scenario for the model period 1947 through 2020. So this is the entire model period we looked at. The blue bars are the substitution bills associated with the River District in-stream flow. The orange bars are associated with a shop terms or shop in-stream flow. And these yellow highlighted bars are shop substitution bills that also coincide with water shortage provisions being triggered in the model. So as you can see here, under current conditions, generally speaking, the substitution bills associated with the higher in-stream flow rate are higher. And I'll also point out that the water shortage provisions are triggered but for 2 years in this 74-year model period. So that's less than 3% of the years. Looking at future conditions with a warmer climate, higher demands, the disparity is larger. You'll notice here that under the same 74-year period, there are more substitution years, and the substitution bills under the River District in-stream flow are greater and also more frequent, as too are the implementation of the water shortage provisions. The yellow bars, I think, would represent about 14% of the years, or less than 1 in 7 years. So it's still, there are more, but it's still a fairly rare occurrence that the water shortage provisions in SHOP are triggered. As I mentioned earlier, substitution bills and substitution operations are important for our system. And they first show up, or best reflected, in Williams Fork Reservoir. So I'm going to move into some Williams Fork Reservoir storage results here. So these are current conditions results for Williams Fork Reservoir storage. This graph shows the volume in Williams Fork Reservoir that Denver Water has available to meet substitution and replacement operations in our system. So this is zooming into the 2000s decade of the model. To show all 74 years would be not fun to look at, and not all that meaningful. The blue line represents Williams Fork storage under the River District in-stream flow, and the orange dotted line is under SHOP. The gray bar here indicates 1 year in the 2000s model period where the water shortage provisions were triggered. As I mentioned, Williams Fork serves to replace operations at Dillon Reservoir. These impacts at Williams Fork translate directly over to Dillon Reservoir. And where we see that most directly is in these years in 2002 and 2004, where the blue line hits zero. So when Williams Fork empties out, that impact translates directly over to Dillon Reservoir. So current conditions modeling again with Dillon Reservoir contents. Blue line is River District in-stream flow results again, and the orange line is under SHOP. You'll see here in 2003 and then into 2005, when Williams Fork emptied out in the previous slide, it's now translating over to lower Dillon Reservoir content. So we made higher replacements in the model, we made higher replacements out of Dillon Reservoir for those operations. And the thing here is that as the more we draw down Dillon Reservoir and even Williams Fork and Wolford, that increases the risk to our system. That increases the risk to Denver Water supplying our 1.5 million customers in the Front Range. The effects are pronounced when you look at future conditions. Going back to Williams Fork storage here under future conditions, the disparity between the two in-stream flow flow rates in the model results is more dramatic, with Williams Fork emptying out more frequently and generally being lower for a longer period of time through the 2000s drought under the River District in-stream flow. Williams Fork empties out in 2001, 2002, 4, 5, and 6 under the River District in-stream flow, but only 2 years under SHOP. You'll notice here under future conditions, the water shortage provisions are triggered twice in the model, in 2002 and then in 2004, excuse me. Similarly, this translates directly over to Dillon Reservoir, and so there's, again, the disparity between the two in-stream flow conditions is greater, and the period where Dillon Reservoir would be drawn down greater under the River District in-stream flow versus SHOP It's deeper and longer in duration. So while no model is an exact prediction of actual operations, it is useful to provide a reasonable comparison of how different in-stream flow conditions would operate in both the near term and the potential future conditions. In summary, the status quo when the plant is offline is SHOP. The modeling results I just reviewed were comparing to the status quo, the in-stream flow of 1408 to what is on the river today. But ignoring SHOP and moving to the proposed river district in-stream flow would have adverse effects on Denver Water. A greater in-stream flow amount and greater ability to call as compared to SHOP will require greater reservoir releases and thus result in lower storage. This will increase the risk to Denver Water supplies and its ability to supply 1.5 million customers. Further, as Denver Water recovers in subsequent years, stream flows, will be retimed. They will be reduced when the reservoirs refill from the greater drawdown. While I didn't focus on other reservoirs in our modeling, it's reasonable to assume similar effects would be seen elsewhere. In addition to the increased drawdown at the increased drawdown at Williams Fork, Wolford, and Dillon reservoirs will impact the flat water recreation in Grand and Summit counties. The lower Denver Water's reservoirs are drawn down, the less flexibility Denver Water has to maintain recreation targets in the reservoirs or contribute and retime outflows for recreational needs or critical habitat reaches. Thank you again for your time today. I look forward to the discussion, and I'm going to turn it back over to Mr. Arnold.
Thank you, Mr. Bandy. If SHOP terms are not applied to the Shoshone water rights, similar to Northern, for Denver Water, there's a greater need to accurately quantify the historical use of the Shoshone water rights because we won't have the holistic protections of SHOP. An accurate quantification of the Shoshone water rights is particularly necessary given their senior priority, flow rate, operation on the main stem of the Colorado River, and the need to prevent an unlawful enlargement which could result in material injury to water rights. As mentioned by Mr. Wirt, we have Ms. Heather Thompson here today, a professional engineer who's a shared witness between the Front Range parties. Ms. Thompson will describe the flaws in the BBA analysis, which could result in an enlargement of the Shoshone water rights historical use and provide her assessment of what an accurate quantification could yield. We do not ask the CWCB to try to resolve the technical flaws in the historical use analysis here today, but again, we are just presenting this information to provide the board with a complete picture of the issues surrounding historical use. We request that based on the significance of the proposed acquisition and the complexities of the technical issues with the BBA analysis, that the board take no position or take a position of neutrality on the issue of historical use today and in water court, and direct staff to take a similar position. And with that, I'll turn things over to Ms. Thompson.
We will now pause Denver's time, and Ms. Thompson's time will be kept separately and divided amongst the parties.
Good morning, and thank you for the opportunity to testify today. My name is Heather Thompson. I'm a senior water resource engineer at Ecological Resource Consultants, or ERC. I have a BS in civil engineering and a master's in water resource engineering, and I have been a professional engineer in Colorado since 1998. I have 30 years of experience in projects that involve the development and use of surface water allocation models, water rights investigations, water supply planning, and environmental permitting. I started in the field of water rights at BBA, spent several years at Boyle Engineering, and have been at ERC for almost 20 years. I've been involved in numerous water rights investigations on both the opposer and applicant side, and have testified and provided expert witness testimony in water rights litigation, with the majority of my work being in the Colorado and South Platte basins. I've been involved in a wide range of water rights cases that have involved change of use proceedings that have required historical use analyses. On the water rights and administration and operation side, I routinely work with municipalities and ditch companies regarding daily operations. I'm frequently in contact with Division of Water Resource staff regarding decree interpretation and water administration issues. Regarding my surface water allocation modeling experience, I've reviewed, built, and used several surface water allocation models, including the state's CDSS Colorado River model, to simulate river basins, raw water systems, and in the context of environmental permitting. I built the Windy Gap Firming Project model that was used for the effects analysis in that EIS. I reviewed Denver Water's PACSIM model for the Gross Reservoir Expansion EIS. I used the CDSS model, the Colorado River for the Colorado Springs Utilities Green Mountain Reservoir Substitution EA, and have used it to evaluate fish releases for the fish recovery program. I've routinely used the CDSS model to evaluate operations such as the Shoshone operations that I'll be testifying about today. The historical use quantification of the Shoshone water rights is foundational to whether the acquisition and use of those water rights can be made without material injury under an in-stream flow water right. A properly quantified historical use, or HU, can maintain the status quo and prevent injury because it prevents enlargement of the Shoshone water rights. Both upstream and downstream interests are at risk of injury if the HU is inflated or Shoshone return flows are underestimated. In the pre-hearing rebuttal and pre-hearing statements submitted by the Front Range entities that are here today, they made clear that they support an acquisition of the Shoshone water rights and use of that rights for in-stream flow use, preserving the functions those rights perform and protecting the historical flow regime. Their concern is with enlargement of the Shoshone water rights and with the River District's characterization of status quo and the volumetric limit that is proposed. The River District's HU analysis overstates the historical use and diversions of the Shoshone water rights, and its inflated volumetric limit would cause injury if it's adopted. The HU analysis is clearly complicated and difficult, and the purpose of my testimony today is to demonstrate the issues at stake with the HU analysis and the magnitude of difference in HU if alternative assumptions are used, so that the board can consider that information when evaluating the different options that Dan Arnold and Davis Wirt presented for the CWCB in terms of how they would participate in the change of use proceeding. On behalf of the Rivers District, BBA performed an assessment of the historical use of the Shoshone water rights, and under the set of assumptions that BBA used, they estimated the average annual yield of the Shoshone water rights to be 844,644 acre-feet per year. They claim that is an appropriate volumetric limit for the change of water rights if it's implemented on a 29-year rolling average basis. I disagree. I believe that BBA's analysis inflates the HU for the following reasons. BBA used an inappropriate study period that extends from 1975 through 2003, which excludes the last 2 decades. BBA used the .0 gauge as a surrogate for Shoshone diversions instead of the official CDSS diversion records. BBA assumed the administrative flow was equal to the .0 gauge prior to 1998, and the administrative flow is the amount of water that's physically and legally available to the Shoshone water rights. And finally, BBA excluded all months of full outage at Shoshone when they calculated the monthly averages, which it summed to determine an annual volumetric limit. I'll elaborate on each of these issues on the next slides. The first critical issue in BBA's HU analysis is the study period it selected. As I mentioned, they used the study period of 1975 through 2003 to quantify the yield of the Shoshone water rights. I believe a more appropriate and reasonable study period would extend from 1998 through the present. BBA's primary justification for its study period is that it is consistent with Colorado water law, which doesn't require that a study period include all years of operation, but include a sufficient number of average wet and dry years. While BBA's study period meets those criteria, state statute also requires that a study period be representative of historical use. A study period that excludes the most recent 2 decades is not representative. For example, BBA's study period includes only 6 years of current administrative practices, yet 23 years of administrative practices that are distinctly different and include operations related to the Shoshone administration that no longer occur. Most notably, prior to 1984, the division engineer did not administer calls on the Shoshone water rights. Instead, as Kyle Whitaker mentioned, releases were made from Green Mountain Reservoir in accordance with Senate Document 80 to maintain 1,250 CFS at the .0 gauge. Therefore, BBA's volumetric limit includes diversions at Shoshone of water released from Green Mountain Reservoir to prop up the flow at the .0 gauge. These particular releases have not been made from Green Mountain Reservoir under current administration since 1998. As a result, a significant amount of water that was historically diverted at Shoshone is not natural flow water and cannot be legally available to the Shoshone water rights and called for under the Shoshone water rights today. Therefore, if BBA's volumetric limit is adopted, when Shoshone calls in the future and Green Mountain Water does not release this water that was historically released to prop up the .0 gauge flow, that source will need to come from another supply. That supply will consist of junior upstream water rights and replacement releases from reservoirs such as Williams Fork Reservoir, the Green Mountain Historic Users Pool or HUP Pool, and CBT's 52K Pool. This will clearly change the historical flow regime and reduce the amount of water that these upstream junior water rights were historically entitled to divert, which is injurious. An appropriate way to address this significant issue is to select a study period that extends from 1998 through the present. That period contains a sufficient number of average wet and dry years, and most importantly, it reflects the current administration on the river for the past 25 plus years. BBA's concern is that the period after 2003 includes more outages at Shoshone. However, there are other ways to address that rather than simply excluding all years after 2003. In addition, BBA could have excluded these additional reservoir releases from Green Mountain Reservoir that I just mentioned for the period prior to 1998. These concerns and options were discussed with BBA, River District, and CWCB staff, and we're hopeful that they will continue to consider these recommendations as they refine their HU analysis for the change case. The administrative flow prior to 1998 must be addressed if the study period includes those years. As I mentioned, BBA assumed that the administrative flow was equal to the .0 gauge prior to 1998. I believe they should rely on the undepleted flow at .0 gauge, which was reported in the USBR Colorado River accounting ledgers prior to 1998. The administrative flow at .0 is what the division engineer uses to administer the Shoshone water rights. It represents the amount of water that's physically and legally available for diversion at Shoshone. Importantly, it excludes reservoir releases that are shepherded to users downstream of Shoshone, such as Green Mountain Reservoir releases to GVIC, Government Highline, releases to HUP beneficiaries downstream of Shoshone, and releases for the Fish Recovery Program. For the 6 years from 1998 through 2003, BBA excluded these reservoir releases that were destined to users downstream of Shoshone. I agree with that approach, since it prevents overestimating the amount of water that's available to the Shoshone water rights. However, prior to 1998, BBA simply assumed that the administrative flow was equal to the .0 gauge and did not make an attempt to exclude reservoir releases such as the releases I mentioned from Green Mountain Reservoir. BBA's pre versus post 1998 methodology is inconsistent. The approach for the years prior to 1998 overestimates the HU. The undepleted flow that was recorded at the .0 gauge in the USBR ledgers is similar to the administrative flow that the division engineer uses today, since it was used to administer the Shoshone water rights, and it excluded the additional releases from Green Mountain Reservoir that I just mentioned. The undepleted flow was often several hundred CFS less than the .0 gauge. Therefore, BBA's reliance on the gauge flow prior to 1998 inflates the historical CU. I believe the HU analysis should rely on the undepleted flow if the study period includes the years prior to 1998. This issue can be avoided if the study period extends from 1998 through the present. Another critical issue in the HU analysis are the Shoshone diversion records. BBA used the USGS .0 gauge record capped at 1,408 CFS as a surrogate for Shoshone diversions. I believe they should use the CDSS Shoshone diversion records that were submitted by PSCO to the state, and they're reported by the state of Colorado. The .0 gauge measures the flow in the Colorado River approximately 8 miles upstream of the Shoshone diversion dam. While the flow measured at .0 is used to administer the Shoshone water rights, it is the location of administration, not the decreed diversion point. It is not a measurement of diversions at Shoshone, because there is no measurement structure at the Shoshone diversion dam. There are tributary inflows between the .0 gauge and gains and losses that occur between the gauge and the diversion dam. We understand that PSCO estimated the amount of water diverted as shown based on power production records and an assumed efficiency. Since the CDSS diversion records relate to the amount of water that was diverted and put to the beneficial use of power production, I believe they are the more accurate and reliable source for determining the HU. The figure on this slide shows the difference between the flow at the .0 gauge capped at 1408 CFS, which is the red line on the graph, and the CDSS Shoshone diversion records. The x-axis on the graph extends from water years 1975 through 2024, and the y-axis is in acre feet per month. As shown on this graph, the red line, the .0 gauge capped at 1408 CFS, is considerably higher than the CDS diversions, particularly after 2003, but even during the study period, there are significant differences between the .0 gauge flow and the CDSS diversion records. BBA assumed that the difference between the blue line, the CDSS diversions, and the .0 gauge capped at 1408 CFS was diverted at Shoshone with no evidence or records of such diversions. Using the .0 gauge capped at 1408 CFS as a surrogate for Shoshone diversions instead of the official CDSS diversion records results in a significantly higher estimate of HU. Finally, BBA's exclusion of months of full outage at Shoshone inflates the volumetric limit. BBA did not include any full months of Shoshone outage when it calculated the monthly averages that it summed to determine its annual volumetric limit. If the CDSS records show no water was diverted for an entire month, it may be appropriate to include a 0 for that month so as not to overstate the monthly averages. Outages are a part of real-world operations, whether they are planned or unplanned. They can be due to a number of reasons, including repairs, maintenance, the relaxation of the Shoshone call, damage caused by weather-related events. Future use of the Shoshone water rights for in-stream flow use will not require use or operation of any of the Shoshone facilities. Therefore, it's critical to reflect these outages in the HU analysis, since in-stream flow use will not require operations of the plant or facilities, unlike use of the water rights for power production. BBA claimed that these outages were largely due to events that were outside the control of PSCO. However, several of the outages, including taking the plant offline to automate operations, reducing seepage at the dam, the call relaxation per the Denver PSCO agreement, and inspections were within the control of PSCO. While exclusion of months of outage was an issue for only 1 month in BBA's study period, it occurred more frequently in the period after 2003. To demonstrate the significance of the assumptions used in this analysis and the extent that I believe BBA's HU is overestimated, I prepared a revised estimate of HU using different assumptions that I believe are more defensible. I used the study period from 1998 through 2022. I used the official CDSS diversion records. I also included months of full outage at Shoshone. My revised estimate of the average annual yield of the Shoshone water rights is 538,204 acre feet per year, which is about 36% less than BBA's estimate. Use of the Shoshone water rights would be enlarged if BBA's volumetric limit of approximately 845,000 acre feet per year is adopted. Unlawful enlargement of the Shoshone water rights will injure other water rights because there will be changes in the frequency, duration, and timing of Shoshone calls, which will alter the historical flow regime. The graph on the following slide shows in a stepwise fashion the impact of each of the assumptions that I just discussed. On the x-axis is months of the year, and the y-axis is average monthly diversion rate in CFS. The red line at the top of the graph is BBA's volumetric limit distributed on a monthly basis. The second blue line down shows the reduction in the volumetric limit due to changing the study period. The third line down, which is the green line, shows the reduction in the volumetric limit if you use the CDSS diversion records. And then the fourth light blue line at the bottom shows a reduction in the volumetric limit if you include all months of full outage. That line equates to 538,204 acre feet per year. As shown on this graph, the study period and the CDSS diversion records versus .0 gauge records play a significant role in the HU estimation. The table on this slide provides a month-by-month comparison of BBA's volumetric limit and the revised estimate that I just mentioned. I'll just draw your attention to three boxes that are highlighted red. The first box on the left is BBA's historical use estimate. The box in the middle is my revised estimate at 538,000 roughly. And the box to the far right shows the average monthly differences in CFS. The monthly differences in our averages range from 260 CFS to as much as 691 CFS in June. In addition, to just put something in perspective, if you look at BBA's numbers, their average monthly diversion in May and June is 1,394 CFS over a 29-year study period. That is 99% of the Shoshone water rights. The graph I showed earlier of the historical CDSS records show that was not the case. The next series of slides shows how an inflated volumetric would translate to injury to decreed water rights. I'll also apologize because similar to Jeff, I'm going to be talking about some modeling, but I will keep it as brief as I can. I use the CWCB's updated CDSS Colorado River model in a daily mode for the period from 1988 through 2013, and I modified the demand at Shoshone. The demands for all other users in the model represented current conditions that was just available in the model that CWCB provided. When simulating the CWCB's current conditions model, similar to Hydros, the only thing that I changed was the demand at Shoshone. For one scenario, I placed a demand at Shoshone that is equivalent to historical diversions. That limits the simulated diversions at Shoshone to historical levels, and the purpose of that run was to simulate diversions at Shoshone that were reflective of historical diversions. For the second scenario, I placed a demand at Shoshone that was equivalent to BBA's volumetric limit. The demand schedule I used was 1,408 CFS from the end of April through October and 900 CFS from November through about the end of April. The purpose of that run was to simulate diversions at Shoshone that were consistent with the BBA volumetric limit up to that amount each year. The results of that modeling showed the following impacts would occur if diversions at Shoshone increased from historical levels up to the levels of the BBA volumetric. There would be more frequent curtailment of diversions by upstream Trans Mountain projects, other junior water rights, and HUP beneficiaries to the extent the Green Mountain HUP pool is depleted. There would be increased drawdown of replacement reservoirs and accounts, including Williams Fork and Green Mountain Reservoir HUP pool and 52K pool. In addition, there would be an increased substitution bill, which increases the drawdown at Williams Fork and Wolford Mountain to pay that bill. There are other impacts as well. There would be flow increases in the 15-mile reach, but there would be flow reductions as well when these replacement reservoirs that I just mentioned are refilling in priority during runoff. The figure on this slide demonstrates the additional drawdown that would occur at Williams Fork Reservoir if the simulated Shoshone diversions increase from historical levels up to the BBA volumetric levels. The x-axis on this graph shows water years 1988 through 2013. The y-axis shows contents. The red line on the graph represents the Williams Fork contents under the BBA volumetric, and the blue line on the graph represents Williams Fork contents with the historical demand level. This graph shows that Williams Fork Reservoir is drawn down in most years and significantly more during the drought period from 2001 through 2004. When Williams Fork Reservoir is drawn down more, that means additional water will need to be diverted to storage when in priority during runoff. That will reduce flows in Williams Fork Reservoir and further down in Williams Fork River, and in further downstream in the 15-mile reach. Hydro similarly modeled different demand levels at Shoshone using the daily CDSS model with current conditions levels for other users. However, I believe that Hydros' analysis underestimated impacts on storage and the Trans Mountain projects. I believe this difference boils down to the demands that we modeled at Shoshone, since that was the only thing we both changed in the model. Hydros' impacts were based on a comparison against a baseline scenario with simulated Shoshone diversions that do not represent historical diversions. The scenarios that Hydros compared generated very similar Shoshone diversions that are much higher than historical diversions. If the simulated Shoshone diversions are essentially the same, and there's no other change in model inputs, there will be little to minimal change in upstream facilities and diversions by other projects. The figure on this slide illustrates different demand levels at Shoshone. The x-axis of the graph shows months of the year, and the y-axis is in acre feet per month. The blue line at the bottom is the average monthly CDSS diversion for the period from 1988 through 2013. The yellow line on the graph represents the demand at Shoshone that was in the CWCB's version of the model. And the gray line at the top represents the max Shoshone demand, which is 1,408 CFS, 24/7, 365 days of the year. Hydros compared two scenarios with demands at Shoshone that are essentially equivalent to the yellow line and the gray line, although they did include relaxation in 2003 and 2013. So their max Shoshone demand is actually even a little bit lower than the gray line that's shown. The figure on the next slide illustrates the difference in the average monthly simulated natural flow diversions at Shoshone that's generated by modeling the gray and yellow demand lines at Shoshone. As shown in this figure, there's very little difference between the gray and the yellow lines. If there's little to no difference in simulated Shoshone diversions, there will be little difference in upstream diversions by junior water rights, since all other model inputs are the same. I believe Hydros also underestimated impacts on Trans Mountain projects and storage because it didn't show impacts on reservoir contents such as Williams Fork Reservoir, Homestake Reservoir, replacement accounts in Green Mountain like the Hupp Pool and the 52K Pool. Impacts due to increased calls at Shoshone will be experienced at these reservoirs first before you will see an impact on diversions or deliveries through the tunnels. In summary, I believe Hydros underestimated impacts on upstream junior water rights and storage because the demand levels that it modeled generated very similar Shoshone diversions. In summary, the Front Range entities support CWCB's acquisition and use of the Shoshone water rights for in-stream flow use if the status quo is maintained and there is no enlargement. BBA's proposed volumetric limit overestimates the historical use by approximately 36%. If BBA's limit is adopted, that will cause material injury to decreed water rights, including more frequent curtailment of upstream junior water rights, increased drawdown of replacement reservoirs, which decreases the reliability of those reservoirs, particularly through a drought, and increased substitution bill and drawdown of the reservoirs to pay that bill. Thank you very much. And with that, I'll turn it back over to Dan.
Just give Viola 1 second. Thank you. We'll resume Denver Water's time now.
All right, thank you. This is Dan Arnold again for Denver Water. And so even though you all have more comfortable chairs today, I'm going to try and be brief on this final section and wrap up. Just on the discretion issue, I don't want to belabor points on that. We agree, I think, with pretty much everything Northern said. We just think as a policy matter, it's important to retain some level of discretion because of the potential unknowns out there. I think Mr. Bandy's slides illustrated what could potentially happen to reservoir storage during future scenarios, which we don't necessarily know will unfold, but could. And I think potentially if Williams Fork is down, other West Slope reservoirs could be down, and there could be a situation where folks need relief. Additionally, I could see a situation where maybe the science changes on aquatic life, and maybe there's a different approach to trying to protect the environment, or environments change over time. And I think there's also legal concerns. I don't think I need to go through all of those. I think you're already aware of those and have commented on them. So in conclusion, Denver Water's request for relief is that as a policy, the board consider adopting terms that either mimic SHOP or some other compromise proposal that strikes a balance between protecting and improving the environment and the need to maximize other beneficial uses of water. And that provides a means to protect essential water supplies in times of extreme shortage. And we think that's a much preferable approach than going to water court. It'd be, I think, better for everyone if we could, in the next few months, reach consensus on a potential consent decree. and go into water court without any disputes. Again, we request that the CWCB remain neutral on historical use, quantification, and methodology, and give direction to staff to remain neutral. I think there's other approaches, as I mentioned, but I think they do have some drawbacks. And modify provisions in the proposed dedication use agreement to retain some level of discretion. We were concerned with paragraph 7C and 9. Also, other paragraphs, we have some red line revisions that are set forth in Denver Exhibit 1. And with that, thank you for your time again, and we're happy to answer any questions that you have.
Director Haas.
Yes, thank you. I have a question on Mr. Bandy's slides. I just wasn't tracking your slide on the contributions and the significance of what you were sharing there. Just wondering if you could go over that again.
I'd be happy to, Director Haas. Yeah, the takeaways from 2013 to 2024, these are Denver Water contributions under SHOP from our replacement reservoirs. So I'd like to just reiterate that we are operating under SHOP. We are replacing to maintain the historical flow regime as contemplated in the CRCA and SHOP. Did that answer your question?
Yeah, so when you use the word contribution, I just want to make sure I'm understanding that. That's what you're releasing from your reservoirs to make sure Shoshone's whole?
Or contributions towards
per the agreement.
1250 or 900 per the agreement,
Okay.
correct, without an actual call on the river.
Okay, and so those first, I don't know, 10 or 8 years, that meant,
So from 2013 to 2019, most likely the plant was operating. So we were replacing to the plant and the power call at the time.
okay.
So the plant was either operating, or if it wasn't operating, flows at dot zero were 1250 or 900. So this is the non-zero numbers are purely a SHOP contribution by Denver Water.
Okay, so in 2021, 2023 and 24, SHOP was operating, and this is what you all were sending downstream per the agreement.
That's correct.
Okay, thank you.
Thank you for the help in clarifying that.
Director McLeod.
Well, I have a question for Dan. Now, you ask us, I think you're asking us to put SHOP terms in the acquisition agreement. Am I understanding that correctly? Terms that mimic SHOP was your number one point on your list of requests?
That I think would be a starting point. I mean, hypothetically, the board could include a term in the acquisition agreement that says any decree to be applied for in water court will include terms that mimic SHOP. I don't know that you have to put the terms verbatim into the decree. I mean, I'm sorry, into the use agreement.
Well, you seem to assume, it seems to me you're assuming that this acquisition agreement cancels SHOP. I mean, that's the status quo. The River District is a party to SHOP. How does this acquisition change the River District's obligations under the existing agreement?
That's a good question. I think what we're thinking is that we're able to come up with terms that replicate SHOP that we can live with altogether in place of SHOP. So I mean, potentially there might be the need to work out some side agreements with other parties to those separate contracts to recognize that what we're doing now satisfies those obligations in SHOP.
Well, but SHOP doesn't change just because the board acquires an interest in this water right. Isn't that correct?
That is correct.
So
unless it's modified or amended.
The water right would continue to operate under the current conditions, under current SHOP conditions, wouldn't it? So what do we need to do in addition to maintain the shop protocol. It seems to me it stays in place regardless of what we do.
It's hard to say how a court might resolve these issues. I'm reluctant to say that that is definitely, I mean, that could be one outcome. There's a potential that a court could say or conclude that what has been proposed with the in-stream flow acquisition is so inconsistent with what was contemplated in the CRCA that this change isn't it is inconsistent with the party's intent and plain language of the CRCA, that it just can't be accomplished. And
Well,
that
but
they need to continue to just operate under shop.
the court could do that regardless of what we do.
True, and that's why we're proposing. I guess we're thinking that we can come together and have agreement on terms that mimic shop.
But why do we need to do anything with shop? It's there, it's been operating, all the parties have complied with it so far, as I understand it. What do we need to do with it? Can't we just leave it alone and let it continue to operate as it has historically? Why do we need to get involved in that?
Yeah, potentially you do not need to, but I think there'd still be issues that would need to be sorted out in water court.
But that has nothing to do with us, and that's gonna happen anyway, right?
Yes.
Okay. Different question. Thank you for your answer, by the way. Can we have your list of requests again, please?
Sure.
There. So you're talking about modifying paragraph 7C. Yesterday, Mr. Mueller agreed that the River District would work with CWCB staff to create a collaborative process for exercising 7C. Does that give you any comfort that this issue might be resolved in that way?
Yes, I think a collaborative process is a great idea, and we're open to exploring that. I mean, I think the challenging issue is, I think you still need some backstop if that collaborative process breaks down, and I think that's something that will need to be resolved. And I think
So we made a little bit of progress toward that goal yesterday, don't you
I
think?
believe so.
Okay, good. Thank you.
Okay, are there any other questions? Director Combs?
I'm offended you didn't look my way first. Yeah, sorry. Would you also recognize, Mr. Arnold, that I think Mr. Mueller was very plain in saying that they put out the BBA study just as a starting point. And so I never heard them think that they're hanging their hat on that anyway through their presentation. So I appreciate what Heather did with that study and the complexity of it, but do you agree that somewhere in the middle is gonna happen, and that is water court will handle it and they'll look at it? I've been involved in a lot of water court cases, but all the ones I have, I've never seen two engineers agree. And so, I guess that's a stab, didn't mean to be, but so at that point, it seems like that's something that's gonna get handled anyway in the course of the court. So I would just say, I guess the point is, be cautious of, I think they're coming with a collaborative mindset, and don't hit them over the head because they're trying to come out and start the negotiations. That's all. That's what it kind of felt a little heavy when they were very adamant, this is just a starting point. So if these negotiations are going to move forward, I think everybody has to recognize the intent of where someone's coming from. That's it.
Thank you, Director Coombs, and I appreciate your comment. we recognize that the BBA analysis is preliminary. And I think what Ms. Thompson she's trying to show maybe a potential bottom line scenario, but there's also decisions that along the way that the water court would have to make, and you could end up anywhere in the middle. Totally agree. And, I sometimes historical use analyses are litigated in water court, but there's also lots of cases where parties are able to come to some kind of meeting of the minds. And I don't want to foreclose that.
Sorry, I didn't mean to. As a follow-up, I was just thinking in the good nature of trying to negotiate and not have to go to water court. I'm just saying that little response there, that's it. Just if you want to stay out of water court, that's where I would ask you if it's possible to acknowledge that was just the starting point and that it'll work out with them.
We understand and we do acknowledge that.
Okay, are there any other questions? Okay, hearing none. Thank you.
Thank you.
I believe Aurora is next. And Madam Timekeeper, can we maybe tell Aurora how much time they have given the subtraction from Ms. Thompson? No, only a 1/5. Okay, so 20. The English major is not allowed to do math in front of this many people. If we could. 4.5, it sounds like, just about. Yeah, let's go with 4.5. Thank you so much.
All right.
0.6. We'll go with that. Thank you, Scott, for saving me.
We will wrap it up before that time. Good morning, Madam Chair, Board of Directors. My name is Josh Mann. I am an attorney for Aurora Water. It's great to be here with you today. I would like to express appreciation to you all for the opportunity to present Aurora's perspective on this acquisition and hopefully provide some information that may be helpful to you all in your deliberation process. As Aurora has emphasized in all of its written and verbal comments, it strongly supports the acquisition of the Shoshone water rights. Our concern lies with the River District's proposal. The question before you is not whether to protect the Colorado River in Glenwood Canyon with the Shoshone water rights, but how, in a way that is legally sound, environmentally meaningful, equitable for all Coloradans, and that does not permanently delegate the board's exclusive authority or set a troubling precedent. There are 3 interrelated flaws in the current proposal which pose a significant threat to Aurora's water supply. First, based on Heather Thompson's testimony, which we just heard, the River District's historical use analysis is not actually representative of historical use, and which would result in a greatly expanded quantification. They say it is just preliminary, and we note that they've acknowledged that it's a starting point, but in their rebuttal statement, they made it clear that they're wed to their methodology. And I will also note that they have rejected every suggested improvement to that methodology that Aurora and the other Front Range water users have offered. Second, the River District has proposed a co-management approach in its draft in-stream flow agreement that is arguably unlawful and clearly unprecedented. Whether it is right or wrong is for you all to decide, but the General Assembly granted you the exclusive authority to hold and administer in-stream flows with the obligation to act appropriately and reasonably, balancing environmental benefits with statewide interest. That authority is particularly critical here, given the magnitude of potential effects. Third, staff has recommended that you approve the River District's proposed in-stream flow agreement. However, approval on those terms would align the board with the River District in water court. I know we've been talking about that, but that's effectually what would occur, which would commit your institutional weight to this analysis that enlarges the Shoshone water rights and would put you at odds with the very Front Range water communities that stand to be harmed. It would also permanently hand over control of the Colorado River's most commanding right, leaving the board with no ability to adapt to future conditions. We highlight these flaws to encourage you all to direct staff to pursue a workable co-management arrangement and an objective analysis that preserves the historic flow regime. As Director McLeod mentioned, this is something that was begun yesterday, and Aurora is looking forward to learning more about that process. And then I just would like to address the image on the screen here. We know you have received literally thousands upon thousands of pages of written material in preparation for this hearing. So we wanted to share our concerns with some imagery. This image represents the acquisition terms as currently proposed, at least from Aurora's perspective. We are asking you to avoid this outcome and instead to direct the parties to work together towards a collaborative solution that will be a true win for Colorado. At this point, I'm going to turn this over to Alex Davis, and I'll be back shortly. Thank you.
Good morning, Madam Chair, directors, Madam Hearing Officer, who's not here. For the record, my name is Alexandra Davis. I am an Assistant General Manager at Aurora Water. My division is Water Supply and Demand, is responsible for the raw water supply, storage supply projects, as well as conservation for the city of Aurora. I've been in water resources for about 30-ish years. Almost 20 of those years were spent serving the state of Colorado at the Attorney General's office, at the Department of Natural Resources, and at Colorado Parks and Wildlife. The last 10 have been spent at Aurora Water, working on their water supply issues. Sorry. As Josh said, Aurora Water supports this acquisition so long as there is not an expansion of use, which is what a lot of the testimony yesterday said. A lot of water users said yesterday, maintain the historic flow regime. We are asking the same, and we think that is a great idea. The city of Aurora understands the value of water. We started our system in the late 1950s. And as most of you know, when you start acquiring water rights in the late 1950s in Colorado, you are late to the game. Aurora had to work hard to create a reliable drinking water supply for its citizens at the time, and the city council directed Aurora to create a diverse water supply. One of the early projects that Aurora Water Department engaged in was the acquisition and the building of the Homestake project in partnership with Colorado Springs. Today, that system, along with 2 other Trans Mountain water rights, comprises 25% of Aurora's water supply. What does the city do with its water? Aurora Water enables the existence of world-renowned medical centers, Anschutz Medical Center, UC Health, Children's Hospital. And I understand the extraordinary service that those institutions provide the state of Colorado on a very personal level. When my son was 4 years old, he had to have surgery, and he had that at Children's Hospital, which was a gift. More recently, one of my closest friends growing up, who still lives in Carbondale, spent months driving back and forth to Anschutz Medical Center so that her husband could get the care he needed for stomach cancer. Alongside these hospitals, Aurora supports over 30,000 healthcare and bioscience jobs, which are created by over 160 companies in those fields, creating enormous research and innovation that benefits everyone in the state. We support over 22,000 jobs in aerospace and defense, jobs that pay on average $140,000 a year. That goes greatly to providing a strong quality of life. Our community college, our technical college, our medical campuses provide great career pathways for our children and develop talent that benefits all of Colorado. Additionally, as in all cities, we support those people who are critical to functioning communities. The teachers, the police, the firefighters, government workers, utility workers. The citizens in Aurora enable a lot of good things for the state of Colorado. And Aurora Water enables those citizens to do that work and provide those services in a way that demonstrates every day how deeply we care about and value our water resources. Aurora uses water wisely. Our water ethic is reflected in our comprehensive and robust portfolio of programs to drive efficiency across all sectors, industry, commercial, residential. We have programs that address large water users. So we allocate how much a large water user, say a data center, can use. And if that data center comes to Aurora and they cannot fit within that allocation, they don't get to come to Aurora. We have a connection fee schedule and a very progressive 4-tiered rate structure that ensures those people in lower income brackets have the water they need to meet all basic human needs, but also ensures that people who have more, who have plenty, who have large lawns or big landscaping, they pay significant amounts more. They have to pay the value of that water in order to maintain that lifestyle. Aurora Water the city of Aurora was the first entity in the state to adopt a ban on non-functional turf. People on the West Slope have been concerned about Front Range Kentucky bluegrass for decades. And Aurora Water was the first to take the step to say, we too are concerned about Kentucky bluegrass and we too don't want any more. We also committed to take out 30% of our existing turf, which if anyone has been involved in turf removal, you know it is extraordinarily expensive. Our water acquisition is done with a deep commitment to partnership. Recently, you probably saw in the news, about 1.5 years, 2 years ago, Aurora bought a large farm in the Arkansas Valley. That was done completely within constraints of IGAs that we had entered into with entities in the lower Arkansas. And we have committed and are committed to keeping that farm in production in perpetuity. Some people are skeptical, but we have made that commitment and we will do it. We have invested millions of dollars into automated metering. Aurora's leak levels were already quite low, around 4% when I started, which is significantly low. But we are now even more efficient in finding and preventing water loss. We have an incredibly aggressive and robust conservation program with 24 different programs to help people reduce demand. Our indoor water use is already extremely efficient at 115 gallons per capita per day, and we're constantly working to reduce that outdoor use. Our conservation programs use regulatory criteria, conservation incentives, grants, rebates, education, outreach, and enforcement. And we are constantly seeking to maximize our existing water supplies. We believe that our programs to drive efficiency are unparalleled in breadth and depth. Every drop counts. Not only are we constantly looking to ensure wise water use, but we built the first, and I think still the largest, indirect potable reuse plant system in the state, the Prairie Waters Project, which allows us to reuse 95% of our water rights to extinction. Aurora was an early adopter of reclaimed water for irrigating parks and golf courses, and we are working to implement direct potable reuse by 2030. Taken together, our ethic of operation, stewardship, and our unmatched conservation and reuse demonstrate our deep commitment to using our water that is critical to our economy, that is critical to the state's economy, to all that Aurora provides, and to our 400,000 citizens as efficiently as possible. I'd like to point out also that Aurora takes on average 25,000 acre-feet from the Colorado River, 20,000 acre-feet through the Homestake system. The River District noted yesterday that there's been an average annual flow at Dotsero since 1941 of 1.5 million acre feet. 20,000, 25,000 acre feet, I was going to say is not even a fraction of 1.5 million. It is a fraction, but it's a very small fraction in the context of the Colorado River. But to Aurora, that water, every single drop of that water is critical supply for critical uses. And we are not here, as claimed in the newspaper recently, to seek some sort of windfall, but we are here to protect every single drop that Aurora currently takes from the Colorado River. Entities yesterday talked about injury, that they might suffer under certain circumstances with regard to the operation of this right. And as Rick Keenitz will discuss later, and Heather made clear earlier, the methodology employed by the River District currently in defining the status quo of the flow regime would result in an annual reduction of approximately 17% of our existing Colorado River rights. We understand that the analysis is preliminary, but as Josh mentioned, BBA's rebuttal statement says the methodology is not going to change. So the analysis and the results of that methodology might be informed, but the methodology that they're going to use is what we are concerned about. And they have said in their rebuttal statement, that's not going to change. 3,500 acre feet of water annually is what that 17% represents. An amount that is actually immeasurable after the confluence of the Colorado and the Eagle River. But to Aurora, that reduction has significant impacts on our annual water supply. And that's why determining the historic flow regime and ensuring no expansion of Shoshone water rights is imperative. So my testimony is very similar to a lot of the testimony that you heard yesterday. Testimony about protecting culture, economics, industry, livelihoods. Every entity participating in this hearing has water use that they consider extremely valuable. All of us do. And guess what? All of those uses are extremely valuable. It is this fact that makes your role in the operation of the proposed in-stream flow water rights so very important, so very critical. No entity participating today is charged, as you are, to ensure statewide solutions. This is about more than your authority on in-stream flows. This is not about asking you to determine whose water right or whose water use is more valuable. That is a Gordian knot, and also, fortunately, is completely unnecessary. This is about ensuring that the agency that is entrusted, charged to conserve, develop, protect, and manage Colorado's water for present and future generations is the agency that creates transparent and inclusive processes to answer difficult questions in these difficult times. This is why the content of the in-stream flow agreement is so important, and the board retaining its ability to be flexible in times of extreme drought is so critical. Every entity, including Aurora, is concerned about getting less than what they have been getting. And this is why the board is the right entity to make the difficult decisions. The River District yesterday noted that they are an entity charged with upholding public interest. So are we. We are a nonprofit government entity. We are our local government. Most of the entities who testified yesterday have that same charge of upholding public interest. The River District noted they have repeatedly over the last decades, in a context of numbers of negotiations, demonstrated their willingness to work creatively with the Front Range entities to find solutions. And that they have. And there's no question that many of the entities, including the River District and the Front Range entities here, have been involved in numerous negotiations that have led to creative and important agreements. Some of the agreements are the ones that the board that you requested yesterday be acknowledged in the in-stream flow agreement, and we appreciate that request. In the same presentation yesterday, the River District also said, and I quote, "We have to protect the west slope and all of the values you heard about. We have to protect the west slope. Aurora is very happy to hear that the River District wants to work together to find a good path forward that listens to all of the water user needs, and so does Aurora. And we are appreciative, very appreciative of the River District's extension of time to help find that path forward. But the issue, which is no surprise, and as Director Vasquez noted in her previous question, the issue is a trust issue. Entities on the west slope believe or think that the Front Range entities are looking to take advantage. The Front Range entities, at least Aurora, is concerned that the west slope is trying to diminish our existing water rights. While the River District is right about our ability to find solutions and get creative going forward, the main reason that we are here today is because, as the board noted yesterday, the in-stream flow agreement as proffered does not reflect what the River District committed to yesterday. And this is why the board's role in maintaining your authority is vital. I wanted to take a second to try to respond. I know you've gotten some responses, Director McLeod, to your question about the authority. And I have great respect for the Attorney General's office, and I know they do great work. And I am going to very respectfully disagree with the idea that the board's discretion regarding operating an in-stream flow is so different if the water for that in-stream flow is an acquisition versus an original appropriation. I heard the position to be that in the case of an acquisition, the board has no authority over how the in-stream flow would be called. And while I agree the statute does look at acquisitions and appropriations a little bit differently, the statute, when read as a whole in the context of the in-stream flow statutory scheme, vests the authority to operate in-stream flow rights solely with the CWCB. The legislature vested this authority with the Water Conservation Board specifically because they wanted the state to be able to balance the needs of the environment with the needs of mankind. The River District's point about a donor wanting to retain the necessary control to ensure their donation is used as it intended has emotive appeal. And as the River District pointed out yesterday, there have been times in the past when the needs of mankind took precedent over the environment. The fact that today no one is contesting that the environment would be protected by this in-stream flow, or that it should be protected by this in-stream flow, demonstrates how far our balancing and our priorities have shifted. And that's great. And regardless of that, it doesn't change the overall statutory scheme about the authority granted to the Conservation Board. The decree will set some parameters, but it won't dictate how everything operates in every situation. And that's why the board needs to retain its flexibility to address the statewide issues. The process, I was going to say, in my experience, most of the agreements of this type are accomplished because there is some sort of driver. So while everyone agrees we need to come to an agreement and people are willing to work on an agreement, generally these types of agreements need a driver. And it's this process and the water court process and the board who are the drivers in this case that drive us to the table to talk. Briefly, I just wanted to touch on the 2018 IGA. We signed this IGA with the River District and several other West Slope entities. Before SHOP was signed, you have all heard quite a bit about SHOP. Before SHOP was signed, when the power plant was operating, or only operating one turbine, when it was not operating, Homestake could divert water. Under the SHOP agreement, we agreed to pretend that the senior right was being called and would not divert. However, we would not pretend the call was on if our storage was below a very serious level and if the forecast for future water supplies was below a serious level. These conditions these were a drought protection clause, which enabled us to agree, as Denver did, to provide more water to the system when we otherwise would not have been required to do so. Under what the River District calls in-stream flow permanency, the idea is the same. When the power plant is not operating, the in-stream flow right would be on. And Aurora agreed to that permanency of the senior right with 3 conditions. These conditions are that the River District was seeking to achieve permanent protection of the flow regime created by the operation of the Shoshone Power Plant. In other words, the historic flow regime. Second, that the principles in Denver and Excel's 07 call reduction agreement would be continued and would be included in the operation of the permanent in-stream flow right. And third, if there was a threat of curtailment under the Colorado River, there would be a process that would include the board, all the water users, and the district to operate the river in a way that balanced all of the needs to ensure the best outcome from a statewide point of view. And when I say all of the water users, I include the representatives for the environment, because the environment is a very important water user in this, particularly in this context. Conditions 2 and 3 are drought protection clauses. However, we are here today because the current in-stream flow agreement, as the board noted yesterday, does not include those provisions. And we were very pleased to hear the River District affirmatively commit that all of those conditions will be included and honored. We agree with the request of the directors that the in-stream flow agreement explicitly include the appropriate process and explicit language to enable us to get to the proper resolution. We can be pretty sure that there are going to be hard times in the future. We want the historic flow regime protected, and it is vitally important for the state to be able to make sure that during those difficult times, there is not one winner and some losers, or some losers and some winners, but that we all, including the environmental representatives, work together to share the most critical resource on the planet. Before I hand this back to Josh, I want to note that Aurora had asked previously the board to direct their staff to remain neutral in the water court case on the issue of determining historic use and stream flow regime. We ask this because we understand that the weight granted to state agencies in court cases can be significant, but also because if the staff working on this were from the in-stream flow team, they might support maximizing the in-stream flow, which in many in-stream flow cases would be entirely appropriate, but not this one. In this case, we need to balance. If the in-stream flow right is maximized, it will injure upstream users. If it is minimized, it will injure downstream users. We have to figure out how to protect the regime as it has existed. So our thinking has evolved, and we would now request that you direct staff to work to assist all of the parties in objectively defining that historic flow regime. This would put the state in the position of helping all the water users and the River District to achieve what everyone has said they want and are looking for, which is the protection of the flow regime historically created by the Shoshone Power Plant. With that, I will turn it back to Josh and will be available for any questions afterwards.
Hello again. Could I just get a quick time check? Left? Oh, okay. All righty. Again, for the record, my name is Josh Mann. I will spend the rest of the time here today addressing the delegation of authority issue that we've been talking about so much, a little bit more in depth and in a way that is hopefully helpful. The question before you really is threefold. One, is the River District's proposed reduction of the board's discretion actually limited as required by Rule 10? Is the proposed delegation of enforcement authority to the district actually limited as required by Rule 10? And even if you answered those two questions in the affirmative, is it appropriate and reasonable for the board to cede such blanket authority given the magnitude of the rights and the statewide concerns? To help answer these questions, let me advance the slide. To help answer these questions and explore other co-management options, let us compare the River District's proposed in-stream flow agreement to the 6 agreements that it included as exhibits in its pre-hearing statement. So we'll start with the River District's agreement. As shown in this slide, you can see that their proposal requires the board to limit its discretion to call both the senior and junior rights at 1,408 cubic feet per second for in-stream flow purposes at all times unless the River District provides its written consent. Now, we've heard that the River District characterizes this as co-management and bristles at the suggestion that it gives them veto power, as was suggested yesterday. But in truth, the currently drafted language does just that. It gives the River District override authority in the extremely limited circumstances when you may determine another course of action is more appropriate. This framework, as we heard from Davis Wirt so eloquently, undermines your statutory mandate under 3792-102 to consider whether the proposed acquisition is quote unquote appropriate and quote unquote to preserve or improve the natural environment to a reasonable degree. Inherent in those requirements is the obligation to consider trade-offs between environmental benefits and impacts to existing users. If approved as currently proposed, the terms would strip the board of its discretion and permanently elevate the River District to a gatekeeping role impacting millions of water users across Colorado. So to focus in a little bit more on Rule 10, which provides guidance for how the board can limit its discretion and delegate enforcement authority. While the rule does authorize some delegation authority, it does not support a total cessation of your exclusive authority to hold and administer in-stream flow. The relevant language in Rule 10 concerns limits of board discretion and/or limited delegations of enforcement authority. I'm going to actually read the rule. 1, the board may enter into enforcement agreements that limit the board's discretion in the protection, approval of inundation, modification, or disposal of an in-stream flow right, and/or 2, may delegate limited authority to act on the board's behalf. So let's look at a few examples of valid exercises of Rule 10 delegations where the board entered into co-management agreements with water right owners. So this is a table that includes the 6 in-stream flow agreements provided by the River District, as well as the River District's proposal in red. We think it's helpful to sort of put in context what the River District is proposing. None of these 6 agreements required the board to sustain a call of the proposed magnitude or to fully cede its discretion to another party. The table highlights in yellow the 2 instances where the board limited its discretion, and then in red is the River District's proposal. So as shown in the middle column that says annual acre feet and flow rate, you can see that the 6 agreements invariably concern water quantities and flow rates that are de minimis compared to the Shoshone water rights. They are measured in single digits of CFS or 1 to 2,000 acre feet of water compared to the approximately 850,000 acre feet and 1,408 cubic feet per second. And we did hear that, there's likely to be a haircut of these rights through the water court process. But even with that haircut, the Shoshone water rights dwarf all of these previous acquisitions. And then I'll also note in the City of Boulder agreement, the city obtained they had changed the water right from ag to municipal use in the year prior to the in-stream flow agreement. And so the terms and conditions were established to prevent expansion and injury. As discussed yesterday, if the River District insists on its proposed co-management framework, perhaps it should obtain a change decree through water court, which would provide us, again, those definite terms and conditions to prevent expansion and injury. So in the 2 instances here highlighted in yellow, which I'll get into a little bit more detail momentarily, where the board exercised its Rule 10 abilities and entered into co-management agreements, the terms were in fact limited, as neither imposed a perpetual obligation to call for the administration of a right anywhere near the seniority or magnitude of the Shoshone rights, and neither included a permanent limitation of board discretion or delegation of authority. Okay, so we'll start to dig in a little bit deeper with the City of Boulder Agreement, where the board determined that the natural environment in the Boulder Creek could be preserved to a reasonable degree with a flow of 15 CFS. And so you can see here in paragraph 11, the board authorized the City of Boulder to be its agent for administration and monitoring. And so if the flow of the Boulder Creek fell below 15 CFS at any time, Boulder could make the call on the board's behalf. However, the board this was not a permanent cessation of board authority, because as you can see in paragraph 16, upon 30 days of written notice, the board may in its sole discretion revoke this authorization. There was some discussion about this yesterday about, well, what would revocation mean? Would that mean that the in-stream flow agreement terminated? No, it would not. What that would mean is that the CWCB would have then the responsibility of administration and monitoring of that right. And again, as I mentioned, the subject rights were originally, they were decreed in 1882, but they were changed to municipal use in 89, the year prior to this agreement being entered. So this here is an example of a valid limitation of discretion pursuant to Rule 10. The delegation was narrow in scope, 15 CFS. It was applied to a recently decreed water right, so there was no risk of expansion through the delegation. And most importantly, the board kept a backstop of control, its ability to revoke the delegation. Now, this contrasts sharply with the current proposed co-management in the in-stream flow agreement. In the agreement, the River District seeks not a revocable narrow delegation, but a perpetual mandate obligating the board to enforce the 1,408 CFS at all time when the plant is offline. And there is no mechanism under the current proposal for the board to withdraw or adjust its position without the River District's written consent. We'll now turn to the Colorado Water Trust in-stream flow agreement. This was cited yesterday by the River District. It was also the subject of a letter by the Colorado Water Trust that was also included as an exhibit in your materials. In its letter, the trust writes that it has completed 27 in-stream flow agreements across the state over a period of 24 years, and that this 2015 agreement is the best example of your exercise of Rule 10 abilities. I will note, as I was sitting here, I just saw that the water report has a whole expose on the Water Trust and why that is the way to go for the future across the West. So this is an important endorsement from the Water Trust, considering the length and the breadth of the trust's experience with in-stream flow agreements. So let's examine some of the terms of that agreement. So in the agreement, the trust conveyed 5.8 CFS to the board to improve the natural environment of the Little Cimarron and Cimarron rivers. An interesting component of this is that it allows for the split use of ag versus in-stream flow, depending on certain conditions. And in some instances, it could be used for ag the full season. Some instances, it could be in-stream flow the full season. If there's any disagreement, and I think this is also important, the parties would go to mediation to negotiate a compromise. Here, the board, the co-management agreement included a delegation of administration and monitoring authority. So if the stream flow falls below the decreed in-stream flow amount, then the trust will notify the staff of the board. And here's the key language: upon consultation with the trust and the Division of Water Resources, the staff of the board shall place a call for administration of water rights if appropriate. And so we've heard a lot about the river districts having concern that under some future leadership, the board might not place a call. We understand this. That's a valid concern given the value of the right. And this in-stream flow agreement with the trust addresses that very concern with a built-in safeguard, ensuring that the board exercise the in-stream flow right consistent with the parties' agreement. And so there's a paragraph, and had I read it by the time I put together this PowerPoint, I would have included it. But I'm going to read it to you now verbatim, so please bear with me. This is the injury and mitigation clause. If the board and the trust successfully obtain a decree in the change case, the board commits to use the water rights as changed for in-stream flow purposes to preserve and or improve the natural environment to a reasonable degree consistent with the terms of the decree and this grant, and to take all reasonable steps to enforce those rights for in-stream flow purposes and protect them from injury. If the board receives a request to consider injury with mitigation for the portion of the Little Cimarron or Cimarron River benefited by the change of the water rights, the board shall promptly inform the trust of such request, consult with the trust regarding such request, and not take any action that in the trust's reasonable judgment would impair the benefits to the Little Cimarron or Cimarron Rivers resulting from the trust grant to the board of the water rights and their change to add in-stream flow uses. So given that this is the Colorado Water Trust's best example of how you exercise your Rule 10 authority, perhaps this is the type of a co-management agreement that could be workable in this instance. So in conclusion, Aurora requests, and Alex explained it very eloquently, that the board directs staff to work with the parties towards a workable co-management proposal and a framework that preserves the historic flow regime. Aurora remains committed to working collaboratively with all parties and hopes that we might even reach a stipulated decree without the need for a contested water court hearing. In closing, we share this image here, in contrast to the previous one, as a symbol of balance and a win for Colorado, the win that we all seek. An acquisition where the board's exclusive authority is preserved, the historical flow regime is maintained, and the environment is permanently protected without injury to existing water users. Thank you for your time and attention. We welcome any questions.
I did want to note for the board, thank you very much, Aurora, that if the Aurora's time is further deducted based on additional testimony from Ms. Whitman, they will still be available for questions on rebuttal. So just because they may not have rebuttal time, you can still ask them questions in the order that was presented on rebuttal. So I just wanted to make that clarification to the board. Given that we only have 5 minutes before lunch, I think we will have questions for you all following the lunch hour, if that's okay.
Absolutely.
Wonderful. I also,
Thank you so much.
no problem. I also want to flag, oh, Director Felt has a question before I continue. Go ahead. No, please.
I don't want anyone to read too much into this question, but I think it's just an objective question that other people on the board may have as well. But I was looking at the schedule and I see that Aurora had 45 minutes, Colorado Springs Utilities has 45 minutes, and then Homestake has 45 minutes. Can you explain that?
Sure, yeah, no, so this was based on the parties' requests. They had said either they present all together for, I think it was 4 hours, or that if they were not going to present together, they were going to ask for an hour each. In my discretion and looking at the time requested, I had to cut time for each party to fit within the allotted hearing time. So they each received 45 minutes based on their request, and also in response to having an equitable divide of East Slope, Front Range, interests and the River District Coalition trying to have some level of equitable time between those interests for presentation.
I guess what I'm getting at is, I may be incorrect. I view Homestake as a joint effort of Colorado Springs and Aurora.
Understood, they were given a separate party status, though.
Okay, thank you.
Thank you. I completely hear you. My last note before we jump to lunch is that we are likely going to have an executive session request directly following lunch. So I just want to make the parties and the board aware of that. And some of that will be due to the scheduling available of the federal interstate team of attorneys that may need to be present based on the questions received.
And Jackie, just to clarify, would that be before or after the questions for Aurora?
It will be before. just based on scheduling
Before,
time.
okay.
Yes, so please hold your
So
questions.
do you like a motion to go into executive session now?
We can do that now. Or we can do it coming back from lunch. So if I may, Director Vasquez is raising her hand.
Yeah, do we want to have a working lunch and do our executive session over lunch?
They are not available until 12:50, Director Vasquez, so I think we may want to wait and still have a lunch.
Okay,
Yeah.
thanks.
I would suggest that we go ahead and make a motion for executive session and go into executive session. That way, when we come back from lunch, that's taken care of and we can, and everybody can go ahead and exit during the lunch time.
Because we can wait for lunch a little bit.
Understood. No, let's still have lunch. Director Cloud, I sent you, to start, we will address one question in particular at this executive session. I have a list of others that I've received. We can go into executive session on the other questions if needed like later in the process, as I discussed before rebuttal. But this is just because this particular question requires attorneys from the Federal Interstate Water Unit. And this is their time that they are available.
Okay, well, I'll go ahead and make, request the motion from the board to go into executive session and then I'll go into our narrative for the record. So is there a motion to enter executive session?
So moved.
Thank you, Director Vasquez. Is there a second? Thank you, Director Hawes. All those, is there any discussion? No discussion.
Before the vote, if I may, just for the sake of the record, my name is Jackie Colicchio. I'm an Assistant Attorney General for the Colorado Water Conservation Board for the Shoshone matter. Executive session is required for the commission to receive legal advice related to specific topics. For discussion of these matters, executive session is authorized pursuant to Colorado Revised Statute 246402 3A2. I want to note, and I just want for the record, excuse me, I have it written down here, the topic that we are going into executive session for. The board will enter executive session directly following the lunch, should they all vote on this motion and seconded motion, to receive legal advice on questions related to interpreting potential impacts to the Colorado River Compact and the state of Colorado's legal obligation under the compact. This request arises from Director Combs's questions yesterday to the River District related to their assertion that the acquisition will maintain the existing flow regimes and also not impact the compact. I want to also note for the record, this is solely based on this topic. No decisions will be made in this executive session, and this executive session will only be to resolve the legal underpinnings of Director Combs's questions. No policy or factual discussion will occur. Thank you so much. Please go to the vote.
Okay. So all those in favor say aye. Those opposed? Okay, the board will now go into executive session at 12 PM. And this session is for the legal advice on questions related to interpreting the potential impacts of the Colorado River Compact and the state of Colorado's legal obligation under the compact. This request arises from Director Combs' question yesterday on the to the River District related to their assertion that the acquisition will maintain the existing flow regimes and not impact the compacts.
Thank you. I think we're set.
Thank
Appreciate
you.
that.
The board members get lunch first before everybody else so that
Go for it.
Recording in progress.
Thank you for allowing us to go into executive session. We are now back. I'm gonna go ahead and turn this over to the hearing officer.
Thank you. No, for purposes of the record, the only matter discussed during executive session were the legal questions presented to the public. No decisions have been made. Thank you so much.
Okay, and so now our next is questions?
Yes,
Correct?
questions for Aurora.
All right, so are there any questions for Aurora? Director McLeod?
I have questions for both of you, but I want to start with Mr. Allen. Your discussion about the delegation of authority under Rule 10. So Rule 10 clearly gives us the authority to delegate our authority to another party. Am I right? The second sentence of it makes it really clear that we're allowed to do that if we choose to do so. My question to you is, and I looked at all of those examples that you put up there. I read them all very carefully. I was involved in that McKinley Ditch case, so I knew that one intimately. They're all different, and we established that yesterday, I think. But my question to you is, just because we've done it differently before, does that dictate what we can do now?
Well, that's an excellent question. I think that the rule clearly talks about, uses the word limited, as I said. And so I think as long as you are acting within the framework of a limited grant or delegation of authority, or a limited, a limitation on your own discretion, and it's, just limited, that's the key. I think if you were to do what is being proposed, that is not consistent with Rule 10. And we have all those agreements that where Rule 10 has been exercised. And so I would, yesterday, I think you said it was clearly unprecedented that this
Yes.
hasn't been done before.
Absolutely.
So I think, there's the legal question and then there's the policy question. And so, one, I think it's questionable legally whether you could do that under Rule 10. And then even if it was, is it, and I think you asked this question yesterday too, is that the right thing to do or the wrong thing to do? And in this instance, you would be setting precedent that would be, forever. The grant would be forever, and the precedent would be established for the future. And so that's a consideration for the board to weigh is, do you want to be establishing that precedent?
Well, but the rule says we can enter into agreements that limit our discretion. It's not a limited grant. It's a grant that limits our discretion. So we can do that under our
Correct.
own rules, right?
That's how I see it. Yes, sir.
And these previous agreements, although they're informative, they don't set any precedent for what we can do here. Isn't that right?
Yes, that's correct.
Now, you also said that the delegation creates a risk of expansion of the water right. And I don't understand how that would operate. I mean, the water right, the expansion of the water right is going to be an issue in the water court. And hopefully the water court will reach a decision that, I mean, maybe nobody will like it, but hopefully it will prevent expansion of the water right. That's one of the reasons you go to water court in a change case. So how does the delegation create any risk of expansion?
I guess I hear that distinction, and I don't think it is really a risk of expansion. It really goes down to the exercise of the right. And again, I think it really is more of a policy question, and it doesn't go to expansion.
Well, I'm not agreeing, not arguing what we should or shouldn't do. I just want to make it clear that, as I asked our staff yesterday, are we acting within our legal authority? That's my concern. I think we are, or we will. I have a question for Alex, if that's okay. So Alex, you said you disagreed respectfully with the Attorney General's position that we talked about yesterday. The staff gave it to us, that acquisition is different from appropriation. Say that's not the way you interpret the statute. What the statute says, though, We have the exclusive authority to appropriate water rights for in-stream flows, but we can also acquire them, and that we can attach whatever conditions we want to the acquisition. So isn't that different?
And I believe I did note that there are differences in how those two sources of water for in-stream flows are handled. So yes, absolutely. My disagreement was the idea, as I understood what was said by staff and the Attorney General's office yesterday, they were asserting that the donee of the water right legitimately kept control of the right to call for an in-stream flow. And this discretion question really circles around who has the right to call the in-stream flow water right. I think the statute does address the sources of water for in-stream flows differently. An appropriation is where this is a different source of water than a donation or a lease agreement. And so there's different pieces that go with either of those. But as I look at the entire statutory scheme around what the state did, what the state legislature did when they enabled an entity and one entity to acquire and manage in-stream flows. So this is that particular use of the water right. They vested that solely with the Water Conservation Board. Now, what Josh was talking about in Rule 10, that's enforcement of the right. And there have been, enforcement. I guess this might be where it's a little gray and where legal minds, great legal minds, Jen, differ, is where does enforcement fall in terms of operating an in-stream flow? If the CWCB is that authority, the only authority in the state that can, and I don't want to use it, and I'll say it this way because this is how I'm thinking of it, own in-stream flow rights. So in this context, the River District and in other contexts, other donors have kept the water right, but what they have donated the water to be used for the in-stream flow purpose. And it's that in-stream flow purpose that this board has exclusive jurisdiction over. And that's my understanding of the entire statutory scheme. Over the years since 1973, the legislature realized, well, it can't just be appropriations because then the in-stream flows are going to be forever junior. So how do we allow more water to be used for this purpose of protecting the environment? And because it was different water, there are different sort of considerations that are laid out in the statute. But I see the exclusive authority is over the in-stream flow use. And that's the distinction that I'm making. And I could be wrong. That's the way I read the statutory scheme.
Well, but an enforcement agreement would be include making a call on the water right. Isn't that enforcing the water right?
Yes. And
but we can make agreements that limit our discretion in calling the water right, in enforcing the water right. That's what Rule 10 says.
And what we are asserting is that that can be done, but it has to be done in a way that doesn't forever concede or give away your ultimate authority. So in all the other agreements, you have given away some of that ability, but the other agreements include your ability to take that authority back.
Well, some
to
of
make
them
a
do,
difference.
not all of them. Anyway, I just wanted to make sure that I understood what your argument was. I'm not trying to make you decide one way or the other, nor am I deciding one way or the other. I just want to clearly understand your argument.
And I would say, legally, clearly, we can read the statute differently. And so that it does go to the question of whether you can. And if we say, yes, okay, let's just assume that you can, that as the board, you have the ability to delegate this authority. Then the policy question, which is very clearly a policy question for this body, is whether you should delegate it in the form requested. And I think we have been very clear that that's what we're concerned about, is that entire delegation in perpetuity without flexibility. And that the board has, you have already addressed with your questions and your requests to the River District that they work to change that language to create a process and flexibility and more sense of there might be some times, which we agree will be very limited times, when the board may need to make a different decision about how that right is operated. So I do think that's a distinction. You could almost say, we can put aside the legal question and determine the policy question, would be one way to look at it.
Okay, one more question. You asked earlier that the board instructed staff to be neutral in the water court case. Can you tell me what neutrality involves?
Well, we spent a lot of time thinking about that. And we were initially, so as I said, our thinking around that whole idea has evolved. And there's been a lot of conversations. Initially, what we were thinking in terms of neutrality was the idea that, as you've heard, there's disagreement on methodology, there's disagreement on analysis. A core piece of this is, what does that historic flow regime look like? How are we going to maintain the historic flow regime to provide all the protections that people are asking for? And so initially we were concerned that if CWCB staff were to weigh in on that historic use question, it would essentially mean that the state was taking a position on that technical analysis. Now, as the River District said yesterday, and we totally agree, staff has great expertise in in-stream flow issues. And the in-stream flow staff, they know their job when it comes to in-stream flows, when it comes to biology, when it comes to protection of flows. This question of how does the Colorado River operate and what this historic flow regime, we weren't sure that they had the same expertise in that regard. And so if staff was going to participate, first we were thinking, well, we would like them to do their own independent analysis, have their own consultant, their own engineering support to come up with their determination of what does the historic flow regime look like. Maybe that would be too big of a lift. Maybe with everyone else kind of battling that out, we didn't need them to do that. Okay, if we don't need that, can they just stay neutral on that question? Recognizing that the state, of course, has a role in the change case. And then as these conversations evolved, listening to the testimony yesterday, thinking about like, what does neutrality mean? How would you possibly define that? We evolved to the idea of, no, it would actually be really great for staff, for whichever staff are going to be involved in the change case, to be directed by this board to look for that objective methodology to get us to where we all want to be, which is protecting the status quo. And then we get rid of the problem of the state weighing in on one side or the other, but the state maintains its very important role in this process. So neutrality was a very difficult concept, and we personally went in a lot of circles around what that might mean.
Director Vasquez?
Yeah, my question was very much like my colleague on the board, but you had made a statement that you were instructing us to instruct the staff in water court to remain neutral, and I still don't understand how you parse neutral versus objective. So if the staff is coming to their role in water court and trying to help, as Greg said yesterday, I think, help find the truth with their expertise, I don't see that as them putting their thumb on the scale for any party in that contest before water court. Am I misunderstanding?
I think you're right there, Director Vasquez. I would add, that expertise where. And so one of our concerns was that staff would seek the in-stream flow section, as is their job, would seek to maximize the in-stream flow right. And that's some of the language that was included in the initial in-stream flow agreement, I think. And so in our view, as I said earlier, it's not about maximizing or minimizing, it's finding that definition of status quo. So there are many in-stream flow cases where the idea of maximizing that right for the benefit of the environment is totally appropriate. But we did not want staff to come into this case with that charge. We thought it would be helpful for the board to say, if you agree, you may not agree, that what we are looking for here is a maintenance of the historic flow regime, and we direct staff to work towards that for all parties. Because the staff have been very involved in the in-stream flow part of this, this part in protecting the environment side and looking at those benefits. And I don't know, I just really don't know how deeply they've been engaged in understanding the Green Mountain Reservoir, Denver system, our system, and how those systems operate, how the Grand Valley operates. I don't know if they have been as deeply involved in those details, which will become quite important in fashioning that solution going forward.
Are there any other questions? Dr. Combs?
Thank you, Alex. My question is for Josh. Going back to when you brought up the in-stream flow agreement, the kind of contesting with Colorado Water Trust's interpretation of that as their best example. With what you have highlighted there, I guess I could use a little more clarification. It talks about upon consultation with the trust and the Division of Water Resources, the staff of the board shall place a call for administration of the water rights if appropriate. So in that scenario, you're saying that preserves the authority. But what is the language in your mind that would cede that authority? This allows consultation, it allows an evaluation of if appropriate. It still says the board makes the call to place that in-stream flow into. So I could use a little clarification on how you're saying that does not work cooperatively, or any variation from this would cede authority.
Okay, thank you, Director Combs. I think the Colorado Water Trust Agreement is a good example of a limited grant of delegation of enforcement authority because there's that appropriate language at the end. So the board retains the discretion to make that determination, ultimate determination of whether or not it's appropriate. So if the Water Trust makes the request for the call, the board could take into consideration other factors. I'm contrasting that with the proposed in-stream flow agreement where the final decision is not left with the board. The final decision is left with the River District. The River District has the veto call. So let's say right now it's call for the maximum amount up to 1408 or whatever is decreed. And if the board wants to do something different, it can't unless it obtains the written consent of the River District. So that's a big difference because in the one instance, you get to make the call as, pursuant to your statutory authority, whether it's exclusive, or something else. Appropriateness and reasonableness, that is your charge by the General Assembly. And by granting that away, that's inconsistent, I would say, with what the General Assembly had granted to you. The River District does not have the obligation for reasonableness or appropriateness as you do.
Okay, are there any more questions? Oh, Dr. Hamlin?
I don't know much, if this is much of a question or just maybe a statement, but Alex, maybe you can answer this for me, and thanks for being here. So I've been getting this, and I kind of got it a little bit yesterday too, but from what I understand, you guys are asking us not to give this to the Colorado River District. But then you turn around and say, you know, stay out of the court also. And so, I'm not sure, I guess where I'm getting at is I'm not sure if you take the Colorado River District out of the equation and give it to CWCB staff, we're gonna probably do the same analysis. It might be a little different. All they're gonna do is manipulate a few dates and where it was measured and come up with a third different number. So, I guess where I'm going on this is from what I see, the CWCB staff aligned with Colorado River District fairly well yesterday. And so I'm getting what you guys are asking is drop the Colorado River District, but then get out of your way when it comes to the measurement rules. Am I getting that right?
Respectfully, Director Camlin, I would disagree. But I think that you're harping on some really good points, though, and I appreciate the opportunity to clarify. So we are not asking to move the River District out by any means. And in fact, one of the River District's concerns that I heard loud and clear is they are making a huge investment in acquiring this right, and they want to make sure that this right is used for these purposes. They want to make sure that this in-stream flow works as we've all discussed, which is to protect the historic flow regime of the Shoshone power plant. And our position is in no way asking that they not get some certainty around that. We think certainty for the River District is clearly very important and is important to them. As you said, yesterday, the staff and the River District were very aligned in some aspects. And one of those aspects, it appears to be, and so, you know, I don't know all that staff has been engaged in terms of this, is what does that historic flow regime look like? So in court or in negotiations, because if possible, it would be great to get to a negotiated consent decree before we even get to court. Initially, and this might be where your confusion comes from, initially we had said, please have staff be neutral on this question of the historic consumptive, or the historic use and the historic flow regime. And that was kind of our initial idea of how do we best fashion, if there has to be a fight in water court, how does that fight look the most equitable, if you will? As I said, our thinking has evolved on that point, and it's very clear that CWCB staff have to have a role and have to be involved in this. So again, how do you make that most equitable so that none of the parties are advantaged or disadvantaged by what the state does? And that was where I started this thinking, was how do we take this, if we have to fight about it, if we cannot reach negotiated solution, which I'm hoping we can, how do we prevent the state, whose obligation is not just to the Colorado River, but it's to the South Platte, it's to the Arkansas. The people on this board, you have a duty to wear a statewide hat, and to not, in a case of this magnitude and this importance, take a position that would advantage or disadvantage any of the parties. I really believe that everyone is here in good faith. Everyone is here because they're really concerned about what the future looks like. And I also believe that we can reach a negotiated settlement, at least I'm hopeful. If we can't, yes, we will go to water court, as everyone has discussed. But the role of the Water Conservation Board in this critical change, right? This in-stream flow will affect millions of people. And so we think it's very important that how you set up your role, how you understand your role, is with that statewide hat, seeking to find the statewide solution that does not make it better for one basin at the expense of another basin. And that is kind of a tough path to weave. So that's how we've gotten to this idea of staff's role being in that place of, we are charged with objectively helping all of the parties to figure out what the flow regime looked like. Does that answer your question, sir?
Yeah, it does. And you answered it well. I appreciate that. Thank you.
And I'd just like to add one thing, if I may. I think the setup of going into this hearing is relevant to this discussion because the CWCB the staff has taken the position, and we've been kind of really wondering about this. What does the rule require? Consideration of appropriateness of potential injury and things like that. And what we are reading into what the staff has provided in their pre-hearing statement and rebuttal is that that's really not what needs to happen right now. And so we don't know really where the staff is with regard to what we are really perceiving and very concerned about, this sort of expansive approach to the historic analysis that we've seen with the River District. So that's why we're wanting to make sure that that the board doesn't approve, like, all right, well, we're just going to go with what the River District has done. So there's some uncertainty and something that's unknown about where the staff is on this. And so I'll end with that. Thank you.
Okay, Director Haas.
Yeah, thank you for this. And I'm building on this same theme of, I think I heard you say, Alex, that one way of being objective would be for staff to help identify a methodology for how we get to the historic use. I just want to A, clarify that, and then B, I mean, another option would be helping to broker a deal, which is maybe different staff than just the in-stream flow section. So I just am trying to parse out these different options you're mentioning.
And I appreciate that, Director Hawes. I'm not sure that I had really thought in my own mind what all the different options are. Both of those are great options. There's clearly a difference in terms of methodology. And I see the state as uniquely qualified to broker a deal. And that is, you guys saying we want a statewide solution that works. Staff, go help make that happen. Makes sense to me as well. So both of those options make a lot of sense.
If I might. Okay, so on the methodology piece, would that be what you're talking about, the staff that are presenting here today or yesterday, would that be focused on the in-stream flow or historic use or both in your mind?
And that's a great question because I think that's where some of the confusion comes in. I think clearly staff has great expertise. I mean, I got to work for years with Jay Skinner, and he knows his stuff when it comes to in-stream flows, when it comes to bugs and bunnies and biota and microbes and all of those things and fish. That's where their expertise is unparalleled. No one else does that in the state on a regular basis like staff does. I think where I would be less confident that the in-stream flow section has the expertise is exactly on that kind of historic use analysis. What is the proper engineering methodology? What are the, we had Heather demonstrate what we saw as some of the flaws in the River District's proposed methodology. Clearly, as everyone's been to water court, and I think someone mentioned, I think it was Director Coombs said, no experts ever agree, right? So you can always, that piece might be more difficult for the in-stream flow staff to step into because I don't think it's a space that they spend a lot of time in. I could be totally wrong on that. Other staff might it might fit them really well, or it might be, we're just gonna push everyone to figure out a methodology with us participating in that. I think there's a couple of different options there.
Director Felt?
You both raised concerns about precedent, and you're not alone. Other people have too in the last couple days, and that's an issue that interests me, maybe even triggers me actually, as having just spent 8 years as a county commissioner and being constantly told I was breaking with precedent or I was setting bad precedent. And then in the few short months I've been gone, they've reversed many of my precedents, so I don't even know what it means anymore. And but I guess I'm wondering about it in this instance. I mean, it seems like probably one thing everybody in the room would agree upon is the unprecedented nature of this opportunity. And it strikes me that almost by definition, then the answer to the question or the solution to the problem at hand is unprecedented as well. And I recognize there's a difference between unprecedented and non-precedential, but I would assert that we in our decision record could designate this, our decision, as non-precedential. Just say it. And I'm curious what you think about that.
Well, first I'd say, did you get a law degree recently? But second, there's no question, there are numerous water court decrees out there that have non-precedent language that say this decree and the terms and conditions are non-precedential and forever shall be left that way. So that is definitely an option to use here. I like your distinction between unprecedented and non-precedential. And I do think this is charting new waters, to use, I believe Director Riss said that early on, that we were all in somewhat new waters. And to some degree, this is not going to happen again. Right? There are not a lot of Shoshone power plant rights out there on major rivers that have this kind of impact. So, you know, it's to some degree, this is, I mean, it's definitely unprecedented, and I'm not sure that in my lifetime, we're going to run into another situation that would be along these lines.
Can I add to that? Thank you, Director Fell, for that question. I just talk a little bit about the past precedent that I showed on the slides earlier. So past precedent, and I think this goes a little bit to Director McLeod's question. You know, we've seen that it was low quantities, and there is no precedent where the board ceded its final authority to make the determination. And so in an instance where you have the controlling right on the largest river in the state that affects millions of people, why, you know, as you're weighing this serious decision, and yes, it is a once in a generation opportunity, but getting it right is really important. And so the potential for moving past what you've done in the previously to grant or cede that final determinative authority in this instance, with the potential consequences, you know, I think that is something worthy of concern. And I think, you know, the fact that it hasn't been done before really does go to the legal question of, can it be done? It's not been tested. So that's also something to consider.
Any more questions? Hearing none. Thank you.
Thank you.
Thank you.
I believe Colorado Springs Utilities are next. And just wanted to note, if I stand up, it's not because I don't think you're important. I'm just 6.5 months pregnant and gotta get out of this chair.
Good afternoon, Madam Chair, members of the board. Thank you for your time today. My name is Tyler Benton. I'm a senior water resource engineer at Colorado Springs Utilities. I have a degree in geological engineering from the Colorado School of Mines and am a registered professional engineer in Colorado. Among other duties, my work focuses on water supply planning in the Colorado River Basin. I provide technical support working to develop hydrological models that represent Colorado Springs Utilities water collection systems. These models simulate operations considering downstream senior culling rights, including Cameo, Shoshone, Green Mountain Reservoir, and other flow requirements. These analyses help Colorado Springs Utilities to better understand changes in stream flow and develop estimates for physical and legal water availability. I plan to share with the board specifics about how Colorado Springs utilities can be affected by the proposed terms of the acquisition of the Shoshone water rights for in-stream flow use. First and foremost, I would like to state that by participating in today's hearing, Colorado Springs Utilities is seeking to protect and preserve the yield of existing water rights currently allowed under administration of the prior appropriation system. Colorado Springs Utilities is not looking to gain additional water by the conversion of the Shoshone water rights for use as an in-stream flow. Quite simply, Colorado Springs Utilities cannot afford to lose existing water supplies as our city continues to grow. By way of background, I would like to describe Colorado Springs Utilities' water system at a high level. Colorado Springs Utilities has developed a robust conservation program that educates its customers on smart water use, including implementing water-wise rules that limit outdoor irrigation and fully utilize available supplies that can be used to extinction. In fact, Colorado Springs Utilities customers use roughly the same amount of water today as they did in the mid-1980s, even though the population has nearly doubled. Unlike many large cities in our state, Colorado Springs is not located on or near a major river. As a result, Colorado Springs Utilities relies on relatively junior water rights in 3 river basins and has developed storage and conveyance infrastructure to best utilize those water supplies. Let's see here. There we go. This complex network is shown in the map shown on the screen. This zoomed in portion of the state, you'll note Interstate 70 at the northern boundary at the top of the map. You'll see I-25 running along the right edge. Colorado Springs is located where you see kind of these red house looking features. And you'll see the South Platte River start in South Park near the center of the map, head south, and then veer north towards Denver, and the Arkansas River, the other dark blue line starting near Leadville, veering south, and then east to Pueblo. The large or the dark red lines and the dark green line, those represent the major conveyance pipelines utilities uses to bring raw water to the city, including the Blue River Pipeline, Homestake Pipeline, coming from the South Platte and the Arkansas respectively, and then coming from the Arkansas and Pueblo Reservoir, you'll see the South Platte delivery system, I'm sorry, the Southern Delivery System and Fountain Valley Authority Pipeline. Including reuse, approximately 70% of Colorado Springs water supply is derived from the Colorado Basin. Of the 4 Trans Mountain supplies, which Colorado Springs Utilities receives water, 2 of those systems are located upstream of the Shoshone Hydroelectric Power Plant. Those are the Continental Hoosier System and the Homestake Project, which Utilities owns 50-50 with the city of Aurora. Diversions from these 2 collection systems have the potential to be injured by the Colorado River District's proposed expanded use of Shoshone water rights for in-stream flow purposes. In combination, water supply from the Continental Hoosier System and Homestake Project are used to meet approximately 37% of Colorado Springs Utilities' potable water demand. I'll now describe the Continental Hoosier System in more detail. Colorado Springs Utilities owns and operates the Continental Hoosier System, which I'll refer to as the CHS. The CHS is made of direct flow and storage water rights with 1929 and 1948 priority dates. This system diverts water from the headwaters of the Blue River, which are then conveyed through the Hoosier Tunnel to Montgomery Reservoir, located in the headwaters of the South Platte River Basin. The water is delivered by gravity to Colorado Springs metropolitan area via the 70-mile Blue River Pipeline. The water derived from the CHS Blue River water rights is an important part of utilities' water supply and is used to meet about 12% of treated water demand, considering first use and reuse. These water rights divert in priority or by substitution to Green Mountain Reservoir. Under administration of the prior appropriation system, Colorado Springs Utilities is required to curtail diversions under the CHS water rights whenever a senior downstream water right is not satisfied and places a valid call. The 1948 priority CHS water rights are subject to curtailment from a call by both the senior and junior Shoshone water rights, while the 1929 priority CHS water rights are subject to curtailment from the senior Shoshone water rights. I'll now bring Heather Thompson up, who will now share her modeling efforts that quantify the specific yield impacts to the CHS.
I'm sorry I'm back, but I promise this time I'll be a lot more brief on the modeling. I just wanted to touch briefly on the modeling work that I described earlier. I used the CDSS daily model to compare two different scenarios. Again, reminder, the historical level scenario was one in which I set the demand as shown to historical diversions. Again, the purpose of that was to simulate diversions at Shoshone that were reflective of historical diversions. And then I set another scenario to what I called the BBA volumetric scenario, where I set the demand at Shoshone to the BBA volumetric volume distributed over the year, which is effectively 845,000 acre feet per year. The model results, when I compare those two scenarios, showed that Shoshone calls and diversions increase under the BBA volumetric scenario, and that impacts the continental user system. Next slide. The model results, when I compared them, showed the following impacts on the CHS if Shoshone calls and diversions increase. The CHS water rights are out of priority more often, and they're curtailed more often, therefore. Diversions to storage in Upper Blue Reservoir and directly through the Con-Hoosier Tunnel also decrease when those water rights are out of priority. Under the BBA volumetric scenario, Con-Hoosier Tunnel deliveries decreased by a maximum of 870 acre feet in 1 year. Now I'd like to turn it over to counsel for Colorado Springs Utility, Michael Gustafson.
I'll come. Sorry. Thank you, Heather. Any reduction in yield from the CHS negatively impacts the ability for Colorado Springs Utilities to meet its customer water demands. Not only will the proposed expansion of the Shoshone stream flow injure current water supplies as described by Heather, but future yield of CHS water rights will also be injured. Specifically, Colorado Springs Utilities is currently in pre-permitting for the enlargement of Montgomery Reservoir. The Montgomery Reservoir enlargement project is critical to Colorado Springs Utilities' future. This project is important to provide both resiliency within our water system as well as to provide additional supply to meet future customer water demands. The additional supply from the CHS occurs in years when the historical record shows water is available for diversion while honoring our commitments under the Shoshone Outage Protocol or SHOP. However, due to current infrastructure limitations, this water cannot be diverted. An expansion of use of the Shoshone in-stream flow water rights will impair Colorado Springs Utilities' ability to utilize CHS water rights in a greater amount than what Heather Thompson previously detailed. This reduction in yield would materially impair Colorado Springs Utilities' vested water rights and the ability to manage its water system to meet the needs of its 500,000 customers. I'll now hand the presentation over to City of Colorado Springs Attorney, Mr. Michael Gustafson.
Thank you, Tyler and Heather. Good afternoon, Chairwoman Cloud and members of the board. My name is Michael Gustafson, and I'm a senior attorney with the Colorado Springs City Attorney's Office, and in that role, I am in-house water counsel to Colorado Springs Utilities. I appreciate the opportunity to speak with you today about this important matter. I want to start by reiterating that Colorado Springs Utilities is not opposed to the CWCB's acquisition of an interest in and change of the Shoshone water rights for in-stream flow purposes. However,
We do urge the CWCB and the River District to do so in a manner that does not cede the CWCB's discretion to the River District and is consistent with the commitments Colorado Springs and the River District made to each other in 2024 related to the Shoshone water rights. Specifically, in 2024, Colorado Springs Utilities, the River District, and several other West Slope entities entered into a memorandum of agreement that, among other matters, gave Colorado Springs Utilities the certainty it needed to support the River District's efforts to protect the historical stream flow conditions that resulted from the exercise of the senior Shoshone water right. As relevant to this proceeding, the MOA addresses protection of that flow regime through an agreement by utilities not to oppose the change of the senior water right in exchange for the ability to request call relaxation provisions similar to those in the 2007 call reduction agreement and the Colorado River Cooperative Agreement related to the senior water right, as well as drought exceptions that would allow utilities to operate its Continental Hoosier System and Homestake Project water rights in times of drought. Again, consistent with our commitments made in the Blue River MOA, Colorado Springs does not oppose the CWCB's acquisition and the CWCB and River District's judicial change of the senior Shoshone water right for ISF purposes to provide for permanency of the historic Shoshone call and maintenance of the historical Colorado River flow regime. Colorado Springs Utilities agrees that if managed appropriately, in-stream flow use of the senior Shoshone water rights will benefit both the environment and water users across the state. However, we have the following concerns with the acquisition as currently proposed. First, as you just heard from Mr. Benton, Utilities obtains about 37% of its potable water supply from the Continental Hoosier System and the Homestake Project, and that any reduction of yield under those projects water rights would have severe impacts on our ability to meet the water demands of our customers. Also, as you heard from Ms. Thompson, such reductions would likely occur more often if the River District's preliminary historical use analysis or an updated historic use analysis that relies on similar flawed methodologies that overstate actual historic divergence and understate the resulting impacts to upstream users were decreed in the water court. Like the other Front Range parties, we are not asking this board to come to a conclusion on the historical use or resolve the flaws in the River District's analysis as part of this process. Rather, we are asking the board and the CWCB staff not to endorse one party's historic use analysis over another, because by doing so, it effectively places the agency's weight behind one party to the disadvantage of other parties. Second, Colorado Springs Utilities has the same concerns as other Front Range parties about the provisions in the acquisition agreement that restrict the CWCB's discretion to determine when to place a call under the Shoshone water rights, which arguably encroaches on the CWCB's exclusive authority to hold and exercise in-stream flow rights, an authority that is particularly critical given the magnitude and potential effects of this proposed acquisition. The attorneys at Northern and Aurora have done an excellent job of explaining the legal and policy arguments for why the CWCB should not give up its discretion to operate the Shoshone water rights for in-stream uses as it seems fit. And I don't want to take up more of your important time rehashing those arguments. I do want to state that Colorado Springs Utilities strongly believes that the CWCB should not tie its hands on the administration of the Shoshone water rights and only approve an acquisition agreement under which it maintains that discretion to manage the rights for ISF uses in a manner that promotes protection of the natural environment while ensuring that water is available in times of drought or other water shortage to meet the needs of the citizens of the state, given an uncertain future. One way to do this is to direct CWCB staff to work with the River District and other interested parties, including the Front Range Water Council members before you today, over the next 2 months to develop a collaborative process under which the CWCB can make an informed and well-reasoned decision regarding when and how to reduce the Shoshone water rights call. That can be included in the acquisition agreement ultimately approved by the board. If such a process cannot be agreed upon, Colorado Springs requests that the board direct staff to amend paragraph 7, 8, and 9 of the acquisition agreement in the manner suggested by Denver Water. Third, while Colorado Springs Utilities has committed to support the CWCB's acquisition of an interest in the Shoshone rights and change of the senior ISF use, it strongly believes that given the uncertain hydrology of the Colorado River Basin and its customers' reliance on West Slope water supplies, it is important for the CWCB to understand the impacts of water shortage, drought, and/or compact curtailments would have on the vast majority of the state. We understand that the board does not want to be involved in resolving issues that arise from agreements between the River District and other parties, and we look forward to working with the River District to ensure that those commitments that we made in the Blue River MOA are upheld by both of the parties. Thanks again for your time.
Okay, so we can go ahead and ask questions.
Yes, please.
Okay, are there any questions? Oh, hearing none.
All right, I believe Homestake is next.
Madam Chair, CWC directors, CWC staff and guests, good afternoon. And thank you for allowing us to come and speak to you all today. I'm just to tell you how the Homestake process will go. I'm going to give you just a brief overview of our system. And then Heather is going to give you some impacts to our system. And then Tyler's going to convey some impacts to Colorado Springs. And then I will also give you some impacts to the city of Aurora.
Sir, can you give your name for the record for those online?
Yes.
Thank you.
My name is Rick Kienitz. I work for the city of Aurora, and I have for almost 20 years. I'm the basin manager for Aurora and manage both the Colorado River Basin and the Arkansas River Basin water rights in both of those basins. I and my team manage and administer all of Aurora's raw water supply in both of those basins. Just to interject here, I'd like to address just briefly a question from Director Phelps as best I can. And you may still have more questions about that. The Homestake project is a partnership that is separate from CSU and Aurora. It's an authority and it has representatives from both cities. In this project, Colorado Springs and Aurora are 99% of the time completely aligned. We're not necessarily completely aligned in every other project, but in this project we are, and that's a little bit of the difference between us and the city of Aurora and also the city of Colorado Springs. Today, we are here as Homestake Partners to discuss a matter of significant concern regarding the Homestake project. The Homestake project is a joint use project between the city of Aurora and the city of Colorado Springs that delivers water from the Homestake River to, I'm going to move this to this and give you the slide that has Shoshone on it and the dot arrow gauge as well. It delivers water from the Homestake River and its tributaries to the Eagle River, and then is also tributary to the Colorado River. It delivers water through the ownership of a network of channels, reservoirs, pump stations, and pipelines spanning over 180 miles to over 900,000 residents in both the city of Colorado Springs and the city of Aurora. The Homestake project was developed in partnership with Colorado Springs Utilities and Aurora in the 1950s and is split 50-50 between these two cities. It serves as a critical water source for both of these communities. The Homestake project has water rights appropriated in the 1950s, and it's junior to both Shoshone water rights. The Homestake water rights were developed and perfected on operations and administration of the Colorado River over the last 70 years. To give you a clear understanding of the potential impacts of the change of Shoshone water rights as it is proposed now on the Homestake project, specifically and its partners, I'll turn this over to Heather Thompson.
Thank you. I'd like to talk one last time about the modeling that I've been discussing previously. Again, it was a comparison of model results for the historical level scenario and the BBA volumetric level scenario. When I compared the model runs for those two scenarios, I saw the following impacts on the Homestake project if Shoshone calls and diversions increase. The the Homestake project water rights are called out of priority more often and they're curtailed more often. Diversions to Homestake Reservoir and through Homestake Tunnel would decrease, and drawdown at Homestake Reservoir would also decrease. Right, sorry. If the Homestake water rights are called out more often and less water is diverted to Homestake Reservoir, it's drawn down more to maintain deliveries through Homestake Tunnel. Under the BBA volumetric scenario, the maximum decrease the model results showed was about 7,000 acre feet. If Homestake Reservoir contents also decreased more than 500 acre feet in 168 months during the study period of 1988 through 2013, which is 54% of the model study period. When Homestake Reservoir project water rights are called out more frequently, deliveries through Homestake Tunnel consist of only releases through Homestake Reservoir. When Homestake Reservoir is drawn down completely, deliveries through the Homestake Tunnel are reduced. Under the BBA volumetric scenario, annual deliveries through Homestake Tunnel decrease by a maximum of 6,047 acre feet. I'd like to turn it back over to Tyler.
Thank you, Heather. I'd like to briefly describe the impacts of any reduction in Homestake water supply to Colorado Springs utilities. The Homestake project provides a vital water supply to meet the needs of our customers. This supply is used to provide approximately 21% of our potable water demands, considering first use and reuse. As previously demonstrated by Heather Thompson, an expansion of use of the Shoshone water rights would reduce the yield of Homestake project and would materially impair Colorado Springs' vested water rights and the ability to manage its water system to meet the needs of its 500,000 customers. I'll now hand it over to Rick Keenitz.
We're not going to get close to our 45 minutes. So as you heard and have heard, Aurora Water is a municipal enterprise providing drinking water to over 400,000 residents across the diverse city of Aurora, Colorado. Aurora's water supply is sourced from 3 major river basins, 50% and growing from the South Platte River Basin, 25% from the Arkansas, and 25% from the Colorado River Basin. Aurora's Colorado River supply is critical, with 70% of it provided by the Homestake project, this project. The analysis by Heather Thompson that you just heard highlights a serious concern under the BBA's volumetric scenario. A maximum annual decrease of almost 7,000 acre feet from the project is a reduction of about between 14 and 17%. A decrease exceeding 500 acre feet in 168 months of the study period. And then lastly, the Homestake tunnel deliveries from storage are projected to decrease by a maximum of over 6,000 acre feet. These reductions and injury to the Homestake project demonstrate significant negative impacts on the Homestake project and Aurora Water. Under this scenario, will cause Aurora to look to replace this diminished supply. Now, we understand that this scenario is preliminary, and we hope after the progress of yesterday that you will all After the progress of yesterday, it is our hope that you will direct your staff not to accept the methodology of the BBA volumetric scenarios, but will work with the River District and all other interests to find methodology that will truly seek to develop ways to avoid injury to all users and all water right holders, and to maintain and keep whole the regime of the river. Aurora is not seeking to expand our water supply from the Homestake project. However, we cannot absorb a reduction in our existing supply without significant consequences to our residents and to the reliability of our water system. While the impacts of the Homestake project may seem small compared to the overall flow of the Colorado River, they are vital to both Colorado Springs and to Aurora. Any negative alteration to the historical administration of the river and historical regime of the river will have serious impacts on Aurora and our partners. Thank you for your attention and for the opportunity to share these critical concerns. We trust that you will carefully consider the issues presented today, and we know that you will make responsible decisions that safeguard the water security of all Coloradoans. Thank you. We're here to answer questions if there are any, otherwise.
Questions of these
Okay.
witnesses?
Director Combs?
Yeah, my question's for Heather on the slide that's up. The 7,000 acre feet decrease,
Mhm.
and then I'm assuming the 6,000 acre feet decrease in the tunnel, it's the same, right? If it's not in the reservoir, it doesn't go through the tunnel?
Exactly.
Okay,
Yeah, when the reservoir is depleted, so if the water rights are curtailed, the only source of supply that can be delivered through the tunnel is a release from Homestake Reservoir. So that's when you see a tunnel, an impact on the delivery through the tunnel is when the reservoir is depleted entirely.
okay. And so then on that is from the 1988 to 2023 study period, the
Mm.
total of 6,000 acre feet is the decrease?
In 1 year, yes, yes.
Per year?
No, in 1 year. So it happens in 1 year when the reservoir is depleted, and it's not depleted under the scenario in which the demand was set at historical levels. So that's why we see a difference, is in one scenario, the reservoir is not depleted. In the other scenario, when the demand at Shoshone is increased, we do see the reservoir depleted. And in that 1 year, we see a 6,000 acre foot decrease in the tunnel delivery that year.
Okay, so just to clarify, 1988 to 2023, there's
To-
1 year.
Through 2013, I'm
Okay,
sorry.
so through 2013, there's 1 year that this scenario happened.
Yes.
Thank you.
Director Vasquez?
A comment first, and that is, for those of us not in the weeds, it's very helpful, in addition to the absolute acre foot reduction, that you show a percentage of historical delivery to give us a framing for that reduction. So just a comment. And a question. Everybody keeps talking about drinking water. Not all the water that goes to your cities is actually delivered to customers, residential customers. You have municipal, ag, industrial, right? And so it would also be helpful to understand what the breakdown of usage is. And that's, again, just a comment and a recommendation. As we look at rebuttal, it would be very helpful for us to understand the actual palette of uses by the different Front Range entities. So thank you.
Thank you, Director Vasquez.
Any other questions? Hearing none. Thank you.
I believe next on the list is the last direct presentation from SMYs.
Good afternoon. Last is just another place in line. My name is Lisa Darling. I'm the Executive Director of the South Metro Wise Authority. For brevity, I'm simply going to read our statement, but we wanted to bring the voice of a Front Range water provider who is not a trans-basin diverter to the discussion. South Metro Wise, or WISE, consists of 10 water providers who collectively provide water to more than 350,000 people south of Denver. Our formation purpose was to develop new surface water supplies to decrease our reliance on non-renewable, non-tributary groundwater supplies from the Denver Basin aquifer that have historically supported our area. The Water Infrastructure and Supply Efficiency Project, or WISE, is an important part of that effort. WISE is an innovative partnership among WISE, Denver Water, and Aurora Water to share water supplies and infrastructure, reduce the region's reliance on non-renewable groundwater, bolster water supplies to South Metro communities, and maximize existing water assets and infrastructure in Denver and Aurora. Over 2 million people realize value from the WISE partnership. This is an example of the interdependency and collaboration between water users, which is so evocative of Colorado. So you can understand that through the WISE project, WISE indirectly derives some of its water supply from reusable return flows from Colorado River water via its partners. But in addition, and to support this and in reliance on this water supply, WISE members have made substantial investments, including entering a West Slope charge agreement in which WISE pays a fee to the River District's West Slope Fund based on supplies provided by Denver Water. We've agreed to maximize reuse and successive use of reusable water and agreed to adopt and implement conservation plans. Conservation efforts by WISE members have lowered demand by approximately 30% since 2004. We've invested over $175 million in water supply infrastructure that was based on the hydrological assumptions that underlie the WISE project water supply. We want to be clear that WISE supports the acquisition of the Shoshone rights for in-stream flow purposes, but WISE and its water customers could be harmed if the in-stream flow use expands the use of the Shoshone rights. WISE and other water users who would be indirectly affected are not in a position to evaluate the potential for the expansion of use of the rights or any unintended injury from the proposed in-stream flow use, and may have limited ability to participate in water court proceedings. We certainly can't speak to any level of detail on potentially impacted agreements, but feel that there are folks on both sides of this discussion who can and can find consensus in future exercise of those agreements. Now, we were encouraged by several statements by CWCB staff and the River District in the written materials and in the hearing testimony. For example, in your rebuttal, CWCB staff clarified that they're not advocating for a particular historical use study period or methodology, nor are accepting the River District's draft proposed volumetric limit. Yesterday, CWCB staff expanded upon this in testimony and in answer to board questions, indicating that they could provide information in the water court process to ensure that there was no expansion of use. Also, in yesterday's testimony by the River District, what we heard was clarification that the River District is not asking CWCB to adopt or defend their preliminary historical use analysis, and that it would be appropriate for the board to direct CWCB staff to be objective in the water court case. While it's really encouraging that the CWCB staff have recognized the importance of preventing an expansion of the use of the Shoshone rights, our appropriations system requires that we rely on what might be an adversarial water court process that many potential affected stakeholders will not have a full opportunity to participate in. We all really need to believe that the best outcome for the state can be reached through settlement negotiations. So we sincerely hope that the parties can work through their disagreements. We're encouraged by the statements in this hearing that good faith discussions are occurring and will continue to occur to incorporate collaborative language in the proposed in-stream flow agreement. We also truly appreciate the River District and Public Services 2-month extension of the 120-day rule filed on Tuesday, based in part on providing those additional opportunities for interested entities to continue to pursue a negotiated resolution of the contested issues. So we're looking forward to the outcome of these discussions and the incorporation of the party statements in the CWCB's proposed action. And I thank you for your time.
Are there any questions? Hearing none.
Thank you.
Testimony. Clarify, we have now completed direct presentations. We are now going to move into rebuttal. As I noted earlier, if a party has no remaining time, the board can still ask questions of those witnesses, but they cannot present on rebuttal. I have just emailed the parties all of their remaining time, thanks to the timekeeper. Just wanted to note Pitkin County is first because they only requested 5 minutes of time for rebuttal. I want to also note that parties may not need to use all of their time, so just flagging that as an option for parties. Thank you.
Good afternoon, everyone. This is Jennifer DeLala appearing for Pitkin County. The county does not wish to put on rebuttal testimony today. Thank you.
Strong start. Next on the list is SMYs who had no time left, but do we have any further questions for SMYs? Homestake.
Thank you.
Y'all, don't get my hopes up. All right. Are there any additional questions for Homestake? I know Director Vasquez had asked the Front Range parties for additional information. If possible, that could come through another party's rebuttal. But just wanted to see if there were any further questions for Homestake Partners. Director Combs has one.
Yeah, it's for Heather again, sorry. Was the 1988 to 2013 the same years that were in all the studies, or was that specific years just for the Homestake? We're up there, but
Let her get up there.
No worries. I just figured it would be better with the microphone.
Yes,
Can you
thank-
just repeat your question? I was just running up.
so in reference to my previous question of the time frame of 1988 to 2013,
Mhm.
remind me, those were the same years that you studied for all right?
Yes,
It
so-
wasn't specific just for the Homestake issue.
That's
It was
right.
all of your study in comparison to BBA, you used 88 to 2013.
Exactly. That
Oh.
I ran that for the historical scenario as well as the BBA volumetric scenario. So I used that study period for all comparisons of model results.
And remind me why we didn't do the last 10.
And remind me why? I'm sorry.
Why did we not go to 2023?
Good, very good question. The CDSS model study period, the data that's actually in the model only extends through 2013. So all the model runs that I did, as well as the model runs that Hydros did, ended in 2013 because the input files that are available from the state's version of the model only extend through 2013.
Okay, thank you.
Sure. Thank you.
Any additional questions for Homestake? Okay, thank you so much. Colorado Springs Utilities has 23 minutes of rebuttal left, should they wish to use it. Okay, Colorado Springs Utilities ceding that time. Do we have any additional questions?
Director Vasquez has a question.
Perfect.
Yes, I have
Can
a
they
que-
please come back up and speak into the mic as well, just for the record and folks online?
Thanks so much. Barbara Vasquez, for the record, my question for you and for several other parties is going to be, we heard a lot from parties yesterday and today about what appears to be a new spirit of cooperation and attempt to find a collaborative solution, perhaps even preventing a trip to water court. What do you plan to bring that's different than you have brought to the table over the past 2 months during the mediated discussions that might favor that outcome?
You want to take that? We plan to bring different.
Putting you on the spot, guys. Everybody else has heard the question. They have a preview, but
They have a preview.
but there's been a lot of hopeful rhetoric. I'm looking for what you're going to bring that's different.
I think, what we're going to bring is different is an attitude of seeking collaboration, a really positive attitude towards making sure that everyone is doing what they can do to try to find a collaborative solution that, addresses the concerns of everyone around the state and protects that historic flow regime. It's hard to say exactly what we're going to say now or what we're going to be doing in those negotiations, but we are willing to come in and be as collaborative as possible.
And of course, negotiations require give and take, right?
Yes, they do.
Yeah. So I'm interested to hear the answer from other parties on what they plan to bring that's different. Thank you.
Thank you.
Any other questions for Colorado Springs Utilities? Seeing none, Aurora is next. Aurora does not have any rebuttal presentation time left. However, please feel free to ask some questions. I've heard several questions posed to all parties, so please.
Thank you. Director Vasquez, you had asked a question about our palette of water uses.
Correct.
I immediately shot an email off to the head of our planning to get you specific numbers, which of course I have not yet received. I can describe
It can come later. That's okay. I know that there was no time to prepare for that question, but it's a recommendation that we be able to see that.
Absolutely. May I ask a question to clarify what you're looking for? So we have, I could give you sort of the general list of all the different types of uses that occur in the city of Aurora. Do you want those broken? Like, what sort of detail would be helpful to you?
I think just M&I and environmental and piscatorial.
Okay.
Just to break down it by percentage. And while you're there, perhaps you'll take a crack at answering my subsequent.
Absolutely. It's a great question, and it's an important question. The River District mentioned the negotiations, and I can't remember if any one of the Front Range Council counties or entities mentioned the negotiations that we had over the last couple of months. I found that those were heartening and helpful. I thought there was a lot of information that was shared. So I think we've already brought things to the table. I know that, well, I will guess that Denver will have some thoughts for you that they'd like to share because they've been very interested in saying, and which we agree with, how can we look at the river in a way to make it better? Is there something that we can do in the context of these negotiations that would result in a settlement that makes the river better? And so we're willing to bring that to the table. What ideas can we do? How can we operate differently that might provide more certainty, that might provide more water at different times, that might provide better water sharing? I don't know specifically what those ideas are, but I do think that we are thinking about that, and we're very happy to further explore that as much as possible.
Director Combs.
So we've talked a lot about keeping staff kind of either objective or neutral on the historical use analysis. Do all the Front Range parties plan on coming in with a unified approach to that analysis, or do you all individually have your own analyses you'd like in that court process? And the reason I ask is it's interesting that we want to maintain, I think your words were keep the weight of the state out of that process. But if each of you come in with your own processes and the River District only has one to defend against all, how's that balance? So are you all going to unify on what you think is the correct methodology for that quantification? And it's just a little more level playing field that way, or is it going to be 6-on-1?
A very fair question, Director Coombs. And I would first note that the River District is part of a coalition of numerous other parties. So while they can certainly take on 6 of us easily, they are not alone. However, we have unified, and our expert is Heather. Heather Thompson, as you have heard today, has done our analysis for all of the Front Range Water Council entities that are involved. And so we would continue to rely on her, on what she's done, on her expertise and what she's brought. So she's kind of laid out exactly where we think it should go. So that transparency is there. And I don't think that there will be surprises in that regard. There may be additional detail. So for example, Colorado Springs may have, and I'm trying to remember specifically, but I can't, in one of the conversations, Colorado Springs mentioned a specific potential injury to Con Hoosier. So we will have those individual elements. Aurora has 2 other Trans Mountain diversions that we're concerned about, so we may talk about those specifically. We would use Rick most likely, and we would use Heather. So I don't think that we would be trying to gang up in that case. We would be basically presenting what you've seen is where we're starting. Does that answer your question?
Yeah, it does. I saw that Heather was like the shared witness and everything, and I was just trying to get that on the record that is the intent. And then each of you will bring up your individual particular, I guess, pleas for injury based off of her original analysis as the baseline.
And let me caveat that, Northern system is very complex and very different. And Kyle is certainly, an expert in what Northern's issues are. They have very different issues than Aurora does. Denver too has a very complicated system. So in terms of the hydrology, to the extent that we can rely on Heather to provide this unified view of the methodology to determine what that historic use was, that's one baseline. But the other entities will be bringing their own expertise to those areas. Absolutely.
Thank you.
Okay, any more questions? Director Gibbs?
Thanks, Madam Chair. Mine's kind of a follow-up to Director Vasquez's comments and kind of requests, but I'd love to see what specific terms and conditions Front Range parties would want to see in the cooperative call language, moving forward. And I've kind of asked that in a lot of different ways today, and I feel like I haven't had a really clear answer on that. So I'd love to hear that more.
Thank you, Director Gibbs. It's a great question. I'm going to hesitate because in the settlement conversations that we had over the last 2 months, there was language shared in this regard, but those are in the context of those settlement operations, those settlement conversations. So I don't think they are properly shared here at this point, but we have been talking about what would that language look like? Is there a way to find resolution that everyone can agree to? And I think other parties may have a different view, but as these next 2 months unfold, that will be one of the main goals, is to come up with language that we can share and agree to.
And if I may just add, that would be something the board can absolutely direct parties to address in November. So let's think about how we want to direct the parties, direct staff going forward of what we would like to see presented in November.
Okay. Are there any more questions? Hearing none?
May I ask that when you get that information, you can send it to me and I'll read it into the record for the board if it comes out of time. So I
Absolutely.
make sure it makes
Okay,
it.
thank
you
you.
so much.
Yes, thank you.
Denver Water has 10 minutes.
Good afternoon, Daniel Arnold for Denver Water. We do not have any rebuttal, but are happy to answer any questions, including Director Vasquez's question.
Perhaps we could start with that. Yeah, and include Dan Gibbs' follow-on question in your reply would be helpful.
Yes. So, I don't want to put words in anybody's mouth. I don't remember if it was Mr. Mueller, Mr. Fleming, or Mr. Wirt, but, I think one of the witnesses alluded to productive discussions that we were having and concepts that we were exchanging and making progress on. And through those discussions, we've been exploring water sharing ideas where there could be opportunities to potentially store some of the flows from the Shoshone in the river and make those releases at certain times to help with the flow in the river. And I think Northern probably could also go into a little bit more detail on this concept. I think Denver Water is also open to exploring ways to try to make adjustments in improvements to SHOP to help address some of West Slope concerns and how that operates. And so we let the River District know that we're willing to have those conversations. With regard to Mr. Gibbs' question, I think the management concept, it could work. Again, I think it's helpful to have some kind of backstop. If a decision needs to be made in a pinch and you can't get there. And I wish I had a better concept right now. We want to continue to explore those ideas in the months ahead.
And of course, the board won't be party to those discussions, and we just hope that every party can bring their best selves to that discussion and hope we can see you in November with a consolidated solution. There seem to be two major sticking points in all the testimony we've heard over the last 2 days, and that is the calculation of historic use and this exclusivity or joint management. And I really haven't heard anything from either party about where they might give a little on that. And those are going to be the tough parts of your negotiation, I'm sure. It's just my comment. No reply required.
And I do have one item to add on in response to Director Kuhn's question to Aurora. At this point, we're not sure what we're doing with respect to how we would be approaching the water court process in terms of whether Heather Thompson is going to be our witness or someone else. I just want to put that out there because I don't want to mislead anybody. I think we still kind of need to evaluate how things unfold. Again, I hope we don't get there.
Any more questions? Thank you. Hearing none.
Northern has 1 minute.
Good afternoon. Based on that time, I'll save my 48 slides that I had prepared. No, all seriousness, thank you for your time once again. To answer a few of the questions, just to follow up, I guess, to Director Vasquez's question, the CBT project supplies are delivered to roughly 34 municipal water providers. These are towns, cities, special water districts, and a little over 100 ditch companies. The water deliveries under the CBT system are about 50% to agriculture, 50% to municipal. But because of how our project is structured, in that the return flows coming back from both agriculture and from the municipal first use, almost all of those end up in agriculture. So as far as consumption, it's somewhere about 80% eventually is consumed by agriculture in the South Platte Basin, and about 20 through those municipal providers. That ag extends all the way to the Nebraska border, roughly 600,000 acres that CBT supplies reach in some way. The Windy Gap project is 100% owned, and it's under the municipal subdistrict. And so all of those supplies, the original deliveries go to either municipal or industrial shareholders. As to the question regarding a settlement proposal, I have thought about this way too much in the middle of the night. I think that the concepts that I think would make a better Colorado, and I truly mean that. I spared you all. I have deep connections to the West Slope, spent most of my life on the West Slope. So I hear everything that's said and I take to heart. The concepts that I've thought about are, one, agreeing to a rate. I don't think we need to duke it out. And to Director Combs' comment, we are not going to agree technically from an expert position on a number, but I do think we can agree to a better number, a more workable number, and ultimately a more beneficial number. The second part of that would be whatever that number is, there's a way where, as I mentioned earlier, most of the time we do not need a relaxation or relief, whatever you want to call it, in the collective systems that you've heard from today. And so a way to share whatever that number is compared to whatever maybe another number would be, share that delta and use it through some of the buckets, some of the reservoirs that are in our collective system. There are numerous reservoirs upstream, and I think as has been the case throughout Colorado and probably throughout water development in the West, it's all about retiming. And so if we can retime water to a greater benefit, I think we would open up and discuss that option freely. We have some confining our decrees, our uses, but we've been very creative in the past, as you've heard, under shop arrangements. We've allowed releases to occur from reservoirs without a call. And I think that gets us to a much better place. I think the flows in the river, we all are involved. It's been mentioned, the Wild and Scenic Stakeholder Group, the recovery program, all the cooperative things that benefit us all. And we have to come together to maintain those. I think those are critically important to all of us.
Are there any additional questions for Northern Water?
Director Hawes.
More of a comment. I just really appreciate your thoughts there. And I also want to encourage the environment and CPW to be part of those conversations. I think you're alluding to that, but I think it's easy for it just to be the water users having these conversations. And I do think the timing question just made me think about making sure the environment's included in that. I would hope. Thanks.
Are there any more questions?
If-
No, hearing none.
If I may, I would like to add to Director Vasquez's question earlier, and I believe Director Gibbs. I hear and I understand the concern about convening a group, stakeholder group, to figure out what's best, what's needed, what flexibility could be added. We, as water users, environmental interests, recovery program, the Bureau of Reclamation, all meet every week already. We discuss operations, we discuss flexibilities, we discuss what's possible. And I think that that's started in the early part of the irrigation season, early part of runoff, to try to maximize and enhance peak flows for channel maintenance functions in the 15-mile reach that you've heard about. Then it transitions into water delivery operations, how to make the most out of the river. And we've done that. I've done it for 25 years. And there are many in this room that play critical roles in that. So we have some precedents of how to do that, how to come together. I don't think this requires weekly. I think it'll be maybe every few years having a discussion about what might be needed, what might be helpful.
Thank you, sir.
Thank you.
Public Service Company of Colorado has 4 minutes.
Good afternoon, Board. Carolyn Burr, Outside Water Council on behalf of Public Service Company of Colorado. I just had a clarifying point that I wanted to make. There were several mentions earlier today that that the Water Rights Administration currently in effect included operation of SHOP. And while that may be true when the power plant is not operating, when the power plant is operating, which it currently is, the Water Rights Administration occurs pursuant to the 2 Shoshone water rights decrees for power plant purposes. And so I just wanted to make sure, and the historic use of the water rights is also based on that use, not off of a SHOP modified use. Public Service Company is not a party to SHOP. It's not a party to the CRCA. The only agreement that we have is the 2007 call reduction agreement with the city of Denver, which included, consideration on both sides. So I just wanted to make sure that that was understood by everybody.
Are there any other questions? Very none. Thank you.
Thank you.
Thank you. We have 12 minutes before our scheduled break. I just want to note that the River District has 79 minutes of rebuttal, so maybe we take our 15 minutes now. Let's do that.
Let's do that. We'll come back in 15 minutes.
Thank you.
Recording stopped. Recording in progress.
Our uncomfortable seats. Waiting for 2 more members. I suppose we can go ahead and get started, right?
Do we have Director Vasquez?
Director Vasquez, I'm not sure where she's at, but she should be back any second. She's the only one we have left.
Let's give her a moment.
Okay,
And while we're waiting for her, I'll just note,
she's on her way in.
oh, perfect. I will just note, as I said before the break, the River District and the supporting groups have 79 minutes left on rebuttal, and CWCB staff has 46 minutes on their rebuttal. Okay. River District, thank you all. Viola, please begin. Thank you.
Good afternoon, board members, staff, and Madam Hearing Officer. Orla Bannon, Western Resource Advocates. Thank you for all your time and attention to this hearing. I know it's been a long few days. As you have all heard many times, the purpose of an in-stream flow water right is to preserve and improve the natural environment to a reasonable degree. There is extensive evidence in the record that the water up to and exceeding the full decreed amount of the Shoshone water rights helps to address environmental needs within the Shoshone Reach up and down the Colorado River corridor. Like other parties to this hearing, we are only asking to maintain the historical flow regime, which is best done through the water court process, protecting water users and the environment. We don't want to see the well-documented environmental benefits brought by the Shoshone water rights sacrificed lightly. We appreciate this opportunity to speak to you today, and thank you again for your time and attention. Kirsten, I'll turn it over to you, unless there are questions. Are you going to do questions at the end?
Good afternoon, Kirsten Karoth on behalf of the Grand Valley entities, and likewise, I thank you for your thoughtful attention today. On behalf of the Grand Valley entities, I must take issue with a statement made this morning. I do not believe that anyone's testimony yesterday was overly dramatic or draconian, and I really hope that you feel the same way. The West Slope, like the East Slope, was simply hoping to help you understand how important the Shoshone Call has been and why for decades we have sought to make it permanent. There was also a statement that if you permit the River District to have the final say in any request for a reduction in the in-stream flow call, then all the Front Range entities will fight for the lowest historic use possible in water court. So that felt like a threat to me. It felt like a threat to you all, but perhaps I'm just easily offended. But even more, what has been said to you by any of the Front Range parties that would make you think they're not going to fight for the lowest HU in water court? That's what we do in water court. You know, they fight for what they believe is the historic use. We fight for what we believe is the historic use. If we can reach agreements, that's great. And the water court sets up a process to do that. We aren't here defending the River District's preliminary HU analysis. They've already told you it was preliminary. It was a starting point for discussions, and no one is asking you to endorse it. And we were very appreciative of Director Coombs' comment to that effect. It would appear from the Front Range's presentation that they are concerned and don't trust the water court process. But we trust that process, and we think you should too. The water court process will determine how the various agreements that many of the parties in this room have entered into in the past fit into the HU analysis of the Shoshone water right. That, again, is within the realm of the water court, and it really doesn't make sense for you to pick paragraphs out of various agreements and stick them into the ISF agreement without having any true understanding of how that would affect the call regime on the river. It's been discussed by some of you that the water court decree will determine how the in-stream flow call should be exercised to prevent injury. And that is to prevent injury to both the east slope and to the west slope. A trans-mountain diverter not being able to divert when it is not in priority does not equal injury. But decreasing return flows by reducing the call, contrary to the terms and conditions of a decree, does equal injury. Yes, this is an unprecedented offer to the CWCB in terms of the potential beneficial impact to the entire state, and also because it's a non-consumptive water right. So the return flows that the West Slope are trying so hard to protect are essentially the exercise of the water right. Perhaps this is the very best reason for you to take unprecedented actions to allow this donation to go forward. And moving forward by accepting the donation does not preclude negotiations between the West Slope and the East Slope. And everybody here has demonstrated to you the number of years that the East Slope and the West Slope have continued to negotiate. So again, I urge you to take advantage of this unprecedented opportunity and accept the donation that's before you. Thank you very much.
Are there other members of the River Districts group? Yep, there we go.
Apologies. I was mixed up in my order. I feel, give me just one sec. Good afternoon, Madam Chair and members of the board. My name is John Caron. I'm here on behalf of the Colorado River District, for whom my firm Hydros Consulting has conducted a number of modeling analyses related to this proposed water rights acquisition for in-stream flow purposes. I have a PhD in civil engineering with an emphasis in water resources from the University of Colorado. And I've been involved in Colorado River modeling and water management issues for more than 30 years. In fact, my doctoral excuse me, I hope my throat lasts. My doctoral dissertation, I developed a modeling tool to manage flaming gourd reservoir releases to benefit both the trout fishery and endangered Colorado River fish species in the Green River below Flaming Gorge Dam. Excuse me. If you'll afford me just a minute, a brief moment of levity here late in the day. I've heard rumblings around the room that there are some side bets going on as to whether or not this meeting will be adjourned by 5. And apparently there's rounds of beer at stake. Now, I don't have a horse in that particular race, but I thought this might be a good time for a little poetry. So very quickly, I'm an engineer and engineers don't write poetry. That's not part of our job description. Fortunately, we have artificial intelligence. And so I asked Google AI to write a haiku about Shoshone water rights, given everything that it could find on the internet. And so here we are. Two thirsty divides, river flows through canyon walls, tug of war ensues. Seems pretty apt. Thank you for your patience with that. Well, I want to thank the board for its diligence in this hearing. You've been inundated with a lot of information, much of which I dare say belongs not here, but in water court. And I will try to make my remarks as brief as possible. And in doing so, I hope to refocus your attention on some of the basic facts that are at the core of this in-stream flow acquisition hearing and the decisions that you'll have to make. In addition to the obvious and undisputed benefits of an in-stream flow through Glenwood Canyon, the Shoshone water rights, as has been said before, provide a number of benefits to all users of Colorado River water. And in spite of objectors' attempts to, if you will, distract and divert attention from our modeling analysis, the core findings of our analyses were in fact validated by objectors' analyses. And the questions that we asked in our analyses, which we have provided to the board, was really quite simple. And that was, how would the river change if Shoshone's water rights simply stopped being exercised? And what would happen under Shoshone permanency? To address these questions, we used the Water Conservation Board's Upper Colorado River State Mod Model, which is part of the state's CDSS toolbox. This model was updated, as I believe you've already heard, last year in order to better represent current conditions in the basin. CWC staff and their consultant, Wilson Water Group, completed this work and released a new baseline version of the model late last year. These updates were made to the model, were discussed at length and in a collaborative manner by CWC staff, their consultant, Wilson Water Group, technical representatives from the Front Range Water Council, in particular ERC, and my firm Hydros on behalf of the West Slope entities. If you'll allow me, I want to read a quote or two from the Water Conservation Board's user manual that provides guidance on how to use these models. The Upper Colorado River model was developed as a tool to test the impacts of proposed diversions, reservoirs, water rights, and/or changes in operations and management strategies. Furthermore, it is recommended that the user compare the baseline simulation results to results from a model run to which they have added, or in the case of Shoshone, subtracted, the proposed features to determine performance and effects of the proposed changes, unquote. And I bring this up, and it's important to note because none of the objectors' model analyses presented here actually used that off-the-shelf model. Instead, objectors chose to modify the baseline model, and in particular, modify Shoshone demands to fit what they see as a preferable set of baseline conditions. Now, this presupposition of their desired water court outcome, if you will, regarding historical use and the subsequent use of these average diversions based on a period of reduced Shoshone power generation in place of decreed rights and demands in the model is, in my opinion, an inappropriate use of the model. ERC's modeling approach allows them to claim injury to objectors through an imagined enlargement, starting from what they think is the correct historical use. The analysis that we performed uses the Water Conservation Board's baseline model and makes no assumption about historical consumptive use. It simply represents the Water Conservation Board's best approximation of the current state of water use and administration in the river. Objectors have also characterized our so-called zero Shoshone scenario as inaccurate with respect to how the river would behave absent Shoshone water rights. Those criticisms include many assumptions about what objectors posit would happen with other operational agreements and settlements absent Shoshone, but which are by no means foregone conclusions. ERC in particular casts doubt on our model's lack of representation of SHOP, and yet do not model many of the significant terms of SHOP in their own analysis, and in fact acknowledge that the terms of SHOP are too complex on the whole and subject to external conditions to be reasonably modeled in the Upper Colorado River model. So, having said that, let me run through and hopefully refocus on some of the key findings of our work. First of all, And we've heard this before. We've heard Tom Chart talk about this. In addition to the obvious benefits that accrue or would accrue to the Glenwood Canyon, to the Shoshone Reach in Glenwood Canyon, the Shoshone Call helps to ensure flows through the 15-mile reach. It does so especially during low flow years and during critical late summer months, typically August through October. Absent the Shoshone Call, our modeling shows that the frequency of hitting and meeting those PBO targets is significantly reduced. And why is this important? Well, we've heard what the programmatic biological opinion does for all water users of Colorado River water. It provides blanket coverage under Section 7 of the Endangered Species Act to both current and future water users. A determination of non-compliance under Section 7 would subject all new and many existing users to Section 7 and likely NEPA consultation. In addition to the 15-mile reach flow benefits, we looked at potential impacts of Shoshone permanency to existing water users. These include reclamation projects, trans-mountain diverters, and in-basin water users. We reviewed the model results with respect to not only TMD diversion amounts, but also reservoir storage volumes and accounts on those reservoirs, including historic user pools, TMD replacement pools, contract pools, and water used for flow enhancement in the 15-mile reach. A few points on the results of that analysis. Using the UCRM model, we were able to show that there are no significant impacts to the various replacement pools used by both east and west slope water users that would result from Shoshone permanency. However, absent Shoshone, the fish pool would be relied on much more heavily, sooner and to a greater extent, to meet late season flows. With Shoshone active, fish pools will continue to be available. They won't disappear. And they can be more flexibly used to provide additional benefit to 15-mile reach targets. Our modeling analysis also showed, for example, the frequency with which Green Mountain Reservoir historic user pool filling is unaffected by Shoshone, no matter how we looked at the models. Whether Shoshone was on or off, at a max demand, just the senior 1250 demand, none of those scenarios indicated a change in the frequency with which that hub pool fills. Again, the objectors analysis showing impact to these resources uses a Shoshone demand that's inconsistent with the state's own model. It presupposes a historical use, artificially limits the Shoshone rights based on that assumption, and then incorrectly applies those and other assumptions to the model. So in summary, our analysis demonstrates not only the benefit of the in-stream flow itself, but that permanency is a critical factor in maintaining flows in the 15-mile reach. Absent the Shoshone Call, it is much more likely that the PBO and a Section 7 determination of jeopardy could occur, and that would harm all water users in the state. We've also demonstrated that permanency does not cause harm to the various reservoirs that provide replacement water for all of those different purposes I mentioned before. And contrary to assertions from some of the objectors, Shoshone permanency will provide additional flexibility in the use of fish pools or the HUP excess pools with the fish pools to enhance flows in the 15-mile reach. I'm going to stop there. Thank you for your time.
Are there additional speakers? Okay.
Madam Chair and the board, again, thank you for your patience today. It's been a long day and we hope not to drag it out too much further. There will be one more speaker after, or a couple more, so we're getting there. But my name is Brendan Langenheisen. I am the Director of Technical Advocacy for the Colorado River District. Prior to working at the River District, I have 15 years of experience as a water resources consulting engineer, where I focus a lot of my time on the Colorado River Basin, working on and supporting water court cases, as well as change in use cases. I would like to address the injury claims made by the objectors in this case through two perspectives today. First, through examining long-term planning and permitting of the TMD projects, and second, through the preliminary historical use assessment that has garnered a lot of attention today. In my 20 years of professional experience on the Colorado River, I can confirm that all Colorado River water users know to expect the Shoshone Call will be administered on the river whenever river flows at .0 gauge drop below the 1408 CFS. And every relevant augmentation plan or water supply plan that I prepared or reviewed, the industry standard is to assume the Shoshone water rights will be fully utilized. As prudent water providers, any prudent water provider will incorporate the full Shoshone demands because the Shoshone plant can and does operate consistently throughout the year and is entitled to exercise its water rights year-round without any seasonal use limitations. As you heard from Public Service Company just a minute ago, their aim is to operate as much as possible. In fact, the TMDs also follow this prudent approach. My prior correspondence with ERC has confirmed that Denver Moffitt's firming project EIS and Windy Gap's firming project EIS both modeled the Shoshone at 1408 CFS year-round, confirming that both these projects were planned and permitted with the understanding that their systems would be limited by the Shoshone 1408 CFS demand and call. This highlights a critical perspective that hasn't been acknowledged today or in the written statements by the objectors. The TMD's forecasted water supply absolutely will not be reduced by a change of the Shoshone water rights. First, because the Shoshone in-stream flow will not be any larger than the ability of the rights to call today. And second, because their water supply projections are based on the Shoshone water rights being fully exercised at that 1408 CFS. This water right exists today. It is something that is on the river and it is calling. Any discussion that you have heard from the objectors about potential injury to yields needs to be weighed against the fact that the same objectors have planned their supplies around continuous and full use of the Shoshone water rights. Public Service Company is placing a call today. They are expected to place that call tomorrow and the next month and the next year. To plan otherwise flies in the face of long-standing prudent water supply planning on the Colorado River. I want to switch now. That's planning and how this water right has been looked at going forward. Looking back onto the water court, in my experience in water court cases with opposition, the approach advanced by the objectors here, asking the CWCB to weigh in on matters that should be before the water court is, in my opinion, inappropriate. The objectors' positions would exclude parties not involved in these discussions who are legally entitled to participate in water court and would hinder expert discussions that would otherwise be imposed by the uniform local rules for all state water court divisions. As CWCB staff and Peter Fleming pointed out yesterday, water court is a comprehensive and inclusive process designed to resolve situations and results in a definitive non-injury finding, protecting all water users. But the objectors failed to acknowledge that and set forth in BBA's preliminary analysis, and again in BBA's rebuttal memorandum, BBA's analysis to date is not intended for use in water court and may change in the future based upon additional data and ongoing discussions with the CWCB, Public Service Company, and potential opposers. And that was a quote. As Andy explained yesterday, the River District preemptively prepared and distributed BBA's preliminary assessment in an effort to be transparent and to aid negotiations ahead of the CWCB meeting and water court process. BBA's preliminary assessment was prepared in November of 2024 and was based on information available at that time. Since then, BBA has obtained and reviewed additional information which will ultimately be incorporated into a formal engineering report to be provided to the Water Court consistent with standard practices. After BBA completed its preliminary assessment in 2024, we circulated that draft to interested parties and held webinars and technical work groups later in 2024 and into early 2025 with engineers and representatives from both sides of the divide and CWCB staff, as well as with CWCB staff, to work through those concerns. Unfortunately, our efforts to reach consensus are instead being weaponized against us to thwart any potential for compromise. In fact, earlier today, and as referenced by Kirsten a little bit earlier, we heard that objectors threatened to argue for the lowest historical use possible should they not be satisfied with an improved in-stream flow agreement. I want to emphasize that the River District and our coalition have put forth incredible efforts to meet with the objectors individually and as a group on numerous occasions to solicit comments and ideally to understand their real concerns. This process was the first time that we have received analysis and impacts of their systems. Throughout all those efforts, it took this hearing to get some of those responses so that we could actually understand and see the impacts that they were concerned about. BBA continues to look into these concerns that we've received recently and comments that we received through some of those earlier efforts, evaluating all available records, such as to prepare a well-supported and engineering report consistent with what they stated in their, consistent with what they've stated in the rebuttal report in River District Exhibit 39. We will look into those. We have heard their comments and we will evaluate them. And I want to let the board know that that preliminary assessment is preliminary. We are honest and have full intent to go back and to look into some of these comments that have been raised. But Water Court is the venue for that, and Water Court will be a place where we can flesh that out. I did want to, on some of the other historical use comments, I wanted to just raise some awareness from one of the reports that we received and included in our packet, in our rebuttal statement. There is a report from Alan Martellero, the retired Division 5 engineer, who was in charge with administering the river during his tenure, including the Shoshone Call. He stated in his rebuttal report, and this is the River District's Exhibit number 40, that in his opinion, BBA's approach of using gauge data at .0 and truthing that data against CDSS records is a reasonable approach to calculate the actual historical use of the Shoshone water rights. Put that into context to say that what we're doing is not outside the realm of normal, of what is reasonable. And with that, I will leave that there and welcome Peter Fleming up here.
Thank you, Madam Chair. Thank you, members of the board. I'm going to say a few comments and try to save some time. I think we have time. I don't see our timekeeper in chief over here, but thank you. Yeah, Andy's going to have a couple of comments, so you never know where that goes. But we have a long-running dispute at our at our River District board meetings as to who's causing the board to go over time more. Is it the general counsel and executive session and things, or is it Andy's eloquent tongue that that's a bet for another day, maybe over some beers. So main points on rebuttal. On the historic use, you've heard a lot about that today. The Water Court's going to quantify that and determine which party's correct or come up with a different number and tell us what's the right number. The Water Court's going to ensure there's no injury to objectors. And we'll go back to something that Kirsten Carath noted, and I think accurately so, is that it doesn't appear to us that the objectors trust that process because they are going to be protected from injury. That's the way we do things in Colorado. And yet they're asking for this additional discretion for further reductions of the call. if we assume that the water court's change decree gets that quantification correct, as we must, there won't be any injury. But their opportunity that they're seeking to reduce the call further will result in a direct injury to downstream water rights that have come to rely upon the historical return flow. And I'm also want to raise that we're a little puzzled about this request, because I'll go into this a little bit more in a minute. But there's been a lot of reference to these third-party agreements. I'm going to talk about those too. One of the things we thought we were getting out of those agreements was a limitation on the requests to reduce the Shoshone call. I'm going to talk about that in a minute. Want to talk about the third-party agreements with specific requests to the Shoshone Outage Protocol Agreement, or SHOP. SHOP does not represent historical use. In fact, as Brendan explained, it doesn't even represent the status quo on the river today. For the past year, Shoshone has been fully operating. The call is on the river. Also, in particular, the Colorado River Cooperative Agreement, the CRCA, the Aurora Busk-Ivanhoe Settlement Agreement, and the Colorado Springs Blue River Settlement Agreement all expressly and very clearly distinguish between the agreement to operate under SHOP and Shoshone permanency. Those are two different things, and I'm going to explain that. More importantly, the pledge that you've heard about from Denver that they will operate SHOP perpetually, I will explain, is somewhat illusory. Finally, talk about the co-management issue. I've pointed out already that nothing in the objector's presentations addresses what would happen, the injury that would occur to the downstream water rights that have relied on return flows if they are not guaranteed that the water court's determination of historical use and the terms and conditions will be carried forward without diminution of those return flows. You've also heard a little bit about what we heard before earlier this morning, that if the objectors don't get their say on the or the delegation, the discretion issue, that they guarantee that they will push for a significantly reduced quantification of the historical use, which will result in a reduced yield of the Shoshone water rights. I don't know if that quote is exact, but I think it's pretty accurate. So want to talk a little bit about on the historical use and the allegation of injury that we've heard. Brendan brought up the point about the planning. What have these water rights been planned? And I just want to be clear that what Denver for its gross reservoir enlargement project, Windy Gap for the municipal subdistrict, Northern's municipal subdistrict for the Windy Gap firming project, for the federal permitting, environmental analyses, and for the CWCB fish mitigation enhancement agreements, based that environmental analysis that formed the basis of those permits and the enhancement agreement on a constant demand of 1,408 CFS from the Shoshone water rights every single day, every year. The result meaning that their yields of those projects was constrained by that in their modeling and in the environmental analyses by that demand. Also meaning that the demand, that the resulting flows on the west slope were based on a demand at 1408. Now they're saying, oh, no, that demand is much less, meaning the yield of their projects will be greater and the resulting flow on the west slope will be less. Let's talk about the third-party agreements and SHOP. As we said before, we don't think that's relevant to the specifics of the CWCB's determination. But you've heard a lot about it today, and unfortunately, we are compelled to point out a few distinctions. Frankly, we're surprised that we're even here. Those agreements are pretty clear that they are to support the West Slope's efforts to achieve Shoshone permanency, and they're very clear that the Shoshone outage protocol is distinct and separate from Shoshone permanency. Let's talk just a little bit about the Shoshone outage protocol and the 2007 call relaxation agreement. Those are two different agreements. You've heard a lot about them. It's very confusing. Even we get confused as to which one we're talking about from time to time. The SHOP agreement is a 40-year agreement. There's about 30 years left on it, maybe 31. It has lots of what we call escape clauses. It's an agreement where parties pretend that the call is on the river when the power plant is down. And there are certain drought exceptions where parties don't have to pretend that the call is on the river. The SHOP agreement seeks to protect only the flows created by the senior Shoshone call, 1,250 CFS. I'd point to, we look back at Jeff Bandy's slide that he put up. I think Director Hawes asked a question about that slide. It showed that in Denver, since SHOP has been in effect, has contributed, I don't remember the exact number, 60-some thousand acre feet to SHOP. And that's good, and that's great. Because in the absence of the SHOP agreement and in the absence of an in-stream flow, it wouldn't have had to contribute those flows. What it doesn't show is that all those years of zero was when the Shoshone power plant was operating. It was responding to the call of the hydropower rights being exercised, either at 1408 or 1250%, depending upon where the hydrology lay. In other words, in those years of zero, the amount that Denver was contributing to the river in the form of bypassing water or releasing water when it would otherwise be called out by the senior Shoshone water rights was much greater than the amount that it contributed under the SHOP provisions. The 2007 call relaxation, in contrast, is an agreement only between Denver and Public Service Company, and you heard a little bit about that from Carolyn Burr. That relaxation agreement allows Denver, under certain defined drought criteria, they have to exist, Denver can then ask Excel or tell Excel to reduce the Shoshone call, and they pay power interference. And as Carolyn indicated, there's some other quid pro quo exchange of consideration, including the provision of additional water to the West Slope and to Public Service Company. That 2007 agreement expires in the year 2032. That's actually, it's less than 7 years from now. With respect to the Colorado River Cooperative Agreement, it's a 2013 agreement between Denver and 17 West Slope parties. And I can tell you that only Denver interprets it to mean that SHOP equals Shoshone permanency. One thing they do get right about it is that the CRCA provisions that regard Shoshone intend to only protect the senior right of 1,250 CFS. They don't address the junior, but nothing in the CRCA prevents the West Slope parties from also seeking to protect the junior right of 158 CFS. The agreement just doesn't address that. The CRCA makes clear that SHOP and Shoshone permanency are two different things. The CRCA is attached is River District Exhibit number 16. And at Article 6A4 of the CRCA provides that the signatories agree that a Shoshone outage could adversely affect water users and the Colorado River, and that the signatories agree to implement SHOP to mitigate those potential adverse effects. Then the next sentence says, the signatories also agree to cooperate to achieve permanent management of the of the flows of the Colorado River. Well, if SHOP was intended to be the equal Shoshone permanency, there'd be no reason to include that following sentence. Denver relies, I believe, on a separate paragraph of the SHOP of the CRCA for its position that SHOP is effectively Shoshone permanency, and that SHOP must be incorporated into any future concept of Shoshone permanency. That's Article 6C2, where it says Denver and the River District agree to operate their systems under the Shoshone outage protocol, even if the power plant ceases operations. And that's what they rely upon. What they don't say is that that paragraph expressly states that is subject to the following conditions. And one of those conditions is that the 2007 call relaxation agreement that expires in 2032 remain in full force and effect. Now remember, the River District isn't a party to that agreement. We have no control over whether that agreement ever gets extended or not. Denver could agree on its own accord, decide on its own accord it doesn't want to renew that agreement. And certainly public service could as well. So we have no certainty that SHOP would be carried over into the future other than for the next 6.5 years, at least on a permanent basis. The SHOP agreement itself, which is a larger agreement separate from the CRCA, does bind the parties to that agreement to an additional 30+ years. So SHOP will continue for that period of time, but there's certainly no certainty that it will be renewed after that. Finally, the SHOP agreement itself states in Article 8 that nothing in this agreement shall be interpreted to constitute compliance with or satisfaction of the permanency provisions of the Colorado River Cooperative Agreement. You know, when Denver says that it wants to incorporate the SHOP terms, what it really means and what they're really saying is that they want to incorporate the SHOP escape clauses into Shoshone permanency, because those escape clauses they view will provide them as additional relaxation of the Shoshone call. By definition, SHOP applies only when there is no Shoshone call. Aurora Busk-Ivanhoe settlement agreement, which was entered into between Aurora and the River District and a number of other West Slope entities, it wasn't just the River District, was an agreement that basically restored to Aurora yield that it lost in an unsuccessful Colorado Supreme Court case that the River District and other West Slope entities brought to challenge their change of use of the Busk-Ivanhoe Trans Mountain rights. We entered into a good settlement agreement that restored the yield that Aurora would have lost as a result of the Supreme Court's ruling. We thought we were getting some benefits in exchange, including Aurora's agreement to participate in SHOP, which they have done. And Aurora also agrees not to oppose Shoshone permanency and the in-stream flow use of the senior Shoshone water right. As Alex Davis spoke, that agreement is conditioned on 3 things. And as we clarified, and as I think she confirmed as well, we will go forward carrying that those 3 things we're willing to do. We've always said we're willing to do them. Colorado Springs Blue River settlement that was entered into between the River District and a number of West Slope parties in Colorado Springs with respect to their Con-Hoosier system and the proposed expansion of their Montgomery Reservoir is similar in effect with respect to agreeing to SHOP plus agreeing to Shoshone not to oppose the in-stream flow use of the senior Shoshone water right, subject only to one defined condition regarding compact rules, and we won't talk about that. So I wanted to talk a little bit about the co-management issue. We believe it is clear that the CWCB does have the legal authority to enter into the in-stream flow agreement as proposed, and that there is precedent for it, and that it should. CWCB's statute with respect to in-stream flow acquisitions, it's all in the same case. Mr. Wirt was, or in the same statute, Mr. Wirt was right. That's a long section of the CRS of the statutes. But it's very clear that the authority with respect to acquisitions is different than the authority with respect to appropriations. In the statute, the CWCB, at the request of any person, including any governmental entity, the board shall determine in this 120-day period, which we've extended, what terms and conditions it will accept in a contract or agreement for such acquisition. Doesn't specify any specific limitations on what those terms and conditions would be. It just says what terms and conditions the CWCB will accept. With respect to the CWCB's in-stream flow rules, in-stream flow rule number 10 provides that the board may enter into enforcement agreements that limit the board's discretion in the protection of in-stream flows and or may delegate limited authority to act on the board's behalf. There's been a lot of discussion about that. We believe that the proposal of co-management that you have before you in the in-stream flow agreement is limited. Number one, it's a co-management proposal. It's not simply the river district. Number two, it's limited in the respect that the CWCB is not delegating its use of in-stream flow. It is still the only entity that can use water for in-stream flow purposes. That part has not been delegated. Mr. Mann, on behalf of Aurora, went through a lot of the agreements that the CWCB has entered previously to show, attempt to show that there was no delegation of authority to the extent delegated that they believe would be delegated under the in-stream flow agreement. We simply disagree with Mr. Mann's analysis, but maybe more importantly, some of the parties to those agreements disagree with Mr. Mann's analysis as well. Grand County has made very clear to us that the CWCB Denver Grand County agreement for water delivery and stream flow agreement provides the county with the determinative use as to how to manage and control the water that is donated under that agreement. Paragraph 11 of that agreement says if the management committee cannot reach consensus, and that management committee consists of Denver and Grand County, I believe there's an attempt to get the CWCB involved in that management committee. I don't know whether that has occurred. But if the management committee cannot reach consensus on how to use the donated water, then Grand County shall manage and control the water for the intended environmental purposes. So that last part is a little bit of a quote or a paraphrase. But Grand County has also specified that that delegation is permanent and non-revocable. In addition, I wanted to point out the McKinley Ditch agreement that between the CWCB and the Colorado Water Trust. There was some discussion about that. And let me just read from River District's exhibit number 38, which is a letter to the Water Conservation Board from the Colorado Water Trust dated August 28 of this year. So just recently. In that letter, the Water Trust says, similar to the proposed acquisition agreement between CWCB and the district, meaning the River District, The grant for our McKinley project also expressly grants limited authority to the Water Trust in accordance with In-Stream Flow Rule 10 to act as the CWCB's agent in the administration and monitoring of the in-stream flow use of those water rights. And that projects of this nature, for them to operate successfully as intended, the CWCB must have the flexibility to enter into agreements to reasonably limit its own discretion in how and when it operates the in-stream flow water right. Likewise, the CWCB needs to be able to delegate some level of authority to other parties to act on its behalf. There are other agreements, including the one with Northern that was mentioned yesterday, where Northern, and then that I acknowledge that that is under a different statute. But it says that the water delivered from Glade Reservoir under Northern's water rights will be released in the manner and volumes and at rates of flow at times to be determined at the sole discretion of Northern Water. Go back to the point I made about being puzzled as to why these requests for additional relaxation of the Shoshone Call are being made. We understand that there are circumstances, and there could be circumstances in the future that create a crisis. Now, we've explained through the water court process, they're going to be protected from injury. Everybody is, upstream, downstream. Let's just assume that's going to be correct. But there could be crisis situations in the future, and that's why we've proposed this co-management process. What we're hearing, though, is puzzling to us, because in the negotiations of those agreements that I talked about, the CRCA, the Bosque-Ivanhoe Settlement Agreement, and the Colorado Springs Blue River Agreement, those parties expressly agreed that they would not seek a further reduction of the Shoshone Call other than very limited circumstances that are specifically defined. The 2007 Call Relaxation Agreement, we've agreed, if we get the water right and this process goes forward, that will be incorporated. We have no certainty if we don't get the water right. A potential further relaxation of the call in the winter months, and this is under the terms of the CRCA, under extreme drought conditions under which Denver Water has banned, total ban, outside on watering in its service area in the preceding summer or the subsequent summer. It's a very limited circumstance. It's never occurred. But the CRCA says that if we carry forward and get the water right, we'll make that additional relaxation under that very limited circumstance. And the third one is the limitation that Alex Davis talked about, and it's actually just an agreement to discuss in the terms of trying to avoid disparate impacts if the parade of horribles happens and we're faced with some sort of compact issue. Let me just read what those sections of the CRCA say. Article 6E1A, Denver Water agrees that except as provided under 6E2, which is the 2007 Call Relaxation Agreement and the winter one, it will not seek any relaxation of the Shoshone Call other than a specific renewal of the 2007 Call Relaxation Agreement. Article 6E2E, which is the provision of the CRCA that talks about that severe winter call relaxation agreement, says that any relaxation of the Shoshone Call after March 14 of any given year, and remember that that severe one is only in the winter period, any relaxation after March 14 shall occur only as provided in the 2007 call relaxation agreement. The 2007 call relaxation agreement is limited to the period from March 14 to May 20. And there was a reason for that limitation. It's because that's the May 20s when, irrigation is really getting going. In fact, it starts earlier, but the recreational season in Glenwood Canyon and the upper Colorado River is starting to cook. It's before the Memorial Day holiday. So we're puzzled. Article 6C1 of the CRCA says it is the goal of the signatories to achieve permanent management of the flow of the Colorado so that the flow mimics the call flows, whether or not the Shoshone Power Plant remains operational. Denver's proposal for an extra undefined reduction of the Shoshone call beyond the terms of the Water Court's decree and its terms and conditions and the 2007 call relaxation agreement, that's not permanent management that mimics the Shoshone call flows. And in fact, it's quite the opposite. Same point with the Busk-Ivanhoe agreement. That is Aurora's Exhibit 3, paragraphs 34.3 on page 27 to 28. Aurora agrees that it will not seek or support any additional relaxation of the Shoshone Power Plant rights, except as expressly provided in two paragraphs that deal with the 2007 call relaxation and the compact issues. Same thing with Colorado Springs. Blue River Settlement, Colorado Springs Exhibit 5, paragraph 10.6.3. Colorado Springs agrees that it will not seek or support any additional relaxation of the Shoshone Power Plant water rights, except as expressly provided in the compact issues paragraph. Despite all of that, we firmly remain committed to working cooperatively on a co-management process and addressing crisis situations as any prudent governmental entity would. And we'll do that collaboratively with the Colorado Water Conservation Board and its staff. And I know that that will work. Turn it to Andy Mueller at this point.
Well, thank you, Board. I'll be very brief. I just want to thank you very much for your attention during these 2 long days. And I want to come back to the co-management concept. Peter Fleming just said it, but I think it's important for you to hear it from both he and I. We are committed to good faith co-management. We bring this historic opportunity for a partnership with the CWCB and the West Slope entities in our coalition. As the donating entities, as the parties putting up significant funds, both the West Slope and the CWCB are the appropriate entities to co-manage this. We don't look at this as a veto right. We look at this as a collaborative opportunity. That being said, we have a lot of ideas about how a collaboration paragraph can be read and how we can get the input and when and how and what would trigger the parties, the CWCB and the River District, to consider reducing that call. And I think there were questions from the board about what that might look like. And I will tell you, a lot of it's what has already been identified in the prior documents, right? So, if there's a city on the Front Range that depends on Colorado River water that has banned outdoor lawn watering, then that means their system is in dire constraints. It means that they have figured out in some instances that they only have a few months left of water supply, right? So that means that we need to come together and figure out how that entity can we can relax the call for the benefit of that entity, right? Now, when we do that, we've got to also balance the needs of the Grand Valley, right? The Grand Valley's been pretty clear about that today and yesterday. But there are ways that we can do that if we're all at the table. So we would, we can have a convening process between our two entities with the interested parties. And by the way, the interested parties aren't, I think there was some comments from Northern that they involved people who own water rights. They're also the environmental groups. They're also the recreation industry that depends on these flows, right? It isn't just water users, water right owners who depend on these flows. It's the fish, it's the biology, it's the river itself, right? So we convene that group, and we believe that we can talk through it, and we can set up some structures to do that. Depending upon the speed with which the crisis is occurring, it may need to be virtual. Ideally, it's in person. Meetings in person, in my mind, work much better. But triggering that, right? Well, outdoor lawn watering bans and a demonstration of the severity of the situation, absolutely, right? The West Slope, let me just say, there's a whole, flag out there that Northern has identified and that we agree with because the Grand Valley has identified, and that's the historic user pool. And in 1 year in the entire history of that historic user pool, it almost didn't fill. That was 2002. So if we have a repeat of that, where that 66,000 acre feet in Green Mountain don't look like it's going to fill, that's a problem not just for West Slope irrigators and the endangered fish that depend upon HUP surplus, but that also is a really good indicator that we have a problem in the Colorado River Basin writ large on all water users who depend upon it. So when that prediction is made by DWR and the Bureau of Reclamation, we can convene that group of stakeholders and talk through a process and talk about whether or not a call relaxation is justified. Is it justified just for the junior? Is it for the senior? What's the length of it? When does it occur within the hydrograph to provide the most benefit? How does it work, right? Because every year, every water year is different. So it's going to require a whole lot of very smart and very quick thinking to figure that out. But those are just two of the flags. But I think we can identify with the help of your staff a series of triggers. And I would just say that those are the ones we know about. There needs to be a catch-all that says, and other circumstances that warrant the consideration of a reduction in the call, right? So what are those? We may not identify them today. What I've learned in water management is that we're not very good at predicting the future based upon past performance. So let's make sure that we actually have that flexibility in our co-management. I know the Front Range wants you to solely manage this. And I hear that, and I think they've been very articulate in that. We clearly disagree about their legal interpretation of the statute. We think you have the authority. That's for you and the AGs to determine on your own behalf on that issue. But I can tell you from the West Slopes perspective, the benefit of this partnership depends upon our sharing those management decisions with the CWCB. And so if that's not something you're able to do, unfortunately, this opportunity won't continue to carry forward. I don't think anybody in this room wants that. I've heard every single party come up and say they're in favor of this in-stream flow and this protection for the Colorado River. Well, there are ways in which we can do this and make sure it moves forward. We'll do our best with that collaborative language. I, again, want to thank you for the opportunity to be here and talk about this opportunity with you. If you have further questions for the River District and the co-proponents, we're happy to answer them. We would also want to leave some room for staff who needs to talk next. So.
So are there any questions? Director Haas?
I have a question for Kirsten, actually. Where's she? Oh, sorry. Thank you. I just was hoping you could talk a little bit about the interplay between the Shoshone Call and water rights and Cameo. And I'm asking not to be an advocate in any way. I just think that people that aren't in this basin don't always understand the magnitude of those, how those two rights play together. And like Cameo, I think is over 2,000 CFS. And so I'm just trying to get for my fellow board members who don't
Sure.
live
So,
in the space.
I mean, I can say generally speaking, that the great thing about the Shoshone Call is it does keep the Cameo Call off. And by keeping the Cameo Call off, we also maintain water in the HUP pool. But if you want to talk numbers, I would ask that Luke come up and maybe address that.
Yeah, I think it would be good just to know that these water rights, once they pass Glenwood, get used, especially in the irrigation season.
Really appreciate your question, Taylor. Boy, I thought I was off the hook for the rest of the day. If you would, just, can you rephrase it for me? Sorry.
Yeah, if you can talk about them, like, for people that don't work in this basin and don't understand that kind of back and forth between Shoshone and Cameo and when they're calling, that once it passes Glenwood, this water gets used in the Grand Valley. And it's more of a kind of a factual thing of how the system operates and that there are users downstream. It's not just flowing out of the state.
Yes, 100%. So I think you bring up an important point. The water rights that are associated with the Cameo Call are the common number we use right now is 1,950. Those are the irrigation rights in the Grand Valley. There's an additional 400 CFS summer power water right that we've negotiated away the ability to call for that right. And that's an important part of some other agreements that I don't know it makes sense to get into with this board. But when Shoshone is operating, all that water all accrues to our irrigation diversions and to that power right that doesn't have the ability to call except under some very certain circumstances. So I don't know if I'm answering that really as I'm probably not doing that as much justice as it needs, but everything that Shoshone sends our direction, there are decreed water rights to put that to beneficial use within the state of Colorado. There are times, as you've seen, that call is surplus to what we need from an irrigation perspective, and those are extremely important timeframes for the 15-mile reach, for the recreational community, for the Grand Valley as a whole. And I don't want that to be lost either. It's very similar to what the gentleman from Grand County was talking about with their agricultural diversions. Is Shoshone allows them to continue to divert without kind of destroying, I don't want to use that term, without harming the river in a way that is, hard for us all to see, I guess is one way. For 100 years ago, we could divert the whole river, everyone was fine with it. We can't get away with that anymore in the agricultural community. And Shoshone allows us to continue to divert agricultural water and take advantage of those other values that we've as a community have come to value: the fish, the recreational, the riparian habitat. So I'm being long-winded. I hope that answered your question.
Yes, thank you. I was just trying to make that connection to what happens after the water gets passed and that there are users downstream.
Director Vasquez.
While you're up there, help me understand something. I can't remember who said it from the Front Range. They were talking about the Green Mountain Reservoir and the fact that Shoshone doesn't own rights to the storage, and that the fact that it's released for Shoshone, or Shoshone, if that's the proper pronunciation, is a gift. That was the implication. And I'm trying to understand, if you've got downstream users that are calling, sorry, consultation on the side.
Yeah, sorry, finish your, if you finish your question, certainly.
The implication was it was the downstream irrigation water right holders who were calling the water out of Green Mountain to the benefit of Shoshone.
Okay, I think I understand your question. I don't know that I'm probably the most qualified to answer that. I will point out that there is one thing we will not figure out today, and that's how to pronounce Shoshone. Shoshone.
I'm glad I'm not the only one.
I'll weigh in on the pronunciation. The tribe pronounces it Shoshone, and so do we.
That's what I thought.
And that's why we pronounce it that way.
Yeah,
So,
thank you.
I think that's
Yes.
important. So, but it's a great question because everybody here, there seem to be a number of different pronunciations.
And our chair has just explained the proper pronunciation.
Our cultural appropriation.
Yes.
But it is Shoshone.
Yes, thank you. I think here's the bottom line. Senate Document 80 said both pools, the West Slope pool and the East Slope pool for short language, both pools during certain times of the year shall be used to meet the demand of 1250 at the location of the Shoshone power plant. That's what the document says, and it was a main important goal from the West Slope that it be in that document. And so that water has been released since that reservoir first filled every single year to meet the demands of at Shoshone. Okay, and it didn't say when the power plant was on. It didn't say when the call was on. It said that the water shall be released to meet that flow in the river. And it's very important to us to demonstrate that flow was the benefit the West Slope got out of Senate Document 80. And that is the purpose of Green Mountain Reservoir. And so when the Front Range says that it's a gift, that's not true at all. And to leave you with that impression is incorrect.
And I may have misunderstood.
Well, no, I think you understood what they were saying. I think you heard them correctly.
But I appreciate the clarification.
Okay.
Andy.
Yeah.
Are there any other questions? Director Camblin?
I'd like to speak with John Karen for just a second, if he has a minute. And here you thought you were off sick too, huh?
Yes, exactly.
I'll make this simple. I just have a simple question, and I should have actually asked Heather when she was up, but since that time's up or whatever, I seen it on your slides also, and Director Combs brought it up also. So on this historical data or whatever, it was brought up, why did the data was used from 2013 to, or what was it, 1988 to 2013 on the CDSS. And she said there simply wasn't any data past that point. Why is that? Is it an outdated system and they just quit doing it that way? Or why are they just that far behind on getting data after 2013? Why did it quit at 2013?
I'm not entirely sure I understand your question. The model that we were using at one point only went through 2013, and previous studies that we have done for the River District, for example, the Colorado River Risk Study, encompassed that 88 through 2013 period. I'm not quite sure, and maybe Heather's the more appropriate person to answer the question about why it didn't extend past 2013, but I may not totally understand your question. So, sorry.
I think staff can probably answer this better, but the model was originally published in 2015. And so when that model came out, they only had it up to 2013. I believe that there are ongoing efforts currently at the state to update that model all the way to 2022 or 2023, but that hasn't been finalized or published yet. So that was the limitation in the modeling period.
Okay, that makes more sense now. I do understand that. I appreciate that clarification. And then, John, I'm sorry, I've got one other question for you too. And then I promise I'll let you slip.
That's all right.
You
happy
mentioned
to help.
that the CWCB staff had helped helped you model the historical use for the Colorado River District. Am I correct there?
No, if I said that, I misspoke.
Okay, it was their model that's used then, Brad?
The the staff of the Water Conservation Board, at, in large part at the request of Northern Water and others, from the Front Range, undertook this effort to update, the Upper Colorado River model for use as a daily time step model, specifically for the purposes of evaluating Shoshone permanency. And so that process was undertaken last year. It included staff from the Water Conservation Board, their consultant Wilson Water Group, my firm Hydros on behalf of the West Slope water users, and ERC on behalf of the Front Range, excuse me, Front Range Water Council. So that collaborative effort led to the board releasing this model late last year, and that model then was the basis for our analysis. And we simply took that model as it existed off the shelf to perform our analysis.
Okay, that clarified it. I'm sorry, it's been a long day or a couple of days, and it went in one ear and out the other. And so
Understand.
sometimes you got to tell me twice.
Thank you, Director.
So are there any more questions? Director Felt?
Can I clarify something before your question? I just want to make sure, so John Karen did some modeling assessment, but he did not dive into the historical use. So BBA is our consultant, and they prepared the historical use. They went back to look at the records on how the water right was used, where John Karen was looking at the whole system under more or less current conditions and how to evaluate what is the impact that the Shoshone water rights have. So what does Shoshone bring down the river, and how does it operate within the system? So I just want to distinguish those two things real quick. Sorry.
This is for you, Andy. I feel after what we've been through here and you know, and all the preliminaries leading up to this over the last years, feel like we are extremely close. At least feel like I am, but I think my colleagues may be too. Finding a path forward here. This, I think, so much hinges, honestly, at this point on this question of authority. And I think there is, I feel like on the CWCB side of this collaborative discussion, there is the same goodwill and the same certainty that what's best for Colorado within the greater construct of everything else involved in this and the other commitments involved, that this can be administered in a way that provides 99, whatever Kyle said, 99% of the benefit, and that there is a path for making sure that the state, not the state government, the whole of Colorado is able to be kind of kept healthy. A couple times over the last 2 days, though, you have also you've sort of drawn a line in the sand about you've talked a lot about collaboration, but you have seemed to have drawn a line in the sand about we're not going to just give all the authority to CWCB. And I guess you haven't really articulated what you're going to do if that is the direction of this board. The implication that I've interpreted from your comments, the simple one would be, we're just not going to buy it. We're not going to do it. I can think of other paths forward that you could take, and I don't feel very good about those either. And I'm trying hard to get to a question here, Jackie.
He sees me motioning, but it's okay.
I really am. Can you help me? Can you help me understand? Well, let me say one more thing, actually. I kind of forgot about this. I did not hear one of your group, all the different interests that spoke. I didn't hear one of them, I don't think, speak to this. That by God, you know, we want this, but it has to be the district either controlling it or having a significant controlling element here. I really only heard that from you and maybe Peter. And so can you help me understand where, or can you help me understand how to resolve this blank spot on the map?
I can, but I want Kirsten Karath to provide a voice before I do.
So Director Felt, I guess I was too subtle. I ended my presentation saying this was an unprecedented donation and you should take unprecedented actions or there is no donation. And as my understanding right now, the 32 entities on the West Slope cannot give up. I mean, we've already explained that if the call is reduced, then anyone reliant on the return flows is injured. And so they're investing in this for certainty. They're not investing for a new uncertainty on the river. So I guess I was too subtle, and that's my apology. I mean, that's where we are right now, is, you know, expecting that you would exercise your ability to concede authority on this unprecedented donation.
And Director Phil, I think that's the Grand Valley. I would tell you, I've had conversations with all of our partners. I have them regularly. Believe it or not, keeping a herd of cats like this going forward in the same direction, it takes a lot of communication. And luckily, I have a great team at the River District who does a lot of it. But I will tell you that that is the one sword that the West Slope is prepared to fall on this. And it would be a clearly undesirable outcome from our perspective not to have that partnership with the CWCB. I think we would be forced to walk away from the in-stream flow process. And I hate to say that because it sounds like it's a threat. It's not. It's just the reality. It's the reality I have leading a giant coalition. Do I have other ideas? Do we have other mechanisms that we would then pursue to guarantee the perpetual Shoshone rights? Yes, we do. None of them are as collaborative. None of them are as beneficial to the state as a whole. And all of them also require a heck of a lot more work from me. I will admit that. Even though this is a lot of work, there are others that will be more. And but we're not going to just walk away from the Shoshone permanency effort. But we would have to understand that this path that we have tried to forge with the state is not open because of the insistence that we get to manage this together. And I think remember, and I don't disagree with Kyle that it's the less than 1% of time in the future where we can envision a time where we've got to get together and collaborate about whether or not the call is exercised in the way that it's required to under the terms and conditions of a water court decree. So it's, and it's really important to remember that that water court decree is not going to give us 1408, 7 days a week, 24 hours a day for every week of the year. It is going to be limited by an accurate historical use analysis and an injury prevention. And so, you know, at a full rate, if it were, that's over 1 million acre feet a year, that average in that 29-year period we looked at. We're already down below that significantly. We believe that the end result will be below that. And we think that that means that there are times when the call will be on and times when it won't be on. And there are ways to organize that call, the timing, the seasonality of the call, the volume of the call, to prevent injury, to prevent the injury that we've heard. Brendan mentioned this earlier. Until this hearing process, we couldn't get the Front Range to show us what their injury is. And in fact, we now have numbers, but we don't have times of the season, so we can't figure out how to, you know, time the call to avoid that. That's really important when we're talking about how to find these collaborative solutions. We'll get there, I believe, in the water court process to figure that out. But I think, you know, what we're saying is this is the deal that we were able to cobble together with a huge variety of interests on the West Slope, from the headwaters to the Grand Valley. Just like the Arkansas, our interests are very different at the headwaters than they are at the state line, right? They're just hugely different perspectives, not just different political parties, but different perspectives, right? I mean, it's like, you know, so how do we bring all those together? And we've done our best to do this. And I think what you've seen is a real unified coalition where we're meeting the interests of this varied group. It falls apart if we can't make sure that we're involved in that critical decision making. You know, so that's and it's not just the Grand Valley. I don't want them to be the bad characters here. Perry Will left, but I can tell you the Garfield County Commissioners had some few choice words for me when I told them we were going to partner with the CWCB on an in-stream flow. Okay. I mean, just to be clear, it takes a lot to get to this point where we're able to offer that partnership. It's a lot of effort and compromise. And that's what we've done on the West Slope to make sure this can happen.
Okay, well, I'm glad I asked the question, because while maybe nothing that you said or Kirsten said is new, I think I feel it's important for us to hear it in the context of that particular question that hadn't been asked yet. So thank you.
And can I just supplement what Andy said with just some clarification about where we are with the potential that we might reach agreement. You know, the fact that, you know, Andy correctly stated where we are as a West Slope on this doesn't preclude us as a West Slope. And we obviously need to go back and check with our, you know, constituent group, Mesa County, and Andy mentioned Garfield County. Mesa County also believes very strongly in this point. But it doesn't mean that we can't go back in these intervening 2 months, talk with our constituents, talk with the objectors, and come up with a proposal that addresses this fundamental issue. I still think it's going to, you know, have some bottom line elements to it, but it might have other provisions that satisfy the concerns that have been raised. We hope that that's a possibility. We're going to strive really, really hard to make that happen. We can't guarantee that it will.
Director Vasquez.
Yes, while both of you are still up there, I'd like to ask a follow-up question. Both Front Range opposers and CRD have made the case that the frequency of this decision about relaxation will be extremely low in your estimation. So you agree on that. And I think That's what I heard. Maybe I misunderstood. But given the fact, if it's true, that it would be very infrequent, it seems that the parties could come together to craft language around how this co-management works in those cases, which are infrequent, while CWCB, during the rest of the majority of the time, is managing the in-stream flow. Does that sound reasonable to you?
Excuse me, if I understand the question correctly, Director Vasquez. Yes, it sounds reasonable. Whether we can do it or not, of course, is another question. If we can reach agreement on what frequency we're talking about, number one, what the circumstances are, number two.
The triggers.
The
Right,
triggers, exactly.
right.
And number three, what factors get weighed, even when those circumstances exist, as to whether or not there would be a relaxation of the call. You got to weigh X, Y, and Z, potential injury to the Grand Valley entities, potential crashing of the ecosystem, whatever it might be. And weigh those things with the water crisis situations that are facing not just the objectors, as Andy pointed out previously. Sometimes we have a lot of water on the Front Range and hardly any on the West Slope. That existed kind of today or this year. Other times it's the reverse. Oftentimes it's both, right? And when we're in crisis situations, we have the ability to work together.
And as our chair said yesterday, the more specific you can be, the more the in perpetuity is covered so that there's no guesswork in the future. So encourage that.
Any other questions? Director Combs.
Thank you guys for the clarification. I really appreciate the words and the follow-up. So I'm making an assumption here and I want you to correct me. It seems like you want to keep your hand on the throttle with us as CWCB. There's obviously, we've talked about trust issues, East and West, but is there also a component of preference when we come down to those places and those triggers? Do you want to have it? It seems to me that there's also a trust issue with CWCB making a correct statewide assessment of that call. And you feel like a preference is what you're gaining by maintaining this hand in there. Is that an accurate assessment? And I'm talking very granular and coarse, but that's what it's coming down to in my mind, is you're wanting to maintain a preference in that discussion.
Yeah, I would say that I mean, maybe I'm not fully understanding your question, Director Coombs, but I would say the preference is that the call remain on unless there are these exceptional circumstances that we would define. And then there would be a institution of a collaborative process where we'd get input and weigh those factors that we can identify. And then there will be a number of questions about the size of reduction and the timing of the reduction and all those. And so we would like to be involved in those discussions and those decisions around those particular points. And I would say that it's critical for us to be there. It's critical for our coalition to have that West Slope participation. But it's also critical to have the state's participation in that and the input from your staff and the assessment of the statewide conditions that dictate the need for this. And that's where I think the two agencies, I spoke to this yesterday, where we can bring resources together to make better decisions. And that's how I view us having a much better outcome in these decisions, is that we're bringing these resources and the drought protection ideas and the forecasts and the data that we have. I mean, both of the district and your agency spend a tremendous amount of money forecasting tools and snowpack modeling and soil moisture modeling and even jointly cloud seeding and those kind of things. We're trying to work together on so many things, and we do really well on a lot of all those things that I just identified. This is just an expansion of what we would be working on, and our preference, yes, is that we would be involved in those decision points, and we would bring our perspective and our expertise, and the staff would bring theirs, and we would solicit the input and then make an agreement that we would or would not reduce the call and how it would be done. So,
Well, I appreciate it. And I just want to, I want to tell you, I don't doubt your collaborative spirit. I think you've proven that with the whole group you've put together and the organized to accomplish this. I don't want a greater divide east to west. And that's the concern. I think the collaboration effort that you've put together in the West Slope has to carry across to the entirety of the state. And so when I speak of preference, my question is more of, will the Grand Valley irrigators scarcity trump a scarcity on the Front Range? And if you have your hand on the throttle, that's what I'm talking about, preference. That's what, as CWCB, who's have this exclusive ability to run the in-stream flow, that's my concern of that partnering on that level. So that's where I'm looking for a little comfort from you.
and I think it's from our perspective, what that would be is a weighing of of how do you spread that potential injury, or more a better way to look at it is how do you spread the benefit of a call reduction around to help the most people, right? And how do you do that and meet the most needs, right? In times where there's not enough water, we're not going to meet every need, but how do we do it in the most equitable and fair fashion? That's what we would approach it. That's how we will approach it. I think that's how the CWCB will approach it. Yeah, we have to answer to our constituents, and as do you. Your constituents happen to include the Grand Valley and the Front Range, you know, but does that mean we will always side, or that we have a preference for siding with the Grand Valley? No, it means what's the circumstance that warrants this particular outage and this particular relaxation or this particular need, and how do we best tweak it? And I think there are ways to do that, given the size of the river and the different ways that calls operate, where we can meet those needs. We really can. And so it's going to involve a lot of creativity, and that's where setting up that structure for that kind of collaboration is really important.
Could I just give one example of that? And this actually predates the CRCA, predates the 2007 call relaxation agreement. In 2002, which coincidentally was the most significant drought year in the Colorado River Basin, and the year I started at the River District, which was a lot of fun. But the Green Mountain Reservoir Historic User Pool was very close to not filling. And the River District worked, this was, there was no relaxation agreement in place, worked with Xcel, the public service company, the owner of the power plant, Denver Water, other West Slope water users, and implemented an informal relaxation of the Shoshone call for a limited period of time in that year to allow the Green Mountain Reservoir Historic User Pool to fill. Now that provides a big benefit to the West Slope to ensure that that HUP is full, but it also provides a significant benefit to other water users. When the call's off, everybody else comes into priority. And when you fill Green Mountain Reservoir more, that means less substitution water that Denver and Colorado Springs have to pay. So they like it too. So it's just an example of the fact that even in the absence of an agreement, we did that in the past a long time ago. We'll do it again in the future.
Are there other comments, questions? I do have one, and I was going to wait until we were done, but I think this is the appropriate time to to say this because this is what I expect by November. My own perspective of what I want to see by November.
Director Cloud, will it be a question?
Yes.
Okay, just want.
So a quick comment first, because I feel like it's very ironic that we're sitting here in my basin between two sovereign nations and a whole host of other individuals in the basin that do not get water, that rely on water delivery by trucks and whatever else. But we've talked about the basic human right for people, protecting every single water drop, and every drop matters. And what I would like to see by November is there to be an agreement before it comes back to us. Because again, we're sitting in this basin where it's really dry. We didn't get our monsoons until 2 weeks ago. So that's why everything is kind of green. And so I'm asking for the river district, because you've, again, the words of partnership and collaboration, transparency, all those words have come out of you all. I would like to see if it's possible, yes or no, if you can bring everybody back together from both sides and come to an agreement that protects all of Colorado, all of the water users, provide a win-win for everybody. Because we can't have another divide within the state of Colorado. And so I'm asking, are you capable and willing to do that by November?
Well, Director Cloud, I think that's an excellent question. And my answer is we at the River District, and I believe our coalition, will do everything within our power to do that. Collaboration in this instance is more than a two-sided effort. It's, as I think Director Coombs pointed out, we oftentimes have more than 6 front range diverters on the other side of our discussions. So I can tell you that we will do everything we can. And I will also say that we have been doing that. We have been engaged in very good faith efforts, and we have been putting offers on the table and listening to the needs of the Front Range and trying to create solutions for them within the context of the mediation that we've been participating in. And we will continue to do that. But can I guarantee you that we will be responsible for getting all of those parties to agree? I can't say that because I have no actual control or ability on the Front Range to make that happen.
Well, okay, so can you tell me what your definition of collaboration and partnership is?
Sure. My definition of collaboration and partnership is trying to find solutions that meet the needs of all parties.
Okay, thank you. So you say that, but yet you've also drawn the line in the sand with CWCB as well.
The line we've drawn in the sand is one that we have to, in order to, as the donors of the water right, as the contract owners, to protect our interests. Yes, that is our job. We are charged by statute with that job, just as you are with the job at the Colorado Water Conservation Board.
So again, going back to Director Felt's words, help me to understand the scale, the balance of what that means, particularly not just to this board, but to all of Colorado. What does that mean? Because you have, again, your hand in the authority or what you want CWCB or for the in-stream flow, but you're also talking about the cooperation and partnership. Those two don't seem to go hand in hand. So help me to understand what and how that happens.
I do think those two go hand in hand, Director Cloud. I think that the CWCB has the exclusive authority to operate an in-stream flow and to hold and operate that. We're not asking the CWCB to lose that exclusive authority to be the entity to do that. We are asking, under the terms of a contract, to manage that together in a way that is beneficial to the entire state. And we believe that we can achieve that between the operation of the two entities.
Are there any more questions, comments? Okay, hearing none. Thank you.
Thank you.
Before we bring staff up, first and foremost, whoever had 5 PM as their bet, sorry. Not gonna happen. I do find it may be prudent for us to take at least a 10-minute break before staff starts. Because we
Yes,
will also
please.
go directly into deliberations afterward.
Okay. Thank you.
Recording stopped.
Can we please have all our directors come back to your seats?
Last but not least.
Okay, we are missing Director Hawes and Director Felt and Director Gibbs. Has anybody seen Director Felt? Okay, Director Felt is returning. We can go ahead and get started.
Thank you, Madam Chair. Once again, Rob Veal, CWCB staff. First off, thank you to the board for spending all your free time these past few weeks, reading through all the materials submitted as part of this process and actively participating in this extensive hearing over the past 2 days. Also, thank you to the proponents and objectors for presenting their perspectives and concerns. And I thought it was all in a very civilized manner, so that was a bonus as well. So we plan to be concise in our rebuttal and don't plan to take nearly all of our time. But we just wanted to hit on a few items that we heard during the presentations. So we've heard many opinions on the issue of historical use, and you, the board, have asked excellent questions regarding this matter. I think everyone can agree that the water court process will eventually provide resolutions to the historic use analysis. Staff has not taken a position on historical use, but rather recommends accepting the dedication of the acquisition up to the decreed rights of 1,408 CFS. The actual amounts of the water available to the CWCB for ISF purposes will be determined by negotiated terms and conditions, as well as expert analysis during the water court process. There have also been some suggestions from the board for additional items to be added to the ISF agreement, and some of these that staff doesn't have any issue including. First, that the board is not adopting any preliminary historical use analysis as the board's position. Second, recognizing and listing existing agreements in the ISF agreement is something that we can agree to include. Staff does have concerns about including specific terms for those agreements, just so that there's no issue once we get to water court. Third, staff is not opposed to working on a framework for a collaborative process and collecting public input when contemplating relaxation of the call. One thing I want to clarify too is that I believe that the CWCB in-stream flow staff are uniquely qualified to participate in cases involving historic use and historic consumptive use analysis. Current staff have worked on hundreds of change cases as opposers and several as applicants. Our goal as ISF staff in future negotiations on this project is not to maximize ISF use, but rather to be consistent and reasonable in looking for solutions for inclusion of protective terms in future water court case. So staff is willing to work with all parties to come to a negotiated agreement between now and November, and if needed, during the resulting water court case. With that, I have First Assistant Attorney General Jen Mealy.
Thanks, Rob. This is Jen Mealy with the AG's office. I appreciate the opportunity to reiterate my thoughts on the CWCB's exclusive authority. As has been pointed out, the CWCB's statute does contemplate that the CWCB can enter into contracts and agreements for interest in water rights, and specifically Rule 10 recognizes those agreements can limit the board's discretion in protection of an in-stream flow water right. And so the CWCB can delegate certain aspects of operation of an in-stream flow water right, for example, and interests in water rights. There are things that the CWCB cannot delegate, which include holding the in-stream flow water right or the interest in a water right for in-stream flow use, and determination of the amount of water needed to preserve and improve the natural environment to a reasonable degree. We have not delegated those responsibilities here. And whether it's an appropriation or an acquisition, it's no different on that front. With an acquisition, though, when we're using an interest in somebody else's water right, we can accept terms and conditions on the use of the right. We can, for example, enter into agreements to delegate certain operational aspects of the water rights, and we do that with some routine, like accounting, the measurement and recording of use of the right. And this also includes working with an owner in placing a call. The proposed ISF agreement that we have in this matter recognizes the need to have reliable operations of the Shoshone water rights within the bounds of historical use, so within the bounds of the eventual water court decree, but to allow that in certain situations where the River District and the CWCB agree, they would not have to keep that call on. You've heard there are a number of considerations that would go into that decision. So, you know, if it would work that if the CWCB wanted to pull the call back, we couldn't do that without talking to the River District, if the River District and their agreement. If the River District wanted to pull the call back, they would need to get the buy-in from the CWCB. So we are then proposing this provision with the in-stream flow agreement where the CWCB and the River District work together to determine in what situation we wouldn't call for the in-stream flow use when we otherwise could. We have the authority for that type of provision, and that provision is appropriate for this project. Though I do want to say that this type of agreement would not be appropriate for all projects. So I guess that's maybe my, you know, no precedent provision. And that's all I have on this topic, and I'll turn it over to Kara.
Good afternoon, members of the board. Again, Kara Shiel, CWCB staff with the Interstate Federal and Water Information Section and the manager of the state's participation in endangered species recovery programs. I'll keep my comments brief, but we heard today from all parties that the intention of this acquisition is to maintain historical use. And with the respect of the recovery program, that means no additional water would be added to the 15-mile reach, and that we will most certainly continue to face dry times. I wanted to remind the board that submitted with the CWCB staff's pre-hearing materials was a memo on the recovery program's water management and operations in the 15-mile reach. These operations are significant contributions by Colorado through Colorado's water users as a critical part of the state's obligations under the 15-mile reach PBO, and as a signatory to the cooperative agreement authorizing the Upper Colorado River Endangered Fish Recovery Program as the reasonable and prudent alternative to ensure Endangered Species Act compliance. I am available to the board if there are any questions about this or anything else related to the recovery programs, and I'll turn it back to Rob.
Thank you, Kara. And with that, that is the end of CWCB's rebuttal presentation.
Okay. Are there any questions? Director Powell.
Thanks, Rob. Especially thanks for your brevity, but two other things that I think are action items that you didn't mention. And by the way, in terms of the acknowledging the other agreements, I think at least I was pretty clear. You don't have to be specific, just acknowledge that they exist. That was my thought. I'm not the only one on the board, but that's what I was thinking. Second, Andy agreed that in paragraph 6, we'd make it clear that the River District would pay the cost of any infrastructure that's required in response to Director Vasquez's question. And finally, a couple of the Front Range folks asked, and I think Andy in his original presentation agreed that it would be appropriate to say in this agreement, and I'm not quite sure where it fits, make it explicit that by participating in the application, we don't necessarily endorse the River District's historic use calculation, or we don't endorse the River District's historic use calculation. And I think Andy was comfortable with that. I may be wrong. He can give me a high sign. Is that okay? Yep. Okay.
We would just perhaps ask that.
Wait,
Nope, you can't answer questions at this time. I'm sorry. This is only for staff.
yeah.
And
Sorry.
sorry, Director McLeod, you can't recall any other.
I'm sorry. Okay, well, let me handle it this way.
Sure.
You're going to collaborate with the River District to make these revisions. So you work with them to figure out how best to say that, okay?
Yes, and I believe in my statement, I try to capture that by saying that, the board is not, endorsing any kind of preliminary historic use analysis. And
Right,
so we
but
can clarify that.
I think it should be in the agreement, just for
Okay.
safety's sake. And you can work with the River District folks to figure out how to put that in there.
Director Kemlin?
Jen. What I want to address a little bit, and it came up yesterday and today, was possibly limiting the staff during court hearings or any negotiations or whatever. And I think most of it was on historical use, but what my concern is if we direct our staff to stay out of some of this and the court asks them to come actually be involved, we put our staff in a bad spot. Can we, is that wise? Is it legal to say, hey, you can't, be part of these discussions? Or should we even have a directive like that?
I do think it would be difficult to manage that sort of directive, to have staff co-applicants, but not allow them to be involved in certain conversations. This is, this is my opinion, not staff's. In terms of, okay, well, where do they draw the line? Where are some parties going to think that line is drawn versus where staff going to think that line is drawn? And how does that affect their ability to protect other in-stream flow water rights? I'm not saying it's unmanageable. It has the potential in my mind to protect a lot, to result in a lot of conflict between the parties to the water court case about what can and can't be done. That said, I don't think it's unworkable, but boy, it has the potential to be difficult.
Okay, that's what I wanted to know. Because it might send us the wrong message to the court, is what I'm saying, is if we allow that, and we didn't want to put our staff in a bad spot. So I appreciate your answer.
Thanks.
Director Vasquez?
Yeah, I think in previous comments from the board, we were looking for the staff to participate thoroughly in an objective manner to try and get to the quote truth of historical use, but not to put their thumb on the scale on either side. And my question to both you and Rob, is that workable? Is that a workable expectation that we put on staff?
Do you mind if I go first? Yeah. It feels workable, but I want to clarify that in our role in water court, whenever we participate in a water court case, staff will review the other parties' submissions in terms of expert reports and red line decrees and comments, and staff has opinions on those things and will redline and provide their opinions in response. And so while at this stage, the board doesn't endorse any of the reports, once we get into water court, if we do, then they will be weighing in, they'll be expressing opinions on certain other opinions and certain other draft language. And so as long as everybody's clear that that's allowable, then, and what we're saying is, at this stage, we're not endorsing any of the opinions we've seen so far, I think that's workable, but I'll Towards Rob.
Yeah, and I'm not suggesting that we would hamper the staff from taking a strong position once they've done that technical work. It's just going in, you're not going to put your thumb on one side or the other until you have that opinion developed. So
Yeah.
that was a statement, but it's also a question.
Yeah, I didn't have anything else to add to
Okay,
what Jen
thanks,
said.
Rob.
Director Haas.
We talked a bit earlier about the role of in-stream flow staff who have a certain expertise, and then there's the more senior staff who could play a role in helping broker these discussions. And so I just want to also ask a question of Director Riss, is that allowed?
Given that she oversees staff, I think that's more than allowed.
Okay, so do you feel like there's a role for you and your team to play in helping broker this deal and kind of keeping all these interests balanced?
Yes, thank you, Director Haas. I've been quiet, but I've been listening carefully to these discussions. And as the staff director, I feel like I am a party to this case, and so I've not been participating in the questioning. But I can tell you that we have participated in good faith over the last number of years in these conversations and trying to reach a path forward. And I hear the direction from the board through the questions and feel that with the help of the Attorney General's office and the staff in the in-stream flow section, that we are absolutely committed to continuing to work towards a collaborative solution and a path forward for this board when it comes back in November. And I'm committed to participating in those conversations as well at my level.
Can I do one? Do you need anything? Like, do you need additional resources? I mean, this is kind of a big deal, and you don't have to answer that now, but if there's a way we can support you in getting additional resources to help.
Just clones for Rob would be very helpful. But in all seriousness, I think as much direction as this board feels comfortable providing both the staff and the parties as we continue to pursue a path forward over the next couple of months, that will be very helpful towards making some progress.
Director Vasquez.
Yeah, one other area that was actually brought up by Director Felt, and that is the confusion many people have about what CWCB means, whether it's the board or the agency. And I look to you to help craft language in this agreement that clarifies who the actor is that they're calling out.
Understood. Thank you.
Director Combs.
Thank you for being brief. I'm not going to take it personal that it's against my 6 o'clock thing, but I would say, I think when we're talking about direction of the staff and how we work through this, I would ask it, and I don't ask this thinking it's not going to happen, but I think just to remind us of a priority of CWCB, whether it's the board or the staff, is to work for the true intent of an in-stream flow, right? And to really separate ourselves from, the warring factions here. And we protect the integrity of what that was designed for. And we don't let it be abused or misused. I agree with flexibility of it, but I think the role of CWCB is not, like you said already, not to take parts, but I think, is there a way of staying in that space? I don't know. Sorry, Jackie, I don't know how to ask that, but I'm just asking, how do you see a plan forward to be able to work for what CWCB's goals are in the midst of all this? Is it going to be possible? Do we need to give more clear direction, more specific?
I think I have an indication of the direction you guys are already providing. I don't know that I necessarily have a plan forward at this exact moment of how we can accomplish all that in the next 2 months. But as Director Riss said, we will try our best to accomplish all those goals.
Thank you.
Any other questions? Hearing none.
Wow, 5:20.
We're not done.
Sorry,
Please-
Nathan.
Please don't jinx it, Director Vasquez. Before we close the record in this case, or vote to close the record to go into deliberations, I wanted to give Aurora the opportunity because they were trying to gather information in response to your question, Director Vasquez. Do we have anything from Aurora at this time? If they may come up, say yes or no?
I did get some information from our planning people. I was going to look at it to see if I thought it was responsive. I'm simply going to forward it to the hearing officer. I'm not sure it's responsive to your question. So I'd like to have the ability to perhaps supplement that later next week, but
I will allow a supplement if Director Vasquez says it is not responsive to her question. Because
Okay.
we normally do
That
not
sounds like
collect
the
any
plan.
additional evidence following the closing of the record.
okay.
Thanks, Alex.
Yes.
So Alex, I'm so sorry. If you could just forward me that email and then we will review it and determine if that's necessary.
Perfect. Thank you.
Okay. So at this time, a member of the board may make a motion to go into deliberations. I will not be policing you anymore to ask questions. This is your time to discuss your thoughts, your interpretations with each other of what you have heard and what you believe is necessary to discuss on the record. Yes.
And just to clarify one more time, what this means is the board can no longer call witnesses, staff, or otherwise up to the table to answer questions.
Correct. No
So-
one.
Maybe one last call.
Yes. We're going to take a vote to close the evidentiary record. Because this, just to be clear, the evidentiary record is closed. You will now go into deliberations. That will still be a record of this hearing, but you will not be collecting any new information until November on your direction on if you'd like to see stipulations or settlements. We're going to go into that in a moment as well. So
Then, okay, one clarifying. So once we finish deliberations, is there another motion just to hold it, or we close it at that point?
So after deliberations.
Okay.
What will likely happen, because we have the extension that was granted by the River District, we will pause deliberations until November. That does not mean you can collect any new evidence. That does not mean you can talk to the parties. That does not mean the parties can talk to you or collect any new evidence.
Okay.
We will be in deliberations. The evidentiary record is closed. The only way we will reopen the evidentiary record in November is if we see some level of settlement agreement, a stipulation, or the board here directs the parties to bring something back for consideration in November during this deliberation. And I want to make it clear to the board and to the parties. A settlement does not have to be comprehensive and unanimous to be a settlement. There are such things as non-comprehensive unanimous settlements or non-unanimous comprehensive settlements. Sorry to go into my lawyer world. There also can be stipulations amongst the parties that they agree on one issue. Let's say 5 of the parties all agree, they're not going to keep raising that issue. So I want that to be very clear to everyone here today.
Thank you. I do have one comment before we go into a vote.
Please.
I just want to ensure that we are all working for the future of Colorado and for our environment, for our future, because again, we're not going to be here forever, and our decisions that we make today will be long lasting and they will outlive every single person in this room. And so I'm asking, as we move forward, for everybody, board member or staff member or whoever else is in this room or listening to this meeting, be a good ancestor for our future generations so that they can look back and know that we did the best and we made the best decision for them and for Colorado. Thank you. So with that, I'd like to make a motion to go into deliberation.
She may. And to be clear as well, the only folks that are voting to go into deliberation are the voting members of the board. Should you have a clarifying question of any of the other non-voting members, they've heard this whole record, please invite them into the conversation even though they are not voting. If you have a question on their expertise. Just wanted to flag that.
I'll second that.
Who's making the motion?
You did.
Oh, I
made it. You did. I know it's late.
Okay, all right. Lorelai made the motion. Director Camblin, second. Is there any discussion? Okay. All those in favor say aye. All those opposed? We are now in deliberation.
Thank you. Viola and Anna, can we put the, are my slides up? Wonderful. So I just created this slide and another slide. I think this is the only slide we're going to be talking about today, related to what this board is required to do during deliberations. As you've heard from multiple parties, Rule 6E requires an evaluation include the consideration of these factors. It may be prudent at this time to walk through these factors and determine which ones are not contested, so we don't have to come back to them in November. Those things can be decided today, and we can show that there was a discussion on all of the factors following today and November. So maybe we can start by, Director Cloud, if you want to talk about the first factor and whether or not it should be discussed today, the board can decide in its discretion.
Can we pick sub-bullets of
You
number one?
absolutely may.
Okay, thank you.
Anybody want to go first?
But location is clearly not contested, right?
Okay. So historic location of return flow is not contested.
And the length is not contested from what we heard today. Does everybody agree with that?
Members of the board agree. Okay. I think that would be
Okay.
best. And you could say, we'll reserve this one for November, but yes. So the next sub bullet would be whether an existing in-stream flow rate relies on return flows from the water right proposed for acquisition.
What does this board want to do? You gonna hold that for November, or do you want to deliberate that?
It seems like the answer depends upon whether Shoshone is operating or not.
So that might be one to hold for November.
Okay. Do you want to, do you have discussion about that?
Sure. Not, Director Oz is nodding.
Use your,
You have to
please use your microphone, please.
Yes.
Use your mic, use your mic.
I'm sorry.
It's okay. Can you ask the question again? And then,
I asked, is there an in-stream flow on the main stem below Shoshone? That would be a simple way to look at it. A more complicated way would be to think about how it affects in-stream flow rates on tributaries further downstream.
sure. And Director Hodge, you may
and-
absolutely answer that.
And what I understood was, yes, there are main stem flows, so that simplifies, I think, the answer.
Sure.
The answer is yes.
I
It seems to me.
And there's some upstream too that.
Sure. I think we all heard
also
that
had a
today, but
point on that. Okay. There's some down at the 15-mile reach, so. In between, yes, and upstream.
so it sounds like there may be some members of the board that do not believe this needs to be held until November. Does anybody have any concern of discussing this any further at this time?
Nope.
So it sounds like the board is in agreement that this has been considered and we do not need to revisit it in November, just to be clear. Okay. Next, the environment to be preserved or improved by the proposed acquisition.
Yes,
I think that one was on.
that one was like the one non-disputed thing.
Right.
Sure, okay. Does everyone agree? The board is nodding, okay?
Use your microphone so we can have it
No.
on the record, please.
Yes, would love the microphone.
You can't have head nods on the record.
No.
That's why I'm narrating it, just so everyone knows. It's not because I don't trust you all. Okay. We talked about the environment. Are there any other factors the board would like to identify at this time that they would like to discuss? That says such other factors as the board may identify, so.
Can I go to 11?
Sure.
We jump.
We can absolutely jump. I mean, I'm just going in order to ensure that we don't miss one.
We can do that too. We can.
Yeah, let's
you
just
wanna
go in,
pick-
we can
okay.
go in order.
Okay,
please.
because it gets more complicated in the middle. That's what.
I completely understand, but that's why we may also not deliberate on those factors today.
Right.
Okay. The natural flow regime is the next factor. Do board members have comments at this time on that?
So to be clear, if we are agreeing that that's still for discussion, we would only discuss it in November?
You can discuss it now, but you should, my recommendation is if there's something that needs to be discussed in November, that it should be discussed in November, but if there is something on your mind now that you'd like to bring up, please do.
I need to understand that the relationship between natural flow regime and historical use.
Okay, so maybe that's something we
The
can,
technical question, perhaps our friend from DWR can answer.
and that may very well be, and that could also be something that you direct the parties and staff to clarify by November.
I'm just wondering if Director Ullman can clarify that.
Well, I think there should be some clarification, but I think having staff help educate the board on what that means would be very good, regardless if any of us know what it is.
Sure. Director Ullman, I think we may hold off on that then. There may be a question that's also related from Director Felt before we get there.
Well, just to clarify what we're doing here, I'm not sure that we're necessarily saying that we absolutely arrived at a conclusion on each of these factors, but that we evaluated them.
That's absolutely correct. That is what you are charged with doing, sir.
Yes, so when it just says number 2, natural flow regime, I would suggest that we certainly considered that in our evaluation over the last couple of days. Whether we have established exactly what we think about that, I don't know. So I'm a little bit, I want this, I like this checklist idea, but I want to make sure that it's worthwhile.
That's totally fair, sir. And what I'm trying to decipher with the board at this time is whether or not we need to revisit some of these topics in November for you to make any level of decision on them. Again, the rule requires you to consider them. We are going through them now to show that they were considered. I'm also, if you notice, asking the board, should we revisit this in November? Are there directives that you would like to give staff and the parties related to any of these factors?
So we could check a box, but also say we want to talk more about it. Yeah.
Absolutely. That's the goal. But I think until we've hit this particular factor, that all the factors that we have already checked off, no one has had any additional direction to the parties on for November. Am I correct in that? I see members of the board nodding until Director
On
Hodge
which,
her mic.
can you say that again?
Sure. So up until we've gotten now to number 2, natural flow regime. From number 1 and its sub-bullets, my understanding from this previous discussion is that you not only checked the boxes saying that these were uncontested issues and we have considered them at this time, but that you don't intend to revisit them in November.
Correct.
Is that correct? Can we take a motion on that just for clarity in the record, because there seems to have been some confusion?
Or the vote?
A vote
We don't really need a motion.
is factor 1. Thank you. Yeah, we don't need a motion at this time. Is factor number 1 now considered to be completed for discussion of this board and will not be revisited in November?
Put to bed.
Yes.
I have a question, I'm sorry.
That is quite all right, Director Sandlin. Please do.
So the last bullet, such other factors the board may identify.
You can identify those at any time, sir.
Okay,
That's fine.
if we can do that, then I am okay with saying we're done with 1.
Thank you.
I'm done with 1.
Yep.
Yes. Thank you.
Yes.
Yes.
But let's say hypothetically, so some new information comes up in the next couple of months. Are we taking this off the equation to not talk about it all in 2 months? Or just,
Unless something comes up in a settlement or stipulation, that's my understanding that the evidentiary record before this board is now closed and we will not be considering new information.
okay, I guess maybe, but I mean,
Well,
a lot can happen over the next couple of months. And, I think we should keep our options open and.
to be fair though, sir, the record is closed now.
Right.
Only for very limited purposes.
Yeah,
will
but
we-
it's for us to contemplate these issues.
Yes,
Yeah.
but if new evidence comes up, we would have to figure out because,
We'd have to go back through this whole thing.
Right.
or we'd have to give the parties all the opportunity to evaluate that new evidence,
Right.
comment on that new evidence, and then admit that new evidence into the record.
Right.
So the administrative record is now closed, but for specific things that we account for. So if we want, it's too open-ended, in my opinion, to hold something that may not come to fruition, of new evidence arising to these factors at this time, because that can happen at any time. New evidence could have come out yesterday, and we can't account for it in the administrative record now. Okay.
Yeah,
No.
go to the next one.
Yeah, so natural flow regime, to my understanding, there may be some direction from the board for additional information on.
Yes.
Can we, for the record, ask for that additional information again? Okay.
We would like to have more additional information on natural flow regime.
Do you have any further detail to add
I-
to that directive to the parties and staff?
Dr. Hawes?
Yes, I would be curious, what is the role of the natural flow regime in these factors? And I mean, it doesn't say what we're supposed to do with natural flow regime. So, and again, how does that relate to the next question of historical use?
My understanding, you are supposed to consider that and historical use in whether or not it is appropriate for this board to acquire this donated water right. But you don't have to come to a final determination, just like you have to come to a final determination on historical use. These issues are all going to be discussed and determined through the water court
I
process.
totally agree. That's my question, is what is our role on this issue?
Do you need further information from staff or the parties to feel as though you have fully considered this factor? And what would that additional information that you need be?
And if I could ask, you mean fully considered with the information we've received to date,
Correct.
right? It doesn't address the question of whether the record is opened up again and there's new information that comes.
However, if you feel the need for additional information, that would be something you can direct staff to bring you in November. That's the point of this.
Yeah, and I guess personally, I don't think I need more information. We've heard a lot, so, but on both
And
these
I would
two.
agree with that, yeah.
Yeah, so I'm not sure what is left to consider.
Well, I'm just wondering if we might do something that will sort of help orient the board members. There are also findings that the board has to make that are separate from the factors that the board has to consider. Do you
Yeah.
want to walk them through that, Jackie, to
Sure.
explain the difference between what they have to make findings on and what they have to consider?
I think that's great. If we can go to the next slide, that would be very fantastic, because that's the next slide. So my apologies. So pursuant to statute and pursuant to the rules, this board has to make certain determinations. The determinations are separate and distinct from the consideration, but the consideration informs your determinations in the future. My understanding of where this board intends to go today is that they are not going to make these determinations on the record at this time. They are going to deliberate in November to determine these 3 bullets under 3792-1023C and under Rule 6E, how to best utilize the acquired water rights or interest in water to preserve or improve the natural environment. So those determinations are not being made today, is my understanding of where this board intends to go in November, because we want to see if any additional resolution comes forward. Scott, do you have anything to add to that?
Just to bring it back to the first slide. So in making those determinations, the board is supposed to consider 11 different things. And those are the 11 different things that are on that first slide. There is no requirement, as I think the hearing officer reads it or as I read it, that there are specific determinations made on those. It's just necessary that we show on the record that the board considered all of those things. And so this process right now is helping us go through, find out if there are things that the board has already considered or that aren't contested that we can say, we don't need to go back and have deliberations on to help get to these determinations.
Yes, Director Phelps.
So it's just a much lower bar.
It is a much lower bar in the respect that you don't have to come to a conclusion on whether or not that factor is satisfied. It is whether or not you feel as though you have enough information to have considered the factor to ultimately make this determination.
And in my mind, implied in that is that we are relying on the witnesses to provide adequate information to consider.
You are absolutely correct.
So the issue that I think we're all grappling with is, but there's a lot more information out there, right? About some of the 11 factors, but that's not the point.
That's the point.
Were we given enough, did we do a good enough job with this hearing to be able, and were our witnesses adequate to allow us to have considered each of these points? If there's one that we didn't consider at all, that's something we have to deal with.
And that's something that can also be addressed in November.
Yeah,
Yes.
exactly.
Director Ruiz.
I'm sorry, I really don't want to confuse things any further, but the first bullet there, I'm certain is related to appropriations and
Correct.
acquisition.
So my apologies, I should have
Okay.
deleted that one. I just copied that particular section of the
Okay.
statute. So there's really only two. I can revise that
Okay.
and take
So the
that.
first one is not applicable.
Yes, my apologies. There should
Okay.
have only been three total, not four.
And then just to clarify further, those are the items that would appear in the staff's recommendation that the board would be required to vote on.
Yes.
The factors, we sort of did a straw poll earlier, trying to determine what issues we would categorize as having been considered, because
Yes.
that is the requirement of the board, not that we're voting on those for the record or as a requirement, but rather just as a means for advancing the conversation.
Yes.
Okay.
And my apologies for accidentally leaving that bullet in.
No worries. Thank you.
We can go back to the factors slide. There's only two slides. Only two slides. So I hope, I understand that this is complicated. I completely understand this board's need to get this right because it is an incredibly complicated matter. But I want to remind you, and this is something we started talking about back in May. 6E's factors are truly to help support when you make that determination. Do you feel as though you have questions? Do you feel as though you did not receive adequate information related to these factors? That's what we're trying to figure out right now on the record. So to natural flow regime, which was starting to be a sticking point, do you all feel as though you received adequate information to consider that factor when you are making a future determination?
Yes.
Yes.
Okay,
Yes.
thank you. I want to remind everyone that number 3 is a very contested issue. That is any potential material injury to existing decreed water rights. I will note that I think you all heard a lot about this on the record. I do believe this has been considered by this board.
Yes.
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 However, do you feel as though you need any additional information or do you have any directives related to material injury that you would like to see staff discuss or evaluate for November?
I think the consensus is the water court will make this decision.
I agree with you, sir, yes.
I
So,
don't think we need any more information.
okay,
We considered it. We heard lots of evidence about it.
yes. Yes, Director Fell.
I guess, but I would add to Director McLeod's comment that if we are going to direct staff and direct the parties to work, to negotiate, which I think we are, that would be a critical element for them to work on as well.
It's not our call. I mean, yes, we hope they will.
I mean, it's possible that there's a settlement. That's what I heard, that there could be a settlement that would basically eliminate the need for the entire water court process. A
But that
full
will
water court process.
reopen the record.
In which case, we will reopen the record
Right.
and consider the settlement.
Yes.
We're just talking
Gotcha.
about status quo right now.
Okay, thanks, John. I got it.
Yes.
I understand. Thank you.
I want to clarify one point on this piece because I heard the board ask a lot of questions and I heard the parties speak a lot to these external agreements and how they could potentially impact this factor. I also heard representations from the parties that maybe we list that these exist. I would like to ask the board, is there something you want to see in either the ISF agreement or in November related to those documents? The last thing I heard was that we wanted to list them out to show the water court they existed. Is that the direction of this board?
I'm okay with that. I will say it's complicated and there's probably other agreements. I mean, there could be more than have been mentioned here.
Sure.
Okay.
And that's again, I
Or
think that
ones
this
we
is-
just heard a little bit about.
I think Director McLeod's about to say what I'm thinking, but please do so.
Well, but the staff is going to bring us a revised in-stream flow agreement in November. And at that time, we can figure out if they've done what we want them to do. I told them what I thought they ought to do, but I don't know if that's a consensus, but we'll see this revised agreement in November and then we can decide if these factors are addressed.
And Director McLeod, I think that's exactly what I'm asking the board to comment on, your proposal of how, do they agree that that's what you would like to all see in November? Could you please restate your request? Because I heard you give that direction, but I did not hear the board all agree to that direction, which is why I'm raising this now.
I agree. I'm the one who said it. I didn't hear anyone. I didn't hear anyone disagree, but they can now, of course. But
That's what this time is for, sir, yes.
but my thinking is whether that's accomplished as I addressed it or not is going to depend on the revised draft that they bring us.
So,
At that point, we can take it up,
yes.
right?
So is the board directing the staff as a whole, not just under Director McLeod's suggestion, to revise the ISF agreement as he is suggesting? That's, I believe, the question before this board.
Yes.
I agree.
I would be a yes.
Yes.
Director Hawes?
I think so. I don't remember what he said exactly. I don't. Can you restate it, sir?
Sure. I asked the River District folks when they made their direct presentation if they would object to acknowledging the existence of these agreements. And I asked the staff to put that acknowledgement in the in-stream flow agreement without specifying which agreements we're talking about, just acknowledge that they exist. And the River District folks said they would be okay with that, as I understood their answer.
Is that what you're talking about?
That's exactly what I'm talking about.
Okay, I'm okay with that.
Okay, and to clarify, so you're not proposing listing the oh, okay.
That's also what I was trying to get clarity
Yeah,
on for the
I
record.
was confused. Okay, I'm okay with that.
Thank you.
And Director Felt, you're okay with that as well, too? Okay, thank you.
Thank you. Okay, so we have one directive. So that's a good example of something that you might want to be directing staff on that came up in discussion today. Because you all couldn't respond to each other's suggestions during the hearing. That's what part of this is for. Okay, we talked about number 3. Number 4, historical consumptive use and historical return flows. I think we can say that we heard a lot about these issues. Does the board have any direction to staff on how they want to move forward in the ISF agreement, in water court? These things were all asked, but I want the board as a whole to discuss them and vote on what their ask is for perfect clarity. Director Combs.
So on this one, I think we need to be very clear of where we're gonna put our staff, because I don't think as
Yes.
a board, we have decided that. We've heard objective, we've heard neutral, we've heard yes or no, but I don't think we've been clear of what we're asking the staff to do. And so I would like to have some discussion on how do we want them to proceed? I think Jen did a good job of saying we don't want to put them in a difficult position of being a party to the case, but being muzzled. So I would like them to be objective, represent the integrity of what the in-stream flow is. Maybe not have to get too heavy into how we're gonna calculate the average consumptive use or average historical use, but if I heard Rob correctly, he thinks they're very well, they're very capable of wearing that. So I would like to have them not really bound. I think we can trust them to not put a thumb on the scale. And so I would like them to be, I'm not just saying run wild, but I think we can trust them to know their plight. They've been here for this discussion and they know what's at stake, so. I would like the staff to be involved in this, the calculations and assessing which is the best methodology. That's just start the discussion.
I would support that. I mean, I think they're the experts. They've done more of these than anybody else in the state. So knowing what's possible and not possible is absolutely within their experience. And I heard pulling back from neutral. So I don't think that was on the table
Objective
anymore.
was the term.
Objective, yeah.
Yes.
I have a question. So on this one, I mean, even if an agreement is made before a vote or whatever, and they come to a, you know, a proposed historical consumption, it's still going to be determined by the court when it goes to court. So my recommendation would be that they follow the court rules. But I mean, you know, I'm a little like Director Combs is that, you know, they probably need to be part of that process to a certain extent, but the court is going to actually dictate that. Am I wrong?
I don't believe you're wrong, sir. I think all the parties on the record agreed that no one is asking staff or this board to endorse either historical use analysis. However, I think the question that has been posed to this board from multiple parties is, do we have direction for staff at this time on how they should be moving forward for November and how they should be moving forward in water court? You do not need to decide now on a position in water court unless you have one.
Could I clarify what Director Camblin,
Yeah.
he's right. The court will decide, but my direction is, I think as we're working through negotiations, they have to be active in that. And absolutely abide by the court, but I think they have to be active and engaged if we think there's going to be a settlement made, right? Without having to go to water court for everything, just for kind of a confirmation or a stipulation on what the methodology will be. That's what I was proposing. We abide by the court, but in the spirit of trying to get to a negotiation, they can weigh in.
Director McLeod.
Well, you're missing my point. As far as the negotiations go, absolutely. What I'm talking about is once they get into water court, if that's what happens. Because evaluating the historic use, the contest is going to be which assumptions are most accurate. And I don't want, if the judge says, Rob, what do you think is the most accurate? He would have to say, we take no position. That's what I'm gaming for. But in the negotiations, absolutely, everything should be on the table, and the staff should participate, and Jen should participate actively in all of that. That's not my concern. I'm concerned about once they're in water court, that we somehow throw the weight of the state, is the way people have characterized it, between one assumption or another. That sound fair?
So if I'm understanding you correctly, you're saying when they get to court, you'd like them to step back a little bit more?
Right.
Okay.
We will take no position on which method is appropriate for calculating historic use. And I think they can do that quite easily. You can say the judge, the state takes no position on that issue. And that's not complicated.
I'm a little confused by that, because if we're saying we feel that the staff is where a great deal of expertise lies, can you see a method for them to participate, not endorsing one or the other, but their own view of what would be the best set of assumptions?
Well, but see, what that means is we have to do our own independent evaluation.
I see.
And I'm not so sure the in-stream flow staff that's their expertise. And they could correct me if they think I'm wrong, but if they wanted to come up with their own opinion, I think they'd have to have their own expert. And I'm trying to avoid that.
I got it. Thank you.
Well, just for clarification, I agree with you, Director McLeod, I think that is probably gonna be the best strategy then, is for negotiations, they can work within both parties to negotiate. But when it hits court, they could probably pull back the no position and let the court handle that. That doesn't bother me. I'm comfortable with that, I guess I should say.
I'd be interested to know what staff thinks of that, going into court, and perhaps we can put that on hold and just make a determination here about advice for the negotiations that we hope will result in a compromise.
We can absolutely limit the directive to staff for November. So if someone would like to clarify that for the record, I think Director Combs had the initial ask, seems to have been clarified slightly.
So can I then ask for a direction for staff to participate in the negotiations as far as how we're gonna look at the historic use? But then when we get to court, they could pull back and have no opinion on how the water court does it. Is that the language you're looking for, or?
Yep, I don't think we're even going to talk about water court right now is what I'm hearing
Oh,
from
okay.
Director Vasquez. I think we're just talking about what we'd like to see in November.
Okay, perfect. So to November, that's got it. Thank you.
Okay. Does everyone agree with that?
I agree. I agree.
I'm okay with that.
Okay. The next factor, the natural environment may be preserved or improved by the proposed acquisition, and whether the natural environment will be preserved or improved to a reasonable degree. I think we also heard a lot on that.
Yes.
My understand, check. Does anyone have anything to add? Do we feel as though we have enough information?
Yes.
Yes.
Check. Wonderful.
Yes.
Guys, we're going more than halfway. We're getting it. Location of other water rights on the subject stream or streams. And again, we know this is on the Colorado River. I think you've heard information today. Yep.
Check.
Wonderful. No additional information needed. Great. Number 7, effectively proposed acquisition on any relevant interstate compact issue. I think you've heard some information on this. You received it from all the parties. Do you have any other clarifications or directives?
Well, Director Ullman made a comment earlier that we were gonna bring up here about the role of historical use and the role impact on a compact.
Go for it. That one's good.
Okay, just making sure.
Thank you.
Yeah, we had talked a little bit about the historical use, and I just need to make sure that I make it clear that it would be inappropriate for me to comment on any specifics about the historical use analysis, partly because as the state and the division engineer have a unique statutory role in the water court process. But I think that there was, Director Combs earlier raised a question related to whether this change will result in more water leaving the state and affect the ability for Colorado to put its apportioned water to beneficial use. I think that was the tenor of the question. The 4 upper division states, just be clear, are currently using significantly less than their compact apportionment. But the outcome of the water court case will have an effect on the likelihood that historic flow patterns downstream on the Colorado River, including to the state line, will continue under the changed use. Obviously, after the 2 days of testimony that you've heard, it's clear that there's a disagreement on how to arrive at what that historical use pattern is. But I guess my comment previously was just to highlight that this is another reason why the historical use analysis is important to get right. Is that?
Does the board have anything they would like for November? Okay.
Check.
Check. I
Okay
see
with it.
no opposition from any board
Check.
member. Thank you. All right. Number 8. Effect of the proposed acquisition on the maximum utilization of the waters of the state. To my understanding, you have heard about this factor. Okay.
Check.
Yeah,
Check.
Okay, understood. Any directives to the parties or staff on this particular factor? No.
No, doesn't sound like any.
Okay. Seeing none, moving on to number 9, whether the water acquired will be available for subsequent use or reuse downstream. Check.
Okay.
Check.
No questions.
Excellent. Any,
I just want both, right?
any additional directives to staff or the parties for November? Seeing none. Number 10, cost to complete the transaction or any other associated costs. I believe you've heard quite a bit about. Can we put the mic on, Director Vasquez? Sorry.
Dr. McLeod, can you review your directive regarding the cost of any infrastructure?
Right, I don't think that directly relates to this item, but yes. In response to your question, Mr. Mueller said the River District would pay the costs of any additional infrastructure, and I just asked if we could change the agreement to say that, and everyone agreed that would be okay.
Does the board agree
So-
with that direction?
I-
To put that in the agreement?
I didn't hear that they would pay the cost on any infrastructure. I thought it was just if they needed more measurement near the Shoshone gauge,
That's what I heard too.
Well,
not any infrastructure.
that's a more accurate statement. Thank you. You're right.
So to that point, does the board agree to ask inclusion for that language in the ISF agreement?
Yes.
But I
Yes.
think that's for 11, isn't it? The administrative,
Wouldn't it be both?
you think it's just cost?
Yes.
Okay. Personally, I see Director McCaw's point. I think this one might just be a directive period and might not even necessarily fall under one of these factors, but it's good that we're getting it on the record that we all are agreeing that this is something we want to see changed in the ISF agreement.
Yes, and I would clarify that that there's differences of where where the gauge could go, and it seems like there'll be a need for some kind of analysis, because we heard that it can't go below the dam because of the boulders, so where would it go? Would it be upstream? I just think there's a determination that would need to be made of where.
Fair.
So that might be additional analysis.
So that might be something you would like to see for November as to where that
I
would
needed
go?
to make the decision, but just.
Okay. So let's just note that,
Well, I would think we would, by November, at least have an idea of what would be proposed, whether it's gonna be in the tunnel, whether it's gonna be on the dam. I just as a
Many
proposal, not as a
gauges and-
decision, what
yeah,
do they think
fair.
would be needed to accurately? Just so otherwise we leave it open-ended to the river district, like we're gonna, fly a plane in there every day to measure, I think we gotta have some kind of quantifying.
Okay.
So I would like to see what proposed measurement device could look like by November
okay,
at that location.
so let's revise the ask then to Director Combs's ask of what would the measurement device look like, and language to the effect of that the cost of the measurement device will be covered by the river district. Is that fair?
Correct.
Well,
That's
not
a
so
fair.
much, when the look like is, I think rephrasing that, because what would the plan possibly look like? Because they could just like describe it.
Right.
Not just like give us more information, because I think asking more information, like the placement of it.
Okay. Director McClellan, please.
Well, the current draft of the acquisition agreement in paragraph 6 is pretty detailed about what additional infrastructure I'm talking about. The only thing that it doesn't say is who will pay. And so I'm just saying, add that particular sentence to the existing paragraph 6. Paragraph 6 talks about exactly what might be needed as a result of this change. I'm just saying, make it clear they've agreed to pay for it.
Does everyone agree with Director McLeod's?
I agree with
I
that.
think Director McLeod's right, though.
Okay,
Nothing.
everyone?
I agree, and my recollection was something Andy said that basically acknowledged that it could be, a difficult gauge to install, but that they were acknowledging that they were gonna do what was needed.
Understood. I saw some head nods from other members of the board. Yes, Director Vasquez, everyone is nodding. Okay,
Yes.
that directive unanimously is going through. Last but not least, the administrability of the acquired water right when used for in-stream flow purposes.
Check.
Yes.
Yep.
Any other directives on that one or a need for additional information? Okay, So we have now on the record, for the administrative record, gone through.
Wait, sorry, before you close that up,
Go for it.
would this deal with what we're talking about, language of what that partnership looks like? Or is this strictly DWR's administrability of the acquired water?
I believe it's DWR's administrability.
Okay.
Given the statutory provision that allowed for Mr. Heath to come and speak to you all on that particular factor.
If that's the case, if it's DWR's, then I agree with that completely.
Wonderful. So just for this record, we have now considered the 11 factors. I wanted to note, are there any additional directives, and Director Coombs kind of laughed me, for what they would like to see from staff or the parties by November? Director Vasquez.
Yeah, I had two. The first one was to make explicit in the agreement, whether we're talking about the agency or the board, where CWCB is used in that language.
Members of the board agree.
Yes, I agree with that.
I would agree that if it matters. If the ultimate authority lies with the board and the execution lies with the staff, I don't know that that's necessary. I'd like an evaluation of, is it necessary to differentiate between staff and board before we mandated it be included?
Director McLeod.
I think anything that makes Director Vasquez comfortable is appropriate, but no, I'm serious. I'm serious. But it seems to me that CWCB as an agency, the board acts through the staff. So the staff are the people who do the active work, on the ground work. So that's who this agreement addresses, in my opinion.
My only concern is if there's language where in this co-management where a decision needs to be made, whether that involves the board or whether it would be the senior staff at CWCB who would be involved. So that was where my concern arose in asking for clarification.
I'm okay with that.
I agree with the way it's explained there. Yeah.
I agree as well.
Everyone is agreeing. Director Felt, are you raising your hand or agreeing?
I'm agreeing, and then I was raising my hand for another comment,
Sure, please.
if we're there.
Yeah.
All right, well, some direction to the parties, not just staff, but to the parties. You have to figure this out. I'm serious. You have to figure this out. And I'm not at all confident that it will all get figured out by November, but I think it's worth, this is another one of those things that hasn't maybe quite been said, but it's okay with me if it takes longer than November. Obviously, the River District, as I understand it, would have to extend this process again, but this is so important. And there's just so much at stake here that I think, it calls for the contemplation of extraordinary measures or circumstances. So that would be one thing. Another thing I would say to them, not to complicate this any further, but sometimes there's an element of this that feels sort of zero sum when you're talking about two sides of the divide and trying to figure that out. There's a couple things you can do though to help get through situations like that in my experience. One is you can introduce additional elements to the negotiation. And so that everybody knows that intuitively, I think, but I just want to say it clearly that is a strategy that shouldn't be ruled out. There may be other concerns that can be introduced that would help bring everybody to, to the signing of the agreement kind of thing, or to a place where everybody's on board. The third thing that's related to that is, Kirsten comes to mind when I say this, that there's incredible principle at stake here, no doubt. And right with that is water. They're intertwined in everyone's minds and hearts. It's also true, though, that money is a tool that can be used sometimes to help smooth out some things that can't be equated. And I'm thinking of this relaxation concept, and I'm thinking of SCPP as an example, which I think a lot of people know I don't like SCPP, but the idea that in addition to just out of goodwill helping other entities, other interests in the state, that one could consider some form of financial mitigation from that aided entity, and that there might be entities that could be injured that could benefit from funding, just as SCPP allows people to take a time out and reorganize their ag operation or work on drought resiliency or things like that that we've discussed. So I don't want to bring this down to the level of money. That sounds like I'm polluting the conversation in some way. That's not my objective. I just want to get it on the table that we've got some entities that have tremendous budgets, and we have other entities that could suffer some reduction potentially, and money could be a way to resolve that. So just don't want that left unsaid. I think it's a reasonable thing to consider. So those are my points. Those are my thoughts for all the parties on trying to work this out.
I also wanted to direct staff to, and others to get to an agreement by November. I mean, there's so many parties to this, so many different factors, and it shouldn't just be left up to us to make that determination in November. Again, there should be a win-win solution for all of Colorado in this.
Yes, Director Vasquez.
Yeah, if I can step back to things we've asked staff to do, that is to work on language about this co-management and to try and come to an agreement on what that looks like in detail.
And all the board members seem to agree on that.
Yeah, and I would just add, yeah, it feels like a process needs to be fleshed out. So it's not just, so it's,
right.
Yeah. What would that look like and what are the details?
Right. And as our chair said yesterday, to leave nothing to assumption or something like that.
Nothing should be implied.
Implied, to try and get it, that there's such a balance between being prescriptive versus leaving things open-ended for flexibility. And I trust that the staff can work with CRD to find a middle ground there between those two poles.
Understood. No one objects to that inclusion, correct?
No.
No.
Good.
Okay. We're to take the 6 factors down. I mean, the 6E factors, excuse me. We'll consider them. Is there anything else this board would like to comment on, discuss with one another based on the record before them? Lauren.
If it's appropriate, I would just like to thank all the board members and frankly, everybody in this room for their stamina and their engagement on this. I mean, up until the very end, you all have asked really good questions and had really thoughtful comments. And I just want to recognize that we've all been sitting here for 3 days. And that feels physically difficult and mentally difficult. And I appreciate all the effort that's gone into this conversation. And I also want to recognize that I hear all the direction you've provided to staff and commit to work on that in the next 2 months, and know that we have some of the smartest water minds in Colorado involved in this issue. And we've done it before, and I think we can do it again. So just a big thank you to everyone.
Director Vasquez.
If I might add, there's a benefit to having uncomfortable chairs. It keeps everybody awake.
So, and
You might as well be engaged if you're awake.
Director Riss, I'd like to renew the tradition of providing chair pads to the board for every meeting.
Yes, we could put our logo on them.
So I have a technical question before we end, because we didn't adjourn the CWCB meeting.
We will do
Correct.
that following the end of deliberations.
So we'll vote to pause the deliberations, and then vote to adjourn.
That's correct.
Okay.
Is
Thank
there
you.
any further discussion this board would like to have on the record that is before it at this time?
So before I comfortable ceasing all deliberations in November, how much discussion would be allowed? Just as a reminder, I mean, staff is going to be involved in the negotiation on it, but the board won't be quite as on that level. So just as a refresher, just to get us back in the, I mean, are we, yeah, I mean, because we read the materials, we do that, but is there an opportunity for just a slight discussion? What's appropriate?
So I started to talk about this yesterday and I'll reiterate it now. If there is new information such as a stipulation or a settlement or a revised ISF agreement, like what you have all asked for changes, there will be an opportunity for all of the parties to comment on those documents, file written testimony in support of or in opposition to those things. You will then be allowed to ask them questions on those documents. However, once we go into deliberations again, the entire record before you is up for discussion. So I just want to make that very clear. But you will not be collecting any new evidence but for the result of this mediation, if there is a result, and what you have asked for today.
But-
And potentially the supplement from Aurora.
So then if I'm understanding you in really immature terms here,
Go for it.
when we meet in November as a board, we can continue to discuss and deliberate. We just can't ask for new information.
Yes.
And then we make, okay. 'Cause that's what I'm more important to me is to be able to discuss with the board and make
Absolutely.
in open record, make sure where we are.
Absolutely.
Okay, thank you.
I looked over our chair's shoulder at the information that Aurora sent, and that's just fine.
That's just fine?
Yeah,
Okay.
thank you.
We were going to display it on the screen, but we will enter that into the record. There's no supplement needed per Director Vasquez. So thank you very much. Does-
I have a question on process.
Sure.
Do you think we should plan on 3 days in these chairs in November?
Not here.
It's on here.
No.
With different chairs.
No, different chairs, yeah, but chairs like this, yeah.
We will, that will be a discussion truly with Viola and how they schedule the board meeting, because I know other matters still need to be scheduled for the
Mhm.
board meeting. So I don't know if I can speak to that at this time.
It was more kind of being humorous, but
Right.
yeah.
Fine.
So, I mean, if we have, if, as you described, if we open the record again, we have new information, all the parties can comment and educate us on their opinion about the new documents.
Yes.
It could easily be a 2-day session again.
I will endeavor for that not to be 2 days.
Thank you.
And I will just highlight that we will also have other business to discuss as part of our regular board meeting. So it will not just be limited to this.
And at that point, I may be joining you all virtually because no one needs me here at 8.5 months pregnant in one of these chairs.
Okay, sorry.
Can I make a motion to pause?
Thank you. Motion made by Director Camlin to pause the deliberations, a second by Director Vasquez. Is there any discussion?
No, just a reminder to the board. Do not discuss this with the parties. Do not discuss this with each other. Further discussion on this matter will be done in an open meeting that is noticed appropriately under the Administrative Procedures Act of the state of Colorado.
Thank you. All those in favor say aye.
Aye.
Those opposed, motion passes.
Adjourning the meeting, I believe.
Thank
is
you.
next.
Yes, I will also entertain a motion to adjourn our CWCB meeting. Thank you, Director Gibbs. Director Director Haas, thank you for the second. Is there any discussion about adjourning?
I'm standing up.
All those in favor say aye.